कल adjourn क्या adjourn motion में affidavits not completed.
Complete, my lord. My lord was led by Mr. Thakur.
New motion by mistake, Lord. So anyways, that is not beside the point.
ठीक है adjourn motion में लिख क्या इसको. Bring on adjourn motion. Yes.
My lord, may be permitted to, my lord, mention a matter, my lord, where I am humbly seeking a liberty to, my lord, to file a company application arising out of company petition of 1998. My lord, the department is
Come
not.
at 2 p.m. Come at 2 p.m. Company matter will be taken at 2.
My
Come
lord,
at 2. My officers will be there. I will see.
My
what
lord,
is the
grateful. Now, my lord, may I be permitted to mention a matter, my lord? My lord, there was a previously direction, my lord, to comply with the order where, my lord, certain, my lord, technicalities were pointed out, my lord, those were taken care of, your lordship. If my lord kindly includes in the list, your lordship.
What? Already extended. The rectification is done.
My lord, everything is completed.
So file list. Then you have to use a writ of summons. Have you submitted the writ of summons?
My lord, I believe, my lord, writ of summons have been lodged, my lord.
Lodge. Why it is to be presented here without the writ of summons, without lodging the writ of summons?
My lord,
Lodge the writ
I'll
of summons.
come back. Grateful.
May it please your lordship.
Hmm.
My lord, this is that election petition matter. My lord had expunged the names of the Chief Electoral Commission, Chief
Yes.
and the ECI.
Hmm.
Lordship, there was a direction upon us to make paper publication, the Gazette publication. Lordship, we have taken steps. The difficulty that we are facing is the department has told that there is a direction that we are to take steps to make the publication. Now we have given the draft publication. The department says until because as per 116 of the RP Act, the High Court has to make that publication. So if my lord grants 1 week's time to the department can make that. There is a report also, I believe, my lord, which the department has forwarded to lordship. We will give the requisites, the cost which is to be borne for the publication, but the
matter is listed as to be mentioned on receipt of the report submitted by the registrar original site dated 28th of August 2025. 28 August 2025. It is found from the report that as per the order passed by this court dated
it is dated 13th of August.
13th August 2025, the petitioner has submitted the draft publication which is to be approved by the registrar and the same is to publish in the Calcutta Gazette. In view of the above, the registrar original site is directed that if the draft notice published and submitted by the petitioner is in accordance with law, the same may be approved and published in the Gazette within a period of 1 week from date.
My lord, may it be returned with the permission of Mr.
Yes.
If it may be made returnable on 25th, because 1 week takes us to 10th of September. 2 weeks is the notice period, 14-day period, which takes us to 24th of September. If it could be listed on 25th, then we can submit our written notes and then
my lord, 1 week
after
let
that.
the written let the matter appear before this court on 25th of September.
Extremely grateful. Actually, a very rare phenomenon. So the department was also a little bit confused.
No, I also find in the department so many requisites because original side rules not permit how it is to be done. Because civil rules and order is not here.
Yes.
Only the original side, and that has not been there. Let us see.
Good.
I beg to appear on behalf of the plaintiff, my lord.
I to be mentioned.
My lord, the learned commissioner is to file his report.
Liberty to file affidavit and
Appointed as a commissioner, my lords, in terms of your lordship's order dated 16 July 25, the report is ready and the examination of the plaintiff witness one stands concluded.
Completed.
Yes.
No defendant.
My lord, defendant is there. My lord, I have another witness, expert witness, evidence, my lord. My lord, kindly grant me liberty to file my affidavit in chief and the valuation report on the returnable debt.
What?
My lord, I have another witness, PW2. My lord, he will be an expert witness. My lord, I need to file my affidavit in chief of
Expert evidence. How you can file the affidavit in chief? Expert has to come in the court and he has
he
to
will come.
post
He will come.
in terms of the report only. So how the examination in chief
He
will
will,
be
my
filed
lord.
by you? So you issue the subpoena and or you will bring the.
I'll bring there.
You will bring. There's no need of the subpoena.
But my scope was limited to the plaintiff witness number one.
So this one.
Yeah,
No,
the
you
one
want
that concluded
another
has
witness.
That's concluded.
So you receive the remuneration.
Yes, my lord.
So you will examine the expert before the commissioner.
In court.
Why? Examine before the commissioner.
he will be available in court. My lord,
It is going before the commissioner. Let the commissioner. The commissioner has filed the report after serving the copy to the London advocate appearing for the parties. Let the same be cut with the record. It is submitted that plaintiff's witness number one examined and cross-examined. Counsel for the plaintiff submitted. He will adduce further evidence that is the expert. The plaintiff submitted. The plaintiff intends to examine the expert witness to prove the report, and he will take appropriate step for examining the expert witness on the next date fix. When you are witness, then he will.
my lord, after vacation.
The commissioner is directed to continue the commission for examination of the plaintiff witness and cross-examination, and to file the report by 12th of December 2025.
I'm grateful.
Kindly grant me liberty to file the report of the expert before the learned commissioner.
Naturally.
My lord,
Where is your report? You're
But
not disclosing the plaint.
no, I have not disclosed.
Then
I'll
how you can bring the report on record?
That is why, my lord, I am seeking my lord's liberty.
No, if the expert report you are not disclosed with the plaint.
My lord, what happened? I tell your lordship. There was a report earlier when the plaint was filed. It is there in the judge's brief. Now, in the meantime, that expert has passed away. I had to appoint another expert, and he has to file his report. That is the difficulty.
Another expert file report. Another report.
Yes, a fresh report will come because the earlier expert has passed away.
Okay, the report. Where is the earlier report?
That is there in the judge's brief.
So how the second report has come?
My lord, he has prepared, but without my lord's liberty, I cannot file it.
The first report, which is on record.
Yes.
So how the second expert has further submitted the report?
We have appointed, my lord. We have appointed, and he will depose before you.
After the death.
After the death.
And after the first report is submitted.
After the first report is submitted, it is only the copy was there, but I could not prove it because PW1 was deposing, but much earlier before PW1 was examined, my lord, that expert had passed away.
Sir, previous expert has submitted the report or not?
My lord, only copy was there before your lordship.
What copy?
That valuation report.
Original report is not there.
No, original report is not there.
So then how the second expert has come in picture?
My lord, he will come after taking.
How the second report will come?
Because how the second person comes
Correct.
in, that is what I am not understanding.
How the second? Because the first expert was appointed. He has submitted the report. The copy of the report is on
That
record.
is not a form of a report. It's just a valuation.
Valuation.
Valuation report.
Yes.
Okay, valuation.
It's a valuation report.
That is on record.
Yes.
Now he passed away.
Yes.
So you want another expert is to be examined,
Yes.
and another expert is to bring a fresh report.
Yes.
How?
A fresh report.
How?
My lord, he has prepared because he
Who has prepared?
that newly appointed expert. He has.
Who has
prepared.
appointed the newly
My
appointed?
lord, I have appointed. It is not an appointment by the honorable court. It is expert means it is my witness. I have. It is not. It is not an appointment, but even the earlier appointment also. My lord,
Okay, whatever if that report is not there, how you bring the document on record without the leave of the court?
my lord, that is why, my lord, I am seeking. Very well, my lord, I come with a.
Grateful, my lord.
Item number 2, my lord, I appear for the decree holder, my lord.
Hmm.
On 18th of August, there was a direction, my lord, for
For the judgment debtor, my lord.
there was a previous direction for filing of, my lord, affidavit of assets. They failed. On 18th of August, my lord, the matter came up, my lord. Lordship had, my lord, passed an order, my lord.
It's also warrant.
Yes, my lord, warrant against the judgment debtor. My lord, the only difficulty is judgment debtor is a company.
Hmm.
And so, my lord, in terms of Order 21, Rule 41, my lord, Order 21, Rule 40,
Hmm.
41, my lord, it has to be on the officer of a company.
Hmm.
That is one of the directors, my lord. That master data is also there on record. And even today, my lord, if he files today, my lord, I'll not stand in the way.
Lordship, my affidavit of assets is otherwise ready. It is to be affirmed today. If your Lordship keeps it tomorrow, I'll be in a position to file it subject to what falls from your Lordship.
Not today.
Very well.
Grateful, Lordship.
Next.
And for the plaintiff, publish some office report has come, Lord Amana.
Hmm. Yes. So you are not having Vakalatnama. Who has applied for certified copy?
Oh, no, my lord.
Certified copy. Who has applied for certified copy?
Must be the defendant because, my lord, I filed the suit, so it has to be with the Vakalatnama.
The certificate.
No, this report has come. Who has filed?
We have filed for sir.
You have not filed the Vakalatnama.
We have not filed the
Then how you can
Vakalatnama in
get the certified copy pending case? You not file the Vakalatnama.
How did they appear, my lord? They also have
That's why
question mark.
you have not appeared in the suit either in the application.
No, your lordship, suit we have not filed the Vakalatnama because we have
In the
not received the
application
writ of
also you have not
summons.
filed. In the application also you have not filed.
Surprising, my lord, how they've argued for the contested matter.
We'll file the Vakalatnama, your lordship.
The matter is listed as to be mentioned on receipt of the report of the register original side dated 30th August 2025. It is found from the report that Argus Partners, ARGUS Partners, solicitors and advocates for the defendants have requested for supply of certified copy of the order dated 19th August 2025. But on scrutiny of that record, it was found that the said solicitors and advocates have neither filed Vakalatnama in the suit or in the interlocutory application. Thus,
Your lordship,
the report before this court.
if you're recording a lordship, the suit we have not received the writ of summons. That's why we have not entered a bid.
No, I am not telling you filed in the application. You applied for the GA order.
Yes, your lordship, but you're recording. That's why I said we have not received the writ of summons. If you can,
What is your good name?
Aarti Bhattacharya, your lordship.
Miss Aarti Bhattacharya, an advocate appearing for the defendant, submit that as the writ of summons could not be served, as such the defendant could not file the Vakalatnama.
1 and 2.
Could not file with police. This order was passed in the GA or
GA1. Your lordship, I'm from defendant number 1 and 2. Your
counsel for the plaintiff submit that the order dated 19th August 2025 was passed by this court in an interlocutory application being GA1 of 2025. GA1, 2025. Learned counsel for the defendant press for leave to file Vakalatnama in GA1 of 2025 by within a week.
Your lordship, 2 weeks, your lordship, because
within 2 weeks. It is made clear that After filing of the Vakalatnama by the defendant number 1 and 2, the certified copy can be granted. Certified copy of the order can be granted to the party, to the defendant as applied for. Yes.
May please, Your Lordship. That I appear for the plaintiffs in this matter.
My lord, I appear for the respondent number 6, my lord.
That one small correction is perhaps required in the order passed by Your Lordship on the last occasion.
Yes, what correction is?
That I think the CS number has come.
It is only number.
Yes, I think it should be 177 instead of 117. So that is one, my lord. And my other submission is, my lord, I have filed an application under Order 13A, which is, my lord, GA com number 12. My lord, perhaps my learned friend appearing for the defendant would like to file an opposition to it.
I only, yes, of course, I will want to file one, but I'm only representing the respondent number 6, my lord. There are other respondents also, my lord, can grant leave.
I am the advocate on record for the defendant numbers 1, 2, 4, 5, 6, 7, 8, 9. So, my lord, I can take, I can.
My lord, can direct the affidavits to be exchanged, my lord, in the meantime, except the respondent number 3 is not there today, my lord.
Directions may be given upon the respondent number 3 also, since they're not represented today.
That is not, my lord, in the last order. Your lordship will see in the 4th line of the first paragraph, my lord, the defendant number 9 is also mentioned. The 9 will not be there. It's defendant number 1, 2, 4, 5, 6,
During
7.
the scrutiny of the written statement on the defendant number 1, 2, 4, 5, 6, 7, 8, and 9. There is no signature.
It is not existing.
Maybe.
No, but you're representing them.
The matter is research has to be mentioned for correction in the order dated 20th August 2025. It is submitted that in the cost title of the order dated 20th of August 2025, the old suit number is recorded as CS 117 of 2019 instead of CS 177 of 2019. Thus, in the order dated 20th August 2025, in the cost title, the old suit number shall be read as CS number 177 of 2019 instead of CS 117 of 2019. Full stop. Counsel for the plaintiff submit that the plaintiff has also filed an application under order 37.
13A, my lord.
13A. Under order 13 capital A of the Code of Civil Procedure. Procedure being GA com 12 of 2025. So counsel for the defendants. You are appearing for 3.
I appear for 3, my lord.
And you are
I'm sorry, 6, my lord.
and you are
3
appearing
is not
for
appearing.
I am the advocate on record for all the defendants apart from defendant number 3.
counsel for then that's why and counsel for the defendants press for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks.
It's
3
within
weeks.
2 weeks, 1 week after the vacation, my lord. Because, my lord,
1 week after vacation. Reply, if any, there to be filed within a week thereafter.
2 weeks, my lord.
2 weeks thereafter. 2 weeks thereafter. Let's the matter.
3 nahi hai na? Bol.
Lord, I am not appearing for the defendant number 3, my lord. If that will be.
No, my lord, I am for 6, my lord.
Defendants except defendant.
The plaintiff or the parties can intimate the third respondent, my lord, that
Let the matter appear on
Just intimate the order now.
1 week, 2 week on 26th of 26th. 27th of November 2025.
Grateful,
Hey.
my lord.
Yes.
Item number 5, I am for the plaintiff. Office report has come, Your Lordship.
No written agreement has been filed with the plaintiff to substantiate the claim of the plaintiff. There is a breach of contract. It does not mention the government plaintiff as to whether the defendant is a registered service provider.
Actually, the plaintiff was presented at that point of time. It was indicated by the learned master that agreement, Your Lordship, has not been given. So that's why it will not come under commercial disputes. Paragraph 4 and 5 I have pleaded, Your Lordship. There is no written agreement, but agreement, Your Lordship, has been pleaded, and agreement for services, Your Lordship, will come under commercial disputes. Para 4, Your Lordship, kindly sees.
Negotiations.
And para 5, Your Lordship, I have said, Your Lordship, the assurances agreed and accepted the proposal.
Yes.
Para 4 and 5 is covered, Your Lordship.
No, where is the agreement? That's why the
She's under the impression that there has to be a written agreement.
is a commercial suit.
It's a commercial suit because Your Lordship is coming under that provision. If I don't invoke Your Lordship, again the other side will come and take these particular points.
How it is a commercial?
Lordship, it's agreement for sale of goods or provision for services. It's coming under 18 of the commercial disputes.
Agreement for sale of goods.
Sale of goods or provision of services. And basically, Your Lordship, I paid the money, Your Lordship, for purchase of land. I think, Your Lordship, paragraph 2, 3, and 4, it's clear. Two is clearly mentioned, Your Lordship, the defendant is interiorly engaged in the business of provided services as a land purchase facilitate for commission. Paragraph 2, Your Lordship, the last 3 lines.
The matter is listed before and listed as to be mentioned on the report.
Your Lordship, I take kind leave, Your Lordship. Okay.
Listed as to be mentioned on receipt by the report of the land master dated 29th August 2025. It appears from the report that the master is of the view that no written agreement has been filed with the plaintiff to substantiate the claim of the plaintiff that there is a breach of contract. It is also mentioned in the report that in the averment of the plaintiff as to whether dependent is a registered service provider or not. Or not is not mentioned. Thus, the master is of the view it is not clear whether the instant suit is a commercial suit or not. When the matter is called, learned counsel for the plaintiff has drawn the attention of this court to the paragraph paragraph 2 to 5 of the plaint and submit that it was a negotiation as per the negotiation between the parties. The proposals were made, which is reflected in paragraph 4. Consider the submission made by the counsel for the plaintiff, peruse the plaint. This court find that the plaintiff has made out a case with regard to the commercial transaction in the aforesaid paragraphs. Thus, the plaintiff that the record is sent to the London master for passing appropriate order. Yes.
Lordship, I'm from the plaintiff, Your Lordship.
Yes.
Your Lordship, we request time of say about a week because during the course of inquiry, we have come to realize that the defendant's registered office address has changed. And apart from that, there are also certain clerical error, as your lordships pointed out on the last date of hearing with regard to Order 2, Rule 2. Apologies, your lordship, it's been inserted as a clerical error. So we'll make the amendments, your lordship, along with the cost title change. And because the plaintiff does not reside in Kolkata, your lordship, so we're seeking 1 week's time.
As per the prayer made by the counsel for the plaintiff, the case is adjourned for a week. Let the matter appear on 16 September.
Obliged, your lordship.
Next. Yes.
Today it is, I hope the
Yes.
But your lordship has seen the plaint yesterday. I need not trouble your lordship with that. Suit for eviction, my lord, expiry by efflux of time. My lord, kindly permits me to place. What is it? Judgment which I wanted to start with is not there. Everything else is there. Kindly, would your lordship permits me to hand up my iPad, my lord, if your lordship does not. My lord, kindly pardons me. My lord. This is a judgment which I was placing, I had indicated yesterday. But if there is another suit between the same parties, that means they have evinced their intention of not, my lord, mutually settling the disputes. So, my lord, this cannot be a ground for, my lord, 12A. So, my lord, the leave was granted under 12A. If your lordship kindly sees this very short judgment.
But now the laws change.
No.
Now the laws change with regard to the 12A, sir.
My lord, I shall show all the judgments. I'm carrying everything. But my lord, none of the judgments, perhaps, my lord, subject to correction by my learned senior friend, would contemplate a situation like this, where there is already a suit which is filed, and thereafter, my lord, the other party has wanted to file a suit, and so this is. But I shall deal with that. Now, my lord, in my humble submission, if your lordship sees the language of 12A, if your lordship kindly sees the language of 12, your lordship has seen it umpteen number of times, but just for my satisfaction on this point, it does not anywhere mention that one has to prove it by to the hilt. Two relevant words I shall place. A suit which does not contemplate an urgent interim relief. First is contemplation. Second is shall not be instituted until the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by the rules. So, my lord, what happens is, my lord, I need to satisfy your lordship that I fear that the entire period which might be spent for mediation would be prejudicial to my interest. So, I want an urgent interim relief for protection of that. My lord, in order to prove that, my lord, I have pleaded that I fear that they are, I have reasons to believe that they are in the process of inducting third parties, creating a third party right, despite the agreement having expired by efflux of time. Now, to that aspect, kindly permits me to place one judgment of a division bench of this honorable court. In my lord Srishti. But kindly see Srishti infrastructure.
You have given the 2 copy. Hey, वापस करो.
But kindly see Srishti infrastructure.
Yes.
Now, your lordship would kindly have a look at paragraph 31.
Yes.
At the bottom of the page, say the plaintiff discloses a simple money suit, but it is likely that on notice of it, the defendant might start disposing of some of his assets to defeat the decree that might be passed against him. So the plaintiff may contemplate the urgent relief of an attachment before judgment, but need not plead it in the plaint as the cause of action has not arisen at the time of institution of the suit. Please note the wording of 12A1. The legislature does not mention plaint. It uses the word suit. It employs the word contemplation.
Hence, it avoids such words as averments or statements in the plaint. In other words, the legislature does not say that from the statements or averments in the plaint, urgent reliefs obtainable by the plaintiff should be apparent. I would interpret the section as suggesting that if at the time of presentation of the plaint before the judge from the averment in the plaint and an affidavit to be filed by the plaintiff, it would appear that in the contemplation of the plaintiff, a situation for urgent relief might arise in the period when the mediation has to be undergone. The court may allow the plaintiff to institute the suit without mediation. On the basis of the declaration that urgent relief is contemplated, the plaintiff should be allowed to present the plaint. The court should not ordinarily interfere with such an assertion unless it is shown to be palpably erroneous or malafide. But I pause here for a moment. But from the plaint or my application, is it apparent that it is palpably erroneous or malafide? But they are proceeding this to contend that this property they can enjoy free of cost. 11 months lease, paid anything, they will pay.
They have filed the suit for permanent injunction on the allegation that you have not provided the water and electric connection, whatever it may be. Correct?
So today, all I want is they should not create third party. I am not affecting their right.
They have filed and you are appearing in the matter. Once they are telling they are the tenant and they are in occupation, they are in from where is the intention? Where is the document or where is some intention that they are going to
if unless some document is executed and I get that document, I will never be able to prove that. So, Manoj, at this stage,
and if this so because 12A you want and there is already a suit, you are apprehending. You can also file an application where there yes that this or my or there may be restraint from alienating the property. Why you are not going to that court and praying for injunction over there?
For eviction in a commercial suit, I can come before your lordship.
No, you can
the
come. I am
of
not telling the suit is not maintainable. Now the point with regard to 12A. 12A, now the court has found one suit is there. The plaintiff is praying for the defendant who is defendant, he is praying for injunction before the one of the court. And you are telling that the same plaintiff is going to alienate the property to the third party. You are not invoke the provisions of 12A, you want the dispensation of the 12A. Instead of dispensation, you go to the same court and pray for the injunction over there. Why the 12A is required before this?
That suit is non-est. Because 12A is not there, Dhanbad.
Where is the application of 711?
No, we shall file.
You file it.
We shall file 711. But that will not preclude me from filing.
Sorry, one paragraph. This court is not satisfied.
Your lordship will also see my injunction application. Also.
Cannot.
But this is
cannot,
what I'm
sorry.
But this is the
what,
judgment.
Mr. Gupta,
that is why I'm showing
for
the
12A, the court cannot go into the
that is why I'm
even
showing
your
the
injunction application is not required for 12A. 12A has to be ascertained from the pleadings of the plaint only. And one paragraph only you have stated that you are apprehending defendant is going to alienate the property.
Yes.
For that, this court is not finding any urgency on that.
But in my humble understanding of all the judgments, and I shall show the
yes,
Supreme
I
Court.
know. I refer several times this.
Yes, and I'm carrying your lordship's judgment also.
Yes.
My lord, that the plaintiff's contemplation is what is required in my lord a 12A situation. So, my lord, if I apprehend,
this court didn't want for multiplication of the proceedings, sir. This court didn't want once the court has come to know that one suit is pending, and you have an option on that suit. Why this court will grant a leave to you?
My lord, that's
why the multiplicity of the proceeding?
Because that
then tomorrow they will come with the section 10. Then you will go for order 11. That's why the proceeding is going and going. There is no end of the proceedings.
My lord, that
the court has to be cautioned on that.
Yes, my lord.
That's why the Dhanbad fuel has stated.
Yes, I'm carrying that. I shall be placing that also. But my only contention before your lordship is that I have annexed that plaint. So it's not that I wanted to suppress.
No, I am not on suppression.
Yes, I am. Your lordship is on multiplication of proceedings.
Multiplication.
If there is already a prior suit.
Prior suit, and you have an option over there. There is no need of 12A in here.
My lord, in that suit, that was filed when the contract was subsisting. Their claim in the suit is only do not take steps to evict me without due process of law. So, my lord, this is the process of law which I am, my lord, filing. I have the right by filing a suit to evict him.
Correct. You have a right.
So
I am not telling. I am not telling you are not right. But you go by the procedure. Why you want the dispensation? You go for the proceeding. Go for the mediation. If they are not coming, come here. The court will say yes. You are not coming for the mediation. You are not coming. Then the court naturally will hear you.
But will kindly give me a moment. Kindly.
Naturally, the court will hear you.
My lord, the difficulty is, my lord, if I file an injunction application in that court, I would be accepting the jurisdiction of that court because we are in the process of filing an order 7 relief. I don't know whether it will file today, tomorrow, whenever, because they have not gone, they have not prayed for 12 relief. So that suit is non-est. So I cannot go to that court to file an injunction because that suit is non-est as per, my lord, both Yamini Manohar as well as Patil Automation. Beyond the cutoff date, they cannot file a commercial suit without a 12-way leave. They had never even sought for that. So I will be subjecting.
Where is your averment in the plaint?
No,
Where is
there is no averment.
Then
there is no averment in the plaint.
Then
but I would be subjecting to the jurisdiction of a
that's
suit
why
which is
if
non-est.
you have enclosed that petition.
Yes.
That the suit. You have not stated that you cannot go into that suit. You cannot ask for the because
But plaint has not been served on us. What has been served is the injunction application. I have annexed the injunction.
So the orders are here. Everything has been served.
No,
There
plaint
will
not
be
served.
time for dismissal.
But what is only been served is the injunction application which I have annexed.
Whatever it may
That
be.
kindly takes the entire order sheet.
Even injunction
I was waiting
application
for-
is a replica
Then-
of the plaint, Mr. Gupta.
This is the entire order sheet. 6
My lord,
February
then
suit
my
filed.
lord,
in
I would
February.
be submitting to the jurisdiction for getting an interim relief. So my
So that's why you're not pleaded that. You could have been pleaded that could have been court consider yes. That is the urgency. You cannot go before that court, and you then
Could I-
might be an urgency.
could
but
I
that
could I
is-
take back because that lacks jurisdiction. That lacks jurisdiction.
might be.
That is a non-est
LLO?
suit. May I take back the plaint and include this and come back?
I am not advising anything.
This cannot be done.
May I take back the suit?
Right
Well, he
now,
does not have a
my
right of
submission-
audience.
I have,
But he does not have a right of audience as of
Yes,
now.
I am not hearing. I am hearing you. If you want, I will allow you to withdraw the suit. Take back and withdraw the suit. There is nothing, no problem.
But could I withdraw with liberty to file a fresh? But because that pleading.
Then again, there will be multiplicity.
But your lordship would kindly visualize one situation. Your lordship knows of these judgments that even if there is a 711 application, if I take out a order 6 rule 17 for amendment, your lordship's always considered the amendment first. So in that regard, my lord, may I then amend and bring that?
That's why I don't know
Because-
whether the court can what's right or not. That's why I'm before the presentation.
I understand, but my predicament is that I would be submitting to a court in a suit which is ex facie bad in.
I appreciate.
That is my difficulty.
But you not taken all
But
these things.
That did not strike
The
me.
court
That
cannot.
did not strike me. To be very honest, that did not strike me. I understand that did not strike me. I am before your lordship, my lord. Your lordship would kindly. That did not strike me. That way it can also be looked at. It's a. I bow down.
So what can be done?
But kindly permits me to withdraw with liberty to file a fresh, my lord. If I can satisfy, then
Liberty, then I have to record that you have to go for the pre-institution mediation.
no, my lord. I can.
Or simply if you want to withdraw the suit, then you can.
But withdraw with liberty to file a fresh, then your lordship would consider, my lord, when I get that pleadings done, my lord.
The only thing is because of Dhanbad's fuels, my lord. The only option is, my lord, the suit has to be dismissed.
Yeah, Yamini,
That is not
Yamini
the
Manu-
case. No.
If I don't pray for that,
That's why see
if I
initially
pray for that,
before even after the
But this
Yamini
has-
Manohar, the court was some
Yes. Now
extent.
Dhanbad has
Now
made it very
Dhanbad
clear.
has made it.
carrying Dhanbad also, I should show that
Made that.
Dhanbad also says this plaintiff's contemplation A
No,
and
No,
B.
contemplation. That is that's why the contemplation the court has to
There are
see.
three
What
real-
three things is to be see: cause of action, the pleadings, and the prayer. Then only the court
I
can.
appreciate. I
cons-
completely.
My lord, we have a practice direction, commercial court's
Yes,
practice
yes.
direction. Rule 6 kindly takes into consideration. He has not complied with that also.
Uh,
This has been framed in pursuant to, my lord, the commercial court.
the matter is listed as under the heading presentation of plaint, but mm, af- after hearing some time, the learned counsel for the plaintiff prays for withdrawal of the suit with the liberty to file fresh in view of the submission made by the counsel for the plaintiff. This Plaintiff is given liberty to withdraw the suit, liberty to file afresh when the occasion arises.
Your Lordship has given them liberty to file.
When the occasion arises.
When the occasion arises. Very well. Grateful to you.
With regard to the court fees, my lord, could I?
Perhaps.
Though it has been withdrawn at the stage of presentation of the plaint, the plaintiff, the department is directed to refund the court fee to that plaintiff. ठीक है? Yes.
May I please? Proof को
Oh, well, I had indicated on the last occasion that I'll file two supplementary affidavits
Yes.
to not record those subsequent facts. I've served them a copy in advance.
Have you received, Mr.
Yes, yes. My lord, may I?
Yes. You are appearing for?
My lord, I appear, my lord, for the defendant number 2. My lord, Hatishala Developers Private Limited.
Yes.
না না আমি আগে যেটা আগেরটা মানে যেটা আগে
Yes.
Yes, my lord. My lord, I appear, my lord, for Hatishala, my lord, who is, my lord, the purchaser.
Purchaser.
Now, my lord, there are, my lord, 3 areas, my lord, where, my lord, I wish to address your lordship. My lord, apropos, my lord, the prayer for, my lord, interim relief. My lord, first is, my lord, that owing to the conduct, my lord, of the plaintiff, my lord, there should not be, my lord, there can be no exercise of discretion, my lord, in favor of the plaintiff. That's, my lord, the incident of, my lord, the mentioning, my lord, on, my lord, on the last occasion when the matter had been taken up. Now, my lord, second, my lord, is that, my lord, there is really no case, my lord, made out against, my lord, the defendant number 2, my lord, in the plaint or the petition. And, my lord, third, my lord, is, my lord, the defendant number 2, my lord, is, my lord, a bona fide purchaser for value. And, my lord, therefore, my lord, there can be no interim order, my lord, against, my lord, the defendant number 2. Now, my
Yes.
lord, I'll come straight away, my lord, to, my lord, the case of, my lord, conduct. My lord, kindly take. I don't know if your lordship, my lord, has the plaint before your lordship.
Plaint देना. Plaint. हाँ? इसमें लगाया है. Have you enclosed the plaint, Mr.
I think plaint would be separate. I don't think it's there.
Not in.
Not annex the plaint.
Not annex.
Separate.
Copy, do you have a copy of the plaint? No, let me. Don't hand up things. When did they serve you this? This was after detailed the policy. Yes. Will it kindly, yes. Kindly, Millard, what is this? Property. Millard, kindly come to Millard, paragraph 3 of the plaint.
Yes.
This is the case. The plaintiff is the owner of the Statesman House building, hereinafter referred to as the said property, which is constructed over an area of 4 bighas, 6 katas, 15 shotok and 7 square feet, as more fully and particularly described in schedule written herein. Owing to its importance and heritage, so and so a copy of deed of conveyance is annexed here too and marked blank. Then Millard, kindly have a look at the schedule, Millard, which is Millard at right at Millard straight after the prayers at page 28. Millard.
Yes.
All that piece of land measuring about 4 bighas, 6 katas, 15 shotok, 7 so and so at premises number so and so within aforesaid jurisdiction. So this is Millard, the schedule. Now, Millard, I'm not going into the question whether on the date of institution of the suit they were owners or not. But Millard, this is the statement that they've made. So, Millard, my first submission is one would understand from the plaint that this is the scheduled property, Millard, which is Millard referred to. Now, Millard, kindly come, Millard, to Millard, your lordship's order, Millard, which was passed, Millard, on mentioning that day. You gave me the order sheet, I don't want. I want just this order. Order touch it. This is my lord, 25th August 2025. No luggage, na supplementary. Just give me this. My lord, we believe it's an annexure, my lord, to the supplementary affidavit also. My lord, page, I'm grateful to my lord.
Order dated?
Yes, my lord.
Yes.
This is the supplementary affidavit. No, it's not there. Is it there?
Yes, page 12.
Page 12, my lord.
Supplementary affidavit, my lord, which I filed today, my lord, affirmed by Shumon Bhattacharjee on 26th August 2025. I believe, my lord, my learned friend is referring to the order at page 12 of that.
Ah.
That's what it mentioned? That is 5th of August.
That's 5th.
Oh, I'm sorry. Oh, I'm sorry, Millard. I'm sorry.
No.
Millard, the day it was affirmed, Millard, that order was not available on uploaded.
My lord, kindly, my lord, take.
I'm sorry.
25th August. My lord, 25th August. Now, my lord, kindly have a look. My lord, this is the order which your lordship has passed. My lord, first problem I have with this order is, my lord, by my lord, automation, my lord, my appearance has been recorded. I wasn't even, my lord, in court that day. So, my lord, nor was my lord, Mr. Chadha. My lord, the first three names weren't even before your lordship, my lord, as far as defend number 2 is concerned. So, my lord, kindly have that corrected, my lord. Otherwise, my lord.
You're not, but somebody.
Yes. My learned junior was there, my lord.
Okay.
Now, my lord, kindly come to para 2, my lord.
Yes.
At the time of rising of the court, learned counsel appearing for the plaintiff, upon notice to the other side, has mentioned the matter
and has handed over an email dated 25th August 2025, received at 2:45 p.m. along with photographs, and submits that learned counsel for the plaintiff has received an information and an email from plaintiff stating that the defendants stroke Merlin people have entered into the premises of the plaintiff and started disturbing the peaceful possession of the plaintiff over the suit premises. Kindly mark this, my lord.
Yes.
This is the statement made to your lordship that, my lord, defendant stroke Merlin people have entered into the premises of the plaintiff and started disturbing the peaceful possession of the plaintiff over the suit premises. That's, my lord, entirety. Learned counsel for defendant number 1 submits that he has taken instruction and submits that no person from Merlin has entered into the premises of the plaintiff or disturbed the possession of the plaintiff. So, my lord, this was the submission of 1, and my lord, 2 was, my lord, suit premises, peaceful possession. So, my lord, the submission proceeds on the basis that the plaintiff is in peaceful possession of, my lord, the property, my lord, which is shown in the schedule.
Correct.
Though the plaintiff has filed the suit along with an application for an ad interim injunction, but the defendants had filed caveat, and accordingly the ad interim injunction is taken up for hearing on day-to-day basis. But due to paucity of time, the hearing of the ad interim injunction could not be completed. The matter was fixed on 22nd August at the top for hearing of the interim injunction application, but on the said date, the matter could not be taken up for hearing due to the bar resolution. The matter is fixed today, but the matter could not be taken up for hearing. Though the ad interim injunction is to be taken up as ex parte basis, but in the present case there was a caveat, and accordingly notices were issued to the defendants, and defendants are contesting the prayer for ad interim order. It is the knowledge of the defendants that the court is in season for hearing of the ad interim order of injunction. But it is unfortunate that the defendants are allegedly disturbing the possession of the plaintiff over the premises in question. Or did I pause here? So it's entire suit premises. Then, my lord, in view of the above, this court finds that till the ad interim application is not being heard by this court, the parties should be directed to maintain status quo with regard to the nature, character, possession of the property. My lord, I take it it's the entire, my lord, property. So, my lord, the first point which I wish to make before your lordship is, your lordship, my lord, has, my lord, been, my lord, requested to pass an order, which your lordship has, on the basis that they are in possession of the entirety of the suit premises. Now, my lord, please. Now, my lord, kindly take, my lord, a compilation, my lord, which I have prepared, my lord, for your lordship, and my lord, these are primarily documents, my lord, which are already annexures here to show, my lord, that even as on the date of institution of the suit, copy.
Yes.
Copy the other side. Okay, please.
We have already been served them by email.
Oh, you've already been served by email.
We've already served by email.
I'm sorry, it's been served. My lord, this is, my lord, I want to show, my lord, that, my lord, even as on the date of institution of the suit,
yes,
my lord, the plaintiff was not in possession of, my lord, the entirety, my lord, of, my lord, the premises.
Yes.
Now, my lord, first document your lordship kindly has a look at, my lord, is, and my lord, the notice. My lord, this has been annexed to the supplementary affidavit. Please sit down. My lord, this has been annexed to the supplementary affidavit. And, my lord, your lordship kindly has a look here. 25th August, my lord, at 16:01, right at the top. Dear sir, madam, this is to inform you that the above mentioned matter shall be mentioned on 25th August 2025, that is today, before the Honorable Justice, at this time of rising of the Honorable Court, or any time whenever the Honorable Court permits, you are requested to kindly attend. My lord, the only point I wish to make is, purpose of mentioning, my lord, has not been, my lord, indicated. Earlier, the matter had been mentioned when your lordship had fixed the date at 3 p.m.
Yes.
On the 3rd. We had mentioned earlier. Now, my lord, kindly have a look, my lord, my lord,
Yes.
the development agreement. My lord, which is, my lord, if your lordship looks at the index, my lord, in the petition, it is at pages 45 to 133.
Yes.
And my lord, I'm only drawing your lordship's attention to clause 7, my lord, at page 32 of the compilation, my lord.
Yes.
My lord, kindly come to, my lord, page 32. It should be page 75 of the petition. Shumon petition, petition. I'm indicating the petition pages to my learned. Now, my lord, kindly have a look at clause 7. Authority to enter. Simultaneously with the execution of this agreement, the owner shall hand over. Kindly know that statesman. Khas, peaceful and vacant possession of the said premises, including the building, save and except what? The area occupied by HDFC Bank Limited and owner's office to the developer for execution and implementation of the project. The possession granted by the owner to the developer shall not be deemed to be a transfer under Income Tax Act or under Section 53A of the Transfer of Property Act 1880. Now, my lord, I pause here. The development agreement, my lord, which is executed on 26 March 2019, had this clause. Now, on 26 March, my lord.
So this is a development agreement.
Yes, to which, my lord, the owner and, my lord, Merlin, my lord, are parties.
Yes.
Now, kindly have a look at page 92. Pursuant to this, my lord, possession of the entirety of the suit premises has been handed over to Merlin, other than, my lord, the two.
Office and the HDFC.
Correct. Kindly have a look at page 92. My lord, my only, my lord, point which I'm trying to make is on the basis on which they came, my lord, was not there. Now, kindly have a look, my lord, at 26 March 2019.
Yes.
By an agreement of date,
yes,
we have appointed you as the developer to develop the subject property. In terms of the said agreement, we do hereby hand over to you the vacant and peaceful possession of the subject property, except the portions occupied by HDFC Bank Limited on the ground floor and our office on the certain portion of third floor for the purpose of development of the same. My lord, this is, my lord. So, my lord, the possession, my lord, is not with them from 26th March 2019.
Yes.
Now, my lord, kindly come to the memorandum of understanding, my lord, which is, my lord, referred to in the petition. If your lordship looks at the index, my lord, it's item 5.
Yes.
My lord, 220, my lord, is the page of the petition. And, my lord, page 120, my lord, is, my lord, the, my lord, portion, my lord, which is, my lord, the memorandum of understanding. Now, kindly see here, my lord, who all are parties. My lord, page 120
yes,
of the compilation. Here, my lord, statesman is a party. One, Shalini Gujral is a party. And, my lord, Merlin Projects is a party. Kindly see, my lord, the date, my lord, of this memorandum.
21st November.
21st November 2023.
Yes.
Now, my lord, kindly come to page 121. My lord, kindly take recital B. Subsequent to execution and registration of the said development agreement and grant of power of attorney by the owner in respect of its said property, the owner has also handed over possession of the said property to the developer herein for undertaking necessary steps for addition, alteration, renovation and conversion of the existing heritage building. The developer, in terms of the said development agreement and the power of attorney, have started undertaking said activities as per the plan sanctioned by Kolkata Municipal Corporation, VD building permit with so-and-so with further modification and has already completed substantial work in this regard. Then Millard, C, owner and developer by virtue of development agreement are entitled to receive so-and-so of net sales revenue generated from sale proceeds.
That are the conditions.
Yes. Now kindly see D, again Millard showing. By virtue of a supplementary agreement dated 6 July 2022, the owner and developer agreed that the division of constructed areas would not include, kindly note this, an area of 3,000 super built up square feet equivalent to 1,500 square feet built up area on the third floor of the building over which the owner will enjoy exclusive rights.
So they are on, yes.
So, Millard, it's only that, Millard, on the third floor.
1,500 square feet.
Correct. Now, Millard, kindly come to H, recital H. The owner and the developer have now jointly decided to sell their respective share in the said property as detailed above, along with proportionate share of land, parking spaces and common areas to the purchasers on the terms defined herein below. Kindly note this. Save and except an area of so-and-so on the third floor, which will be retained by the owner. Now kindly come to 123. My lord, clause 1A. My lord, sale is subject to the following. Developer will be responsible for completion of the building in all respects, which includes obtaining completion certificate of the said premises and handover of the said property to the purchaser and the owner's retained area of 3,000 so-and-so equivalent to so-and-so to the owner within 30th June, subject to timely receipt of information. So what is being kept out is what is in their possession. That's, my lord, 3,000, my lord, super built up area. Nothing else. Everything else, my lord, is in the possession, my lord, of the developer. Now, my lord, I'm sorry.
Yes, yes.
Now, my lord, on page 129 now. 27 June 2025.
Yes.
My lord, is the date of execution of the conveyance. And, my lord, the property, my lord, it all compilation.
Yes.
Like what we're hearing it from 129, my lord. 27 June, the date the conveyance is executed. My lord, the developer, my lord, is in possession in furtherance to the execution and registration of so-and-so in your favor, measuring so-and-so, so-and-so area on third floor, retained for so-and-so. We have this day given to you possession of the above property.
So Merlin has given to you.
To me, except, my lord, what is? So, my lord, all that I'm saying is, my lord, on that date, my lord, when they came and said their possession has been disturbed of the entire suit property, my lord, that was possibly, my lord, not, my lord, a correct submission.
Got your point.
My lord, the only, my lord, so, my lord, the order of injunction, my lord, on the face of it, my lord, could not have been, my lord, if this was their submission, if it was a correct submission, my lord, it was an incorrect submission, and therefore, my lord, the order of status quo with regard to the entire property on that basis, my lord, is, my lord, my grievance. My lord, I could have understood that said, third floor, what I've retained, here they are getting in. Now, I want to show something very interesting here. My lord, kindly take, my lord, the supplementary affidavit. Do you mind? Compilation, let's take that out. So it's here. This is mine. Just examine this. It must be somebody. Please. I don't mind instead of picking. Now, my lord, page 18.
25th August.
Yes, my lord. 25th August, page 18.
On the
This
page.
was, my lord, the email which had been shown to your lordships, my lord.
Yes.
I hope your lordships have the color, my lord. Does your lordship have it in color? Yes. Because we have not been favored with color. But doesn't matter, my lord. I have that earlier copy. Lord, affidavit didn't have it in color, but I had, my lord, what was handed up. Now, my lord, kindly, my lord, come to, my lord. My lord, this was after, my lord, the matter had been mentioned and the date fixed. Then, my lord, this is an email of 2:40 p.m. which they received. And, my lord, mentioning notice your lordship in the time is 4:01 without, my lord, object having been mentioned. Then, my lord, kindly, to, my lord, the advocates, I've just been informed by my office. So, my lord, this is from Ravindra Kumar, that about 10 people from Merlin came to the, kindly mark this. It's also showing, my lord, that it's third floor of Statesman House at about 2:10 and attempted to remove records and materials belonging to Statesman. So the only grievance, my lord, here is third floor, because they were not in possession of entire property. Please see first photograph bearing timestamp. Our senior staff present in the office advise them not to touch our property and ask them to contact either the chairman or managing director of a company, without whose permission no material belonging to Statesman could be tampered with. Backdrop shows our material, including old
Newspaper and
old newspaper archives. Now, my lord, then, furthermore, I have just been informed that Merlin has disconnected electricity to our supply, to our office, to bring our operations to a standstill. Further, it has come to our attention that in the intervening night of 24th, 25th, at about 1:44 a.m., Merlin staff installed CCTV cameras at outside our office. This was done without our knowledge and at a time when our staff had gone home after producing the edition dated 25th August 2025. Below is a photograph of such CCTV camera being installed outside our office with a timestamp. The second photograph taken today shows the camera installed by Merlin. Please take necessary steps to apprise the Honorable Court of the position and advise us on the legal steps to be taken by us. Now, my lord, two things. This talks about an interference only with regard to third floor. Now, my lord, second, and my lord, this is very important. My lord, actually, my lord, the photograph, which is the timestamp, my lord, of 1:44 is on the next page, I think, my lord. Page 19.
Yes.
Lordship has that, my lord?
Yes, yes. Showing the CCTV.
Yes. CCTV camera, my lord, being, my lord, installed. And, my lord, then, my lord, the other, my lord, is, my lord, the... Now, my lord, my lord, find it a bit strange that, my lord, a camera set up to photograph, my lord, my lord, trespass into the office of Statesman by, my lord, the person who is being accused of having set up the camera. It's unbelievable, man. But, my lord, Merlin will handle that. The allegation is, my lord, against Merlin. But what I'm showing your lordship, my lord, is that it's only, my lord, the third floor and not, my lord, the entirety of the premises.
Okay.
So, my lord, this order, my lord, unless, my lord, they succeed, my lord, in their interim application entirely, my lord, there is no question, my lord, of, my lord, continuing.
Yes.
Now, my lord, my lord, come to, my lord, the petition.
Yes.
With my iPad now. Now, my lord, the conveyance, my lord, is, my lord, of 27 June 2025.
Yes.
My lord, the amount paid my lord, is 235 crore. Now, my lord, the conveyance, my lord, refers to, my lord, certain documents, my lord, which we had. My lord, the first is, my lord, the development agreement. Second, my lord, is the power of attorney. And, my lord, the third is, my lord, that 10th May
Minutes of the meeting.
minutes of, my lord, the meeting. These are the three documents on the basis of which, my lord, we, my lord, and kindly note this, after doing a due diligence, I have papers for that, my lord, purchase the property. Now, my lord, 3 points have been made, my lord, by my learned
Only
friend.
the question how the deed was executed, because it is a development agreement. The statement entered into development agreement with the Marlin and possession given except these two places. So, and yes, there is an minutes of the meeting. He has given the purchase. Whether that on the basis of this minutes of
Yeah.
the meeting,
My lord, I am grateful.
that is
I'm
only
grateful.
question.
Yes. My lord, I am grateful. My lord, that is the only question I'll address on.
That is only
My lord,
question.
that is the only question. Because, my lord, my learned friend says, my lord, first, my lord, that the minutes, my lord, are not a registered document. So it could not have varied the terms and conditions of the development agreement, which number two, my lord, contemplated, my lord, how, my lord, the property was to be sold, and, my lord, the sale proceeds, my lord, were to be, my lord, divided, my lord, in a particular ratio. It did not contemplate, my lord, sale of the entirety. My lord, this is, my lord,
That is
I believe, my lord. Now, my lord, your lordship seen the first document which I placed, my lord, with, my lord.
Development.
No, no. My lord, with, my lord, what's her name? My lord, huh? Shalini what? With Shalini Gujral,
Gujral, yes.
which was again, my lord, the entire property leaving. Now, my lord, I'll only come to one particular clause of the development agreement and, my lord, show, my lord, that there is no modification. No modification of a registered document by, my lord, the minutes. Kindly now, my lord, kindly take the development agreement once. Page 45, I believe.
Yes, starts from page 45.
My lord, kindly come straight away to, my lord, clause, my lord, 13. My lord, the developer and the owner.
Clause 13.
13, my lord, at page 85.
Yes.
My lord, the developer and, my lord, the owner, by virtue of this development agreement, were required to hold, my lord, monthly meetings or, my lord, meetings, my lord, whenever they chose, my lord, the timing, my lord, the date, for the purposes of marketing and transferring of the project. So, my lord, they could meet, my lord, for deciding, my lord, how, my lord, the entire project would be dealt with. Kindly see, my lord, 13. The two things it contemplates. My lord, one is, my lord, a sale in its entirety. And the second, my lord, is, my lord, even leases being granted. Kindly have a look at 13.1. My lord, and then I'll show your lordship the power of attorney and, my lord, the minutes. My lord, kindly see the principle, kindly mark this, policy decisions regarding the marketing and transfer of the project. That is the total transferable constructed units in the project. So in totality, including deciding the transfer price and revising the same from time to time, shall be taken with by the developer with the concurrence of the owner, which shall be decided by the owner and developer on a monthly or such other basis as may be deemed necessary by the parties. Now, my lord, I stop here. Now, kindly have a look at this, because this clause shows that, my lord, two of them together can take, my lord, decisions, my lord, for the entirety of the project. Now, my lord, kindly come to now, my lord, the power of attorney once. 1 minute. My lord, volume 2, 135.
Yes.
At my lord 139. Kindly come to hereby nominate, constitute and appoint Merlin Projects to be a true and lawful attorney for us in our name and on our behalf to do, execute, perform and exercise all and any one of the following acts and kindly come to my lord page 139. Sorry, my lord, 145.
Yes.
Kindly see. To execute and register from time to time agreement for sale, lease, or any other document in connection with the transfer of the undivided proportionate share in the land comprised in the said property in respect of the saleable spaces of the project and to receive consideration therefore and present the above documents for registration and admit the execution of such documents before the appropriate authorities, registration authority. Then, my lord, 24. To execute conveyances in respect of the saleable spaces of the project to either in favor of the purchaser or its nominee or nominees in such part or parts as the purchaser may desire, and to receive consideration money and sign and give valid and effectual receipts or discharges thereof. Then 25, to present such conveyances, etc., in respect of, etc., before registering authority and to admit execution. So this power, my lord, has been given, my lord. So I have clause 13.1, where they can discuss, my lord, and take decisions with regard to sale of the entire project. And, my lord, this is also, my lord, a provision. Now kindly come to the minutes, and this is very crucial because, my lord, these minutes, my lord, whether they modify or not, whether they fall within 13.1 or not, operates as a stopper, my lord, between the two parties.
Yes.
But it has not, my lord, been, my lord, set aside, not been cancelled, and, my lord, there is no step which has been taken, my lord, which is, my lord, contrary, my lord, to this. My lord, this is annexed to the conveyance, my lord, which is, my lord, volume 3. My lord, kindly come straight away to page 326. This is an undisputed document.
Yes.
My lord, annexure 1.
Yes.
Kindly see, my lord. I'll place this in entire because I think this is, my lord, very important. My lord, both, my lord, sides, my lord, are represented. Kindly see Statesman Limited owners, representatives are Merlin. Then, my lord, the Statesman House Kolkata is being redeveloped as a mall by the developer pursuant to a registered agreement dated 26 March. Although it was initially planned by the developer that the redevelopment of the project will be completed within 42 months from commencement of construction work, structure of the old building was found in very poor condition. Then came the COVID-19 pandemic. As a result of the aforesaid, it was not possible to complete the project within the initial estimation of time as aforesaid. The owner acknowledged the efforts put by the developer to rejuvenate the Statesman House building in spite of having many challenges to execute the work. The owner acknowledges the fact that the construction is on schedule and is satisfactory and final completion works are in progress. Now kindly see. The owner and developer agrees as follows. The owner has agreed to purchase, acquire the right of the developer share of revenue accrued under the agreement dated so-and-so in the Statesman House project at or for a total lump sum consideration of 130 crores and also refund 30 crores paid by the developer to the owner against agreements both dated 26 March 2019, total sum of 160 crores, and same will be paid in the following manner. Date of payment, within 15th August 2024, 55 lakhs, 55 crores on receipt of completion certificate and execution of the requisite document, including sale deed, 75 crores plus deposit and advance of rupees 30 crores. Now, my lord, the owner has agreed that apart from the aforesaid amount of 160 crores, further liable to pay to the developer the following sums: 42 crores 76 lakh 785, 19 crore 42 lakh 616, and 3, owner will reimburse the further expenditure payments made by developer on account of owner towards owner's share of KMC property tax expenses for shifting of owner's office to third floor and amount of TDS with interest. The aforesaid amounts as mentioned in so and so above to the developer on or before my lord, B123 before 15 July 2024. Yeah. So, my lord, there was, my lord, 3 timelines here. For B123, my lord, 15 July, my lord, payment, my lord, for, my lord, the developer share, first tranche 55 crore 15th August, my lord, and my lord, on receipt of completion certificate and execution of documents, my lord, against that, my lord, the balance payment, my lord, of the 160 crores. Then, my lord, kindly see C. And this is very important because it deals with, your lordship recalls, my learned friend had said, oh, this was clearly given a go-by because leases had been executed. I want to show, my lord, this clause. In the event the owner fails or is unable to fulfill its commitment of payment of any of the aforesaid amounts mentioned in clause A and or B above, and the loans advances together with interest, the developer will automatically be entitled to dispose the project in its entirety. Kindly mark the words. The project in its entirety for recovery of all its dues at its sole discretion and in any manner whatsoever without any reference to the owner, and the owner consents not to raise any objection whatsoever with regard thereto, and also extend necessary cooperation to the developer in this regard, and in turn the developer will act to the best of its ability. The developer at its sole discretion would be entitled to deal with in any manner what, kindly mark the words, entire project to any one or more purchaser stroke lordship has lessee
or
the like of its choice, and at a consideration to be solely decided by the developer. And further, the developer shall, after retaining all the amounts payable by the owner to the developer to it as mentioned here and above, together with interest calculated till date of receipt of entire payment, thereafter make over the balance sums to the owner. Apart from the aforesaid agreement regarding transfer of developer share of revenue para and repayment of so-and-so, there is a separate loan transaction between developer and owner for so-and-so inclusive calculated, which is covered by a separate agreement. Then, my lord, kindly see, the title deed of so-and-so has been deposited with Merlin pursuant to registered mortgage deed creating charge on the property. It is agreed between the owner and as mortgager and its directors and Merlin Project as mortgagee that the title deed would lie deposited with Merlin Projects, and Merlin Projects would be entitled to retain it till the entire dues, that is the amount stated in A, B and D above, and other dues of Merlin is repaid. However, the owner fulfilled its commitment of payment to so-and-so and approach for relief for availing of financial assistance, etc. Developer may hand over the title documents. Now, my lord, the first thing is, if this falls under 13.1, my lord, that's the end of the matter.
Yes.
Second, my lord, if it does not, my lord, this is a document which exists. It's an admitted document. There is nothing to show, my lord, that this is, my lord, been retracted from. My lord, if that is the case, does it lie in their mouth?
Yes.
To, my lord, make a claim.
Yes.
Contrary to this.
Yes.
Now, my lord, my learned friend says to, my lord, cast, my lord, an aspersion, my lord, on, my lord, the transaction itself. Please. My lord, cast an aspersion, my lord, on, my lord, this transaction. My learned friend, my lord, shows your lordship, my lord, 2 documents. my lord, which I want to, my lord, show, my lord. My lord, what was relied on was, my lord, the stamp duty and registration charges. Look what has happened. As if, my lord, it's, my lord, something, my lord, which is, my lord, totally, my lord, unusual. My lord, kindly take section 29, my lord, of the Stamp Act. Now, section 29, kindly see, my lord.
Yes.
In the absence of an agreement to the contrary, the expense of providing the proper stamp shall be borne by, kindly come to C, my lord. In the case of a conveyance, including a reconveyance of mortgage property by the grantee, in the case of a lease or agreement to lease by the lessee or intended lessee. They said, why did Merlin? Now, my lord, kindly have a look at the conveyance. Is there anything to the contrary? My lord, conveyance starts, my lord, at page 310. Kindly come, my lord, straight away to, my lord, page 316. My lord, K.
Yes.
The owner is obliged to and the developer entitled to sell and are hereby selling and transferring the entirety of the said premises as more fully described in the first schedule, hereunder written, excluding therefrom the owner's retained area as more fully described in second schedule, hereunder written, and hereinafter referred to as the owner's retained area and duly demarcated in the plan annexed hereto and marked as annexure 2. Now kindly mark the next. For an agreed total consideration of 235 crores as per the sale agreement executed amongst the parties herein. The agreed total consideration is inclusive of stamp duty, registration fee, legal costs, etc., payable for registration of this indenture of conveyance, extra development charges, and expenses to be incurred in respect of anchor score. The sale of the said project is on as is where is basis and free from all mortgage charge, etc., subject to lease as aforesaid. So lease has happened, disclosed. Lease is also in terms of agreement, not questioned. Kindly note, my lord, it's not questioned.
Yes.
Now, my lord, kindly come to, my lord, page 318. This is, my lord. My lord, after the recitals, my lord, representations, etc. Now, my lord, kindly see 318, third line. Now, this indenture witnesseth that 1. In pursuance of the aforesaid agreement and in further consideration of a sum of 235 crores, which is inclusive of stamp duty, registration fee, legal cost, payable for registration of this deed of conveyance, extra development charges of so-and-so, and expenses to be incurred in respect of anchor store as more fully mentioned in the sale agreement of the lawful money, what's it, sale agreement of the
Lawful money of the
inclusive of so-and-so as more fully described of the lawful money paid by the purchaser as mentioned in the memo, the owner and the developer doth hereby sell transfer to the purchaser the said premises in its entirety, more fully described, etc. It's entirely, my lord, inclusive, which arrangement can be made as per 29C. After that, what Merlin and, my lord, statesmen do, my lord, is not, my lord, my concern at all. It's a matter, my lord, between, my lord, Merlin and, my lord, statesmen. These are, my lord, the documents. It's contemplated. It's contemplated. Now, my lord, the lease deed, my lord, which had been executed, page my lord, page 257, volume. Kindly see, my lord, the signatory.
Yes.
My lord, Vishal Jain, my lord, authorized signatory of Merlin project, constituted attorney of statesman. My lord, whatever decisions are being taken under 13.1, my lord, is my lord through my lord Merlin. Merlin, my lord, on the power of attorney is doing this. And the my lord, that's same thing, my lord, as my lord the conveyance.
Correct.
So, my lord, in my respectful submission, now, my lord, so, my lord, my respectful submission is first, my lord, their conduct, my lord, disentitles themselves, my lord, to any, my lord, form of relief. My lord, second, my lord, is, my lord, even on merits, my lord, at the highest, they can have a case with regard to, my lord, the 3,000 super built up area on, my lord, the third floor. My lord, that will not be dealt with, and it is, my lord, we are not dealing with it. We don't even have possession, my lord, apropos, my lord, that. And my lord, there is, my lord, third thing is, this has actually been acted upon, but I can put that, my lord, on affidavit, what steps we have taken. And my lord, electricity, your lordship should know. My lord, statesman, my lord, please, I don't want to show multiply unnecessary. My lord, statesman, my lord, has other offices. It's defaulted to CSC. Under, my lord, the electricity regulations, my lord, a default anywhere, my lord, will result in, my lord, a disconnection everywhere. And my lord, until their entire dues are paid. So we are facing that problem vis-a-vis Statesman House.
Yes.
And my lord, important thing is, I am out by 235 crores. My lord, without, my lord, paying anything, my lord, my learned friend now, my lord, is seeking interim relief, which is, my lord, should not, my lord, be entertained at all. He should come on to the same level playing field.
Yes.
It's no longer his property.
Yes.
There is, my lord, today, my lord, a conveyance. He should not have described himself as, my lord, the owner of, my lord, the property. Because to his knowledge, my lord, the conveyance had been executed.
Yes.
My lord, those are my submissions.
Thank you.
My lord, your lordship wants me to deal with the cases, I can deal with them, my lord, here and now. Very well. Lest my learned friend says, oh, Mr. Mukherjee didn't deal with my case. দেখিয়েছিল কি তিনটেই দেখিয়েছিল my lord, three cases, three দেখিয়েছিল তো my lord, three cases, my lord, had been cited.
Yes, three cases.
Yes. Kindly come to, my lord.
May I come back in just a minute?
My lord, 1958 SCC online, SC 151. My lord, this is, my lord, said Gangadhar.
Yes.
My lord, on clog on the equity of redemption. My lord, paragraph 6 and 7, my lord, had been cited. My lord, this has no application here because, my lord, the sale, my lord, is by virtue of, my lord, the power of attorney, not, my lord, by virtue of, my lord.
It's a sale by statesman.
Yes. It's, my lord, statesman who is selling. My lord, then, my lord, the next case, my lord, is, my lord, Muktakeshi Da. My lord, paragraphs 4 and 5, my lord, were cited.
Yes.
My lord, this was, my lord, whether, my lord, lis pendens, which is better, lis pendens or injunction. My lord, this is, my lord, clearly not involved. My lord, this question, the facts here, my lord, were totally different. My lord, your lordship will have a look, my lord, at, my lord, the facts here, my lord. My lord, there was a dispute, my lord, as to title. Here there is no dispute I've got from statesman. Now, my lord, the next case is, my lord, Ramakant Ambalal.
Yes.
Yes, my lord, paragraph 4 and 32 to 44, my lord. And my lord, this was specific program.
With regard to the principle of the injunction.
Yes. My lord, kindly have a look, my lord, at paragraph 4 first. No, not 4, my lord, paragraph.
Principles of run.
Yes, my lord, not just that. I want to show something, my lord. Kindly come to paragraph 8 and, my lord, 10.1. My lord, kindly see there was a, my lord, a registered sale deed had been executed on the strength of a power of attorney.
Yes.
In my lord, paragraph 10, the business had started. And 10.3, this is very important. Defendant number 1, in collusion with officials of the Office of Sub-Registrar, executed a sale deed of the property without any sale consideration in favor of his son, that is defendant number 3, illegally relying on power of attorney. The other son of defendant number 1 and wife of defendant number 3 stood as attesting witnesses. And my lord, kindly see, I'm sorry, I showed that, I thought 10.1. And my lord, kindly see what the power of attorney was. Power of attorney was executed in favor of defendant number 1 only with a view to entrust the day-to-day conduct of administrative procedure and not to enable defendant number 1 to sell the suit. And here the express clauses, my lord. And then in that context, my lord, kindly have a look at 32. My lord, para 32, principles governing grant of temporary injunction. In that context, my lord, it has to be seen that here, my lord, there was no authority, my lord, to sell. And my lord, the court further that non-interference would result in irreparable.
Correct.
So, my lord, in my respectful submission, my lord, none of these cases, my lord, have, my lord, any of these.
Yes.
My lord, those are my sum.
Thank you.
I am for the defendant number 1. The brief question. I'm for the defendant number 1.
Yes.
Malad. The what I indicate the prayers made are not against me, because Lordship kindly sees prayers A not to give effect to the page 28, not to give effect to the conveyance deed and or dealing. Today I am not in possession. I have handed over possession to, I have sold to the defendant number 2.
I've got the money at paid creditors.
I have. This is the clause for
You can take it.
Yes. Now, my lord, I have.
You can take it.
Which is the clause? Good free.
Settle all existing liability arise in future.
Clause page 60.
This is clause 3F. F.
Well, what they have not disclosed are the several letters after the 10th, after that 10th May meeting, where after the 10th May 2024, na? 10th কত? 10th May, which is the minutes of the meeting?
May 2024.
10th May 2024 meeting.
326.
Page 326. Lordship, may I start with that? Page 326. 10th May 2024 meeting.
Yes.
Now, Mala, this meeting, page 326, at 327, B, clause B, the owner has agreed that apart from the aforesaid sum of rupees 160 crore, further liable to pay to the developer the following sums. And 1, 2, 3, the aforesaid amounts as mentioned in clause B, that is the previous clause B, subclause 1, 2 and 3 above, payable by the owner to the developer on or before 15th July 2024. Then C, so 160 plus this. In the event the owner fails or is unable to fulfill its commitments of payment of any of the aforesaid amount mentioned in clause A and or B above, and the loans and advances together with interest, the developer will automatically entitled to dispose the project in its entirety for recovery of all its dues at its sole discretion and in any manner whatsoever without any reference to the owner, and the owner consents not to raise any objection whatsoever with regard thereto, and also extend necessary cooperation to the developer in this regard, and in turn the developer will act to the best of its ability. The developer at its sole discretion would be entitled to deal in any manner the entire project to any one or more purchaser, lessee or the like of its choice, and at a consideration to be solely decided by the developer. And further, the developer shall, after retaining all the amounts payable by the owner to the developer, to it, as mentioned here and above, together with interest calculated till the date of receipt of entire payment, thereafter make over the balance sums to the owner. Apart from the aforesaid agreement regarding transfer of developer share of revenue, paragraph A above, and repayment of 30 crores, A and B above, there is a separate loan transaction between the owner and developer between the developer and the owner for 39 crores, for 33 crores inclusive interest, which is covered by a separate agreement. The title deed of the Statesman House situated at 4 Chorangi has been deposited by the owner, namely the Statesman Limited, with Merlin Projects on 26th of March. Pursuant to registered mortgage of 26th March 19, creating charge in the property to secure all monies that are due to Merlin projects. It is agreed between the owner as mortgagor and its directors and Merlin projects as mortgagee that the said title deed would lie deposited with Merlin and that Merlin Limited would be entitled to retain it till the entire dues, that is A, B, and D, above, and other dues of Merlin is repaid. However, if the owner fulfilled its commitment of repaying 55 crores to the developer and approached the developer for release of the title document for availing financial assistance to fulfill its further commitment of payment to the developer, in that event, the developer at its sole discretion may hand over the title documents to the the concerned lender directly to enable the owner to avail such financial assistance, with the condition that the same would be exclusively utilized for liquidation of owner's liability to us. Now, after this, well, first
in terms of clause 13 of the development.
no, I will show the power of attorney. Now, Lordship, after this date, we thereafter, even though under no obligation to give them any notice on their default, we gave a notice on 3rd of July. 3rd July, 3rd July, we sent an email, and which they have very conveniently suppressed.
353 of the section 9
No.
application.
3rd July 2024, which is a part of the section 9 petition. At a copy now, George K. Are you at a copy that's no. Acha. Down. Yes, ठीक है. I should kindly take a look. For the copy. We are shocked. No, sorry. Yes. 3rd July 2025. Well, it 25. কি দেখাচ্ছ তুমি 3rd July
24
আরে ভুল দেখাচ্ছ 3rd July 24 have I given the 20 তুমি আমার কি ভুল ভাল দেখাচ্ছ 3rd July 24
at 12:32 p.m.
yes আমি এটা করে দিয়ে দিচ্ছি at the bottom, 3rd year. Pursuant to the financial assistance dated 10th May, you have agreed to repay the entire financial assistance given to you along with interest thereon calculated till 15th July. What's that about? Amounting to 33 crores. We here therefore request you to make payment of the said sum of 33 crores on or before 15 July in terms of the said agreement. The RTGS details of our account is given below. No response to this. If at all the 10th May had slipped their mind, here there's specific reference to 10th May. The clients in their legal parlance called it, in their commercial parlance refers to a financial assistance agreement. Minutes of meeting they call financial assistance, which is in effect financial assistance. It specifically refers to the 10th May 24.
Yes.
Then thereafter, on 10th August 24, WhatsApp message goes, no? Kindly takes a look at this. This is to Rajendra Gupta from Mr. Sushil Mohta of the defendant number 1. This is on 19th August 24. The one at the bottom. Sir, namaste. Vishal JNG has been in touch and discussing with me for the last 7-10 days and hope he has apprised you with the reasons, etc. Rajendra Gupta. Sir, nothing. Thereafter, next page, referring to this. This is the reply. Yes.
Yes, this is the reply.
Sir, nothing concrete coming from you in our last meeting. You promised loan and other payments by 15th August. And the reply is having pressure of loan repayments. So further they requested some more time. We gave them further time.
Yes.
They have not challenged the 10th May 2024 meeting, though they have annexed it themselves in the suit. Now, Lordship has seen the registered power of attorney was cancelled when?
14 July 20.
Was cancelled on 14 July 2025.
14.
Before that, the power of attorney was subsisting and valid, and which is annexed at page 135 of the injunction petition. 135 in the relevant clause, I think Mr. Mukherjee may have placed, is clause 23.
135.
135 it starts.
Yes, 145, 23, 24,
Yes,
24.
23. So land also have specific power to sell the land. And this was very much subsisting because they've cancelled it thereafter.
Yeah, when the power of attorney was cancelled?
14 July 2025. 14 July.
Where is that letter?
Page 351, 14 July 2025. 351.
They gave 14 July 25 and we are there.
Or should kindly takes a look at 351.
Baldua.
Paragraph 7. You have fraudulently misused the power of attorney issued to you on 26th March 2019, which was strictly governed by terms of the joint development agreement. This is an independent document. This is not incorporating the terms of the development agreement. This independently gives powers. By executing the purported deed of conveyance, you have attempted to create third-party interest over our assets. You have no right to deal with any property, any part of the property without approval and consent from us. The lawful owner has clearly laid down in 13.1 of the joint venture agreement. All acts done by you are null and void and not binding. All acts, now paragraph 12. Since you have acted completely contrary to the terms mentioned in the joint development agreement and the power of attorney, we hereby terminate the joint development agreement and the power of attorney. So it is terminated clause, paragraph 12.
What is the date of the conveyance?
The conveyance is 27 June 2025. That is paragraph 8 of the same letter at page 352.
27 June?
25. And they cancelled the power of attorney on the 14th of July.
Yes.
The power of attorney gave me the power which
145 you were placing. Clause 23.
Yes, next.
So next is after the Lordship, under the development agreement, they are to keep the property free from all liabilities. Lordship kindly comes to page 67. I have so far, after the conveys, after receiving money from the defendant number 2, I have met with 38, I shall disclose, I've got all the 38 orders passed earlier from workers, from the employees of statesmen, whose dues they have not paid for last 3, 4, 5 years. And I have had to clear all of them so far because I am liable to Hatishala, defendant number 2, for giving a clean title. So, as and when I am receiving these demands,
25th July, we have made payment June का भी देखा. All payments and letters, the settlement होएगा जो
this
settlement.
is 20th July.
June में हुआ.
June, July, continuously we have received. Lordship kindly comes to starts from $35 workers have had to be paid so far. Lordship, here is the whole set of what they have said now. This is so far as in July, I have received. I have had to pay from out of the sale proceeds. This is month of July. 25th July. Lordship kindly sees at the bottom. Last page. After that, all the certificates have been cancelled.
What is this in compliance with the order dated 2nd July and 22nd July passed by your?
Those are these are all certificate officers' orders restraining us from dealing with the property. Though this really didn't bind me because this was already the sale had happened.
And this is 25th June.
I was not aware. These are all claims against statesmen. And so in compliance of those orders, I have paid off all the certificates from out of the sale proceeds. And Lordship kindly see the last 10 or 12 documents are the orders passed by the certificate officer recording that I have settled the certificate dues. Last 10, 12 pages are all from 25th June 2025 onwards. I have been June, July, we have paid off all the dues as and when received. The dues of the employees.
More than 1 day after the 10th.
Why you have paid?
Because they got attachment orders on the property. And even though
attachment order of the property that was prior to the deed or after the deed?
we were given these orders by the workers. They all came. They all
Deed was on 26th of June 2025. Correct. When the attachment order was passed by the certifying officer?
It must have been earlier because those
the attachment order, how the deed was executed?
These have been subsequently settled. Attachment orders have to be seen.
Unless it is released, how the registration has been done?
Well, attachment.
So we received something subsequently.
Because
where is the release of the? Where is the release of the property by the certifying officer?
Yes, Lordship kindly sees the orders at the bottom. Lordship kindly see the orders. Lordship takes any order at the end. Takes any order at the end.
Yes.
Lordship sees that the last 4 lines. Now, in exercising power conferred on 44 of the Act, certificate proceedings for the say instant case are hereby cancelled.
After this. 25th of June.
These are all 25th June.
Prior to the
prior to the sale. Prior to the sale.
That's why I'm asking.
25th June. And that's why workers have not come forward challenging it.
Yes.
Now, Lordship, even though under
So, with regard to this proceeding, has the power to appear before the authority and to clear the dues?
Well,
it is against the statesman. It is against the statesman and the workers of the statesman. It is going and the property of the statesman was attached. has in the power of attorney, has your authority to appear in the proceeding and to pay the amount?
This is the subject matter of the Section 9 application, which is as per the arbitration agreement. We have made the other Section 9. That is exactly our Section 9 application. That Section 9 is. We have prayed for depositing the money in court, whatever money is there, for the court to settle all workers, and also for the arbitrator to decide how much could go to workmen, because that's an interstate dispute between us. How much should go to the workmen and how much should be paid to them. That is my specific Section 9 application. Copy the Judge Saab ki na Judge Saab. Judge Kelly sees where may hand up a copy of the application given by my juniors. Yes, Lord Kelly takes a look at the. This is subject matter of the because there is the interstate dispute between the workmen and the interstate dispute between statesmen and the respondent number 1.
Sought the Section 9 on 18 July and on 1st August, after 10 days they filed this.
And this, Lordship, kindly notice one thing. 18 July, we served the Section 9 application on them. On 1st August thereafter, they presented the plaint.
So what has happened to the Section 9?
It is still pending. Now also we have got precipitated because matter is being heard by my lord. So lest it be said that we are trying to overreach the court. Because since the Lordship is hearing the matter, that's why we also did not take steps for urgent hearing. Now,
so this Section 9 is only with regard to the payment to the
sale consideration. What happens to the balance sale which is due and payable to them? What will how will the money be dealt with? Whether it will be given to them or to any workers or to other creditors of the, because after all it is their contractual obligation under the development agreement to keep the property free from all encumbrances. That is page 67 of the development agreement. It is clause 3.1F. Page 67. The owner has represented and warranted to the developer as follows. I am on F. Owner shall arrange to settle all its existing liabilities or any liabilities that may arise in future at its own costs and expenses, and shall keep the developer and the said premises fully safe, harmless, and indemnified against payment of the same in any manner whatsoever. Anyway, this is our whether we had rightly exercised our power of selling, because this is a dispute between the plaintiff and defendant number 1. That is covered by the arbitration. Arbitration has been invoked earlier. Section 9 has been filed much earlier. So,
no, arbitration on the basis of which clause?
The development agreement which they are relying upon has the arbitration clause.
Now the development agreement remains after the deed is executed.
But after the deed is executed, the development agreement goes. But the arbitration agreement, Lordship kindly comes to the arbitration clause. Arbitration clause. Arbitration. So, page 103. Whether the arbitration agreement disappears with the, because that is Lordship knows that the arbitration that the arbitrator will decide. Page 103. The parties shall attempt to settle any disputes or differences in relation to or arising out of or touching this agreement. Arising out of. So arising out of will also include conveyance. In relation to or arising out of or touching this agreement, or the validity, interpretation, construction, performance, breach, or enforceability of this agreement by way of negotiation. To this end, each of the parties shall use its reasonable endeavors to consult or negotiate with the other party in good faith and in recognizing the parties' mutual interest and attempts to reach a just and equitable settlement satisfactory to both parties. If the parties have not settled the dispute by negotiating within 30 days from the date on which negotiations are initiated, the dispute shall be referred to and finally is resolved by arbitral tribunal in terms of the Arbitration Conciliation Act. So arising out of, well, or conveyance also arises out of it.
Yes.
Subsequent negotiations between the parties, subsequent agreement, 10th May 24, also arises out of it. 10th May कौन page है? 10th May कौन page है? 10th May कौन page है? 10th May. Because the 10th May also expressly arises out of the development agreement. Well,
Mr. Mitro,
yes.
your argument is not a contradictory. If you are going by the arbitration agreement says that the owner is a liability to keep the premises free from all encumbrances. Correct. Now you file the section and you have showing that there was a claim of the employee of the statesman.
Liabilities of the, yes.
Correct. And the deed was executed by taking into consideration of your MOU, minutes of the meeting, correct, and the development act.
And the power of attorney.
That power of attorney, MOU, and this.
My lord.
Now, thereafter, the deed was executed on June 23rd of June.
27th June.
27th of June 2024. 5. Now, you filed this Section 9 application on 17th of July 2025. And you are telling that this conveyance deed is in accordance with these documents.
Yes.
So how this all can go together?
Well,
either that means as on date you file the Section 9 application, the property was not free from all encumbrances. Because you are telling that there was encumbrances where the amount is to be paid, and subsequently you paid the amount without informing the plaintiff, then there is no power of attorney to you to clear the dues. How
I could pay off the dues?
Yes. If you are relying upon the development agreement and the power of attorney and the minutes of the meeting, power of attorney and the memorandum of understanding having several clauses.
Power of attorney, separate clauses, yes.
Several clauses including the free from encumbrances. Admittedly, that was not free from encumbrances, taking into consideration of the dues of the employees, and you admitted dues of the admitted. And in the power of attorney, there was no clause upon you to deal with the employee of the statesman. And you have cleared the dues without the intimation of the plaintiff and registered the deed. Whether it is a fair transaction.
She kindly sees there's a clause in the power of attorney, page 141. Page 141.
Show me.
Clause 15.
$15.
1-5.
Yes.
$15 and $18, Lordship. To commence, prosecute, enforce, defend, answer, and oppose all actions and other legal proceedings and demands touching any of the matters concerning the said property or any part thereof, including relating to acquisition, the requisition in respect of said property or any part of it, and if think fit to compromise, settle, refer to arbitration, abandon any such action or proceeding. To compromise. Now, whether I have rightly compromised, whether I compromised for a larger amount, that is a dispute inter se. And Lordship also clause 18, my lord. Clause 18.
Yes.
Similar, clause 18, to accept any summons or other legal to appear in any court or authority as our attorney deems appropriate, and to commence any action or legal proceedings in any court or before any authority. So that is, again, I'm saying that is the subject matter because that is arises out of the development agreement power of attorney. So that is.
No, that's why I asked. Where?
Well, that is absolutely right. Yes.
Yeah, next.
Now, my lord, anything else remaining? Just give me a minute. The loans which they have received from us, it is admitted in the. One more thing, a submission was made. First, that registered, the power of attorney is registered. So, under the power of attorney, I don't have power to sell the land. This 10th May is an unregistered document. Unregistered document will give the power of sale. This cannot modify the development.
Registered document.
To that I have two answers. One is my power of sale is in the registered power of attorney. Clause 23 and 25. Secondly, 10th May 24, they agree that I can sell this property in case they do not pay the dues. Does this agreement be just ignored? Is it a nullity? Because this is, though they consciously both two commercial entities signed the document. And this is a piece of paper. I'm a submission no. So it will be a nice fraud. Every borrower will then agree in writing to settle. If not, you may do this. And then when it is done, this piece of paper, commitment to pay, means nothing. Because this is a wonderful exercise by any borrower. Because this is a nullity. So I keep on promising to do certain things, but since it is not registered, Lordship, this is not the law. Lordship, first, registered agreement. Here, of course, is not required to put my case that high. But this dishonest argument, I wanted to counter by relying upon. Now,
I think this point was you argued in another matter. Mukesh Hundai something.
Malar?
Mukesh Hundai, Mr.
Mukesh Hundai.
Dealership was cancelled and agreement, the amount was to be returned. There was minutes of the meeting. You want to argue the matter? Let us see.
Lordship kindly considers 2019 5 Calcutta High Court notes, page 409. Where copy दिएगा? Thank you. Paragraph 15 of this judgment. 15 is the question. Paragraph 15. First, he took a technical point. The development agreement was compulsory registrable and therefore registered. It could not be varied by the unregistered agreement for cancellation. A right to property had been created by the development agreement, which was sought to be extinguished by the cancellation agreement. It needed registration. He also submitted that by mutual agreement, that's not relevant so far as this. It needed registration. The answer to it is paragraph 18 onwards. First of all, let me deal with the argument that the document described as a deed of cancellation was compulsorily registrable as it sought to rescind or vary the registered development agreement. Did the development agreement create any right, title, and interest in the immovable property? If it did, and since it was registered, rescission or variation of that right, title, and interest by the deed of cancellation would be required to be made by a registered document. In Shaktivel versus so, Lordship, can you see now the answer? 22 onwards, the answer starts. Or 21 onwards.
21, yes.
Let us
create the such right or not.
The 20?
21 onwards.
21. Let us, for the sake of argument, assume that the development agreement did create such a right. What was the nature of the deed of cancellation? It was an executory contract. It was an agreement to put an end to the development agreement upon fulfillment of certain terms and conditions. Upon fulfillment of these terms, a formal document would be executed. If the deed of cancellation by itself changed the terms of the registered agreement, then being unregistered, it would be hit by 92. There's a fine distinction between changing the terms and conditions of a registered development agreement, registered document by an unregistered deed, and entering into a wholly new agreement, which is the effect of putting an end to the obligations created by the registered document. Let me give you an example. Suppose there is an agreement for sale between two individuals. It is duly executed and registered under the Registration Act. After a period of time, the parties executed an agreement extending the time to execute the formal conveyance. The document is not registered. Could it be said that since it sought to extend the time period to execute the conveyance, it was compulsory registrable? Answer is no, as it is an independent, separate subsequent agreement. It cannot be said that it rescinded or varied the terms of the sale deed. Take another example. There's a registered deed of sale of a property between the parties. At a future point of time, they enter into another agreement, a new one discharging the parties from their obligations by mutual consent. This is not compulsorily registrable, although the agreement for sale was. In fact, the fourth paragraph of Section 92 of the Evidence Act conceptualizes this situation. It is in the following terms. Section 92 proviso for the existence of any distinct subsequent oral agreement to rescind or modify any such contract, grant or disposition may be proved, except in cases in which such contract, grant or disposition of property is by law required to be in writing or has been registered according to the law. Sarkar in his treatise on evidence has given the following example. A receipt which says, I release you from the liability to pay compound interest, as written in the register in the said mortgage bond, is admissible, though the receipt is not registered, and it operates as a full acceptance for the money already paid. He has also quoted from the English decision, a contract required by law to be in writing may, whether before or after the breach, be wholly rescinded by an oral agreement, even though the latter be not itself enforceable. In the treatise, Sarkar has quoted a passage from an English decision, Goss versus Nugent. Worship kindly comes to the by the general rules of the common law, if there be a contract which has been reduced into writing, verbal evidence is not allowed to be given of what passed between the parties, either before the written instrument was made or during the time that it was in a state of preparation, so as to add or subtract therefrom, or in any manner to vary or qualify the written contract. But after the agreement has been reduced into writing, it is competent to the parties at any time before breach of it by a new contract, not in writing, either altogether to waive, dissolve, or annul, qualify the terms of it, and thus to make a new contract, which is to be proved partly by the written agreement and partly by the subsequent verbal terms engrafted upon what will be thus left in the written agreement. In those circumstances, the argument executed by Mr. Banerjee that the deed of cancellation needed testing not submitted. It was an executory contract, a new contract which would have the effect of discharging the obligations of the earlier contract. By performance of specified obligation, it was certainly not registrable in our opinion. Therefore, all the terms and conditions of this document can be relied upon by the appellant.
In this case, it is exactly in terms of clause 13, because in dealing with spaces.
Yes, 13.1. That Mr. Mukherjee. That
And-
Mr.
and all-
Mukherjee has argued.
And now, Ballot, so far as all the clauses may get discharged, but so far as arbitration clause, as Lordship knows, Sanjeev Prakash survives the supersession of the agreement. So the arbitration clause will remain. Sanjeev Prakash Supreme Court.
And suppression and their conduct. Whole thing is on borrowed money.
First, the Lordship June rightly points out. First, they owe money to State Bank of India, 30 crores.
30 crores.
They come to me, borrow money to repay State Bank.
Then mortgage redeem করার জন্য, নাহলে
Redeem the mortgage and develop the property. In course of development, they keep on borrowing money from us.
From me 20 crores, from others 30 crores, 50
Which I-
crores.
which I have arranged. Then, my lord, thereafter they say that let the project be sold to one Shalini Gujarat for 200 and, some crores,
Then Shalini
290 crores,
Shalini is their person who doesn't turn up.
who simply disappears in thin air. There are several negotiations by which they say you sell it and we shall adjust the sale proceeds. Ultimately, we can't wait any longer and we say 10th May, this is the final arrangement.
That you
And
prefer-
now
you had
they
the first
say
option.
10th May, they had the option to repay and take it back. They had the option to sell it and to repay the money. They just sit back.
And they agree
And then they
all
say,
liabilities
then they
will be
come
paid.
to court and say that this 10th May is ignore it. Ignore it. Suppressing my demand notices by which I ask him to comply with this. WhatsApp, email, suppressing them. And then they come and say, just ignore it.
1 month later, after all his creditors come after the money.
Yes.
Well, this
ওই
is
চিঠির
really
suppression গুলো দেখান। Supplementary agreement to suppress করে।
supplementary
এই দেখো,
agreement.
This has been suppressed by them. দেখো,
এটা এটা আমাদের এটা কার সই করা ব্যাপার? কি সই করেছেন ব্যাপার? এই যে সই করতে এটা কি?
This is subsequent document signed by them. Kumar.
I think this is signed by him.
Yes, and it's referred to in Shalini Gujarat agreement. Rajendra Gupta.
No, this is before the MOU. No,
Yes.
before the minutes of
No,
meeting.
no, it's suppressed in this proceeding.
Yes, before the minutes of the meeting.
Yes,
And
referred to in the minutes.
Lordship kindly takes a look at one more document. This is referred to in the minutes of the meeting.
Sumanda.
Kindly see paragraph 4.
This is between whom? Statesman and
Desmond and Merlin.
Signed by
This is all part of the
Gupta.
section 9.
What is the
Signed by the Gupta.
6 July 2022.
22. এখানটা দেখুন।
I'm only showing how many previous.
The agreed owner's share of sale proceeds will be adjusted in the following manner. তখনও
Lordship
বলেছিল
kindly
adjusted.
comes to clause 4 in partial modification of the relevant causes of said agreement. Said agreement is the development agreement. The owner and developer will jointly decide all aspects of planning saleable areas, so and so, so and so. Then at their meeting on 20th April, the developer had agreed to prepare marketing plans, 3D presentations and commence marketing. It is now agreed that the owner's share of net sales revenue will be appropriated, disbursed, adjusted in the following manner. 50% will be adjusted first for repayment of existing loan together with applicable interest as more fully described in the second schedule. Second schedule, yes. Investors loan.
Which is innocent but
Innocent Bhattar, etc. to 20 crores, and the remaining 50% will be paid to the owner. Once the aforesaid two adjustments are made, the further amounts on account of receipts of the owner's allocation shall be paid to the owner, save and aside an adjustment of balance interest-free security by the 10 crores. After repayment of loan, interest-free deposit in fulfillment, mutual decide to
share unsold area.
share unsold area. There were various
So he
attempts.
agreed to pay
Well,
everybody.
there are various attempts to
তারপরে
pay off the
second
dues. আচ্ছা
না না
কি দেখা
তারপর চিঠিগুলো যেগুলো
কি দেখেছি?
পুরো জুলাইতে হি ওয়েটেড
that I've shown,
প্রেস করেছে
I've shown the email of July,
emails,
the email of July
July
2020.
and August. That Mr. Mitra shown.
to 1st August.
Yes, one is
Why
July and one
should
is July, one is August. Mr. Mitra has shown to this. Then
He was not there.
I've got 7 or 8 of them.
But we shall file our affidavit, then we shall disclose more. But then this is an abuse of process. When they know about the suit, they, the section 9.
Attachment order গুলো বলেছেন
yes, there was a question. Then Mr. Mitra's with regard to the attachment order.
every day something is happening. Very
Yes.
clever strategy. আর আমরা কিছু ডিস্টার্ব করি
One more thing is that we had there was no disturbance by us.
But they were
there's 1500 square feet.
Well, we are
offices at
only
limit.
under an obligation for that trend where the lease has been granted to help them to do the fit out work, and certain finishing work is required to be done, which is the jointly developed, which we jointly agreed. We were doing that. So far, the possession of the property is entirely with Hatishala, apart from that lease portion.
এই যে এখানে কমপ্লেইনটা করেছিল সেদিন এসে 4 o'clock, knowing we will not be here. দেখুন that somebody is disturbing their possession. We are not disturbing their
Somebody. Is there mention of
আমি তো
Merlin?
নেই ওখানে।
Is there mention of Merlin?
এই যে 10 people from Merlin, wrong.
We are denying any disturbance.
না না ওই যে ফিট আউট হচ্ছে ওখানে
Trend.
ওখানে একটা দুটো লোককে সব সময় যেতে হয় to help.
They just wanted to create that drama for that extra effect on that day.
That's all.
That's all.
Thank you. Yes, complete.
Lord, all that I could understand, my lord, from the submissions of Mr. Mukherjee and Mr. Mitra, that there are issues to be tried. If there are issues to be tried and the court feels that evidence is required, then, my lord, in a matter of this nature, my lord, where we are dealing with immovable property, the first thing is, my lord, the court should pass an order where, my lord, at the ultimate end of the litigation, if the plaintiff succeeds, he can be put back into that position. So, all that I need to show at this stage, when my learned friend says I'll deal with each one of them, it shows that I have a lot to say or put it on affidavit, is that they have more to say, and they have more to say against me. I also will have to reply to them. But the fact remains that there are issues. If there are issues, my lord, the property needs to be protected. That's number one. And I have cited authorities to that effect, that like Mr. Mukherjee comes and says that I am a bona fide purchaser for value without notice. Somebody else will tomorrow come and say that no, Mr. Mukherjee has also sold it to me, so I also become a bona fide purchaser. So to prevent that, this order of injunction. Now, my lord, first let me deal with Merlin's app, because, my lord, it is he who has caused all the problem. My lord, a lot of stress has been relied upon paragraph 13.1. Now, my lord, kindly see what 13.1 says. A, it's part of a development agreement.
Page.
I'm sorry, my lord. Clause 13.1
87,
would be
yes.
at page 85.
85.
But completely, this has been taken out of context, because this is part of the development agreement. And what are the parties agreeing in this development agreement? It is how to deal with the spaces in the projects. What does spaces mean? My lord, developers allocation and owners allocation. How will we deal with it? Once it is developed, how will we market and sell it? The principal policy decisions regarding the marketing and transfer of the project, which means, Millard, the owner's allocation, developer's allocation, both. Total, including deciding the transfer price, reserving the same from time to time, shall be taken by the developer with the concurrence of the owner. So as and when a purchaser comes, we will decide as to what will the price to be paid, and at that time you will not have an exclusive right. It has to be with the concurrence.
Correct.
So Millard, here is a question of consent, or here is a question of concurrence evident, which shall be decided by the owner and developer.
Yes.
On a monthly or such other basis as may be deemed necessary by the parties. The sale considerations in respect of the sale shall be collected by the developer and be deposited in a separate account to be opened for such purpose. No other bank account shall be used for the deposit of sale consideration from the project. Millard, I pause here for a moment. This is exactly, Millard, what I have been harping from day one, that we had agreed that after development, there would be a joint decision to sell. And on the basis of the joint decision, which is 13.1, we will meet monthly, whoever is the purchaser, we will decide on the price, it would be sold, and the money would come into a separate account. So, all that 13.1 says, and as I understand, is that in a development agreement, the owner and the developer is agree that by consent of each other, we will agree on who would be. But lot has been said about 13.1 because this is being tried to be tagged with the 10th of May minutes. But I may ask myself this question, had this clause not been there, would it have prevented the parties from holding meetings? No, meetings can be held. So there was nothing for them to come and say that, look, under 13.1 I had this meeting. In fact, the 10th May doesn't say that in terms of 13.1, we are holding this meeting. That's number one.
But under what circumstances you hold the meeting on 10th May and come to that?
I'm coming to that. That would be evident from the document itself. Either it's there or it's not there. If it is not there and the question is a reason why 10th of May, that requires evidence. So the parties have to come to the box. But at this stage, Millard, we can only go by what the parties have recorded in 10th of May. Millard, I'll come to that.
That's why if you go by the parties to be go by the 10th May, then how you can say the deed is to not to give effect to that?
Millard, I'll tell your lordship, Millard, your lordship has not noticed that none of these parties none of the defendants have argued on the cardinal question which I had argued before your lordship. The right to sell the property follows from the deed of mortgage. None of them have addressed that.
Okay.
That mortgage deed provides them that right to deal with my title. This power of attorney has to be read with the development agreement. And when I say so, Millard, I deal with Mr. Mitro's second argument when he says that the power of attorney is an independent document. Millard, kindly come to the power of attorney once. Millard, it's at page 136. It starts. Kindly come to 137. Power of attorney devo bola hai.
Yes.
Millard, 137. Kindly see clause C.
Yes.
Pursuant to and in terms of the said agreement, we hereby intend to nominate, constitute, appoint Merlin Projects to be our truthful attorney to do all following acts and deeds. What is the said agreement? The said agreement is the development agreement. And the development agreement also records that to enable him to effectively carry on the development work, we shall execute a power of attorney. So this is not an independent document that I have given him. Look, I'm giving you a power of attorney, you go and sell my property.
Yes.
Millard, kindly take this clause Milord, I'm sorry, Milord, kindly take 79 and 137 side by side. होता है तो? Yes.
Yes.
Milord, kindly see clause 79, Roman 5. Milord, it is a paragraph apart from the aforesaid general power of attorney, the owner shall execute. Sorry, Milord, I'm sorry.
Apart from,
Milord, just penultimate paragraph.
yes, apart from the aforesaid general power of
The
attorney.
owner shall execute such other power as may be required by the developer in the matter of implementation of the project. This is this power. So it is intricately connected to the development agreement. The impression that I got is that, look, I had a power. That power authorized me to conveyance and sell. And it is an independent, as if I have authorized somebody to go and sell my property. But without documents show that it is intricately connected with the development agreement. So the power to sell a property would depend on the terms and conditions of the development agreement. And the development agreement expressly says that you will develop the property, of which my share would be 55, you would be 45. So where does he, in my respectful submission, my lord, get the right to sell off the entirety of it without notice to me?
Yes. Yes.
And kindly, my lord, see 8.6. While exercising powers and authorities under the powers or powers of attorney to be granted by the owner in terms hereof, the developer shall not do any act, deed, matter, or thing which would in any way infringe or prejudicially affect the right of the owner or go against the spirit of this agreement.
Yes.
The power shall be specifically given and shall not be revoked during the subsistence of this agreement. So, my lord, this power was very well, my lord, what should I say, my lord? Very clearly says when you can exercise this power.
Yes.
Now, my lord, kindly come to the question which all of them are trying to argue, as that is the 10th of May. My lord, two things are very important. There was a stage in this project was to complete within a particular time. COVID extended in and whatever it is, ultimately we have come to 2024. Now in 2024, when this minutes was entered into, if your lordship sees the entirety of the minutes, this minute is only for the purpose of repaying the dues. Clearly says. It says it can repay the dues within this timeline, failing which is the clause which they are harping on.
Yes.
Page 327. It very clearly says, my lord, kindly read 326, my lord. This portion has nobody.
Yes.
My lord, the owner and the developer agrees as follows.
Correct.
The owner, that is my client, has agreed to purchase and acquire the right of the developer's share of revenue accrued under the agreement of 26th May 29 in the Statesman House project at or for a total consideration of 130 crores and also refund 30 crores paid by the developer to the owner against agreements dated 26th.
Total 160.
So I agree to buy him off.
Correct. Because as per the development agreement, you have to pay, he has to invest, so you will refund that.
And so therefore 130 there, 30 is on account of mortgage.
Correct.
The owner has agreed to pay this, then the following millard is repeatedly millard.
So these are the
this amount. Now thereafter it says that if I fail to pay this money, then he will get a right. Let's read it, millard.
in the event.
Even the owner fails or is unable to fulfill its commitments of payment of any of the aforesaid amounts.
Yes.
In clause A or B above,
Yes.
and the loans advances together with interest, the developer will automatically be entitled to dispose the project in its entirety for recovery of all dues at its sole discretion in any manner whatsoever, without any reference to the owner, and the owner consents not to raise any objection whatsoever with regard thereto, and also extend necessary cooperation to the developer in this regard, and in turn developer will act to the best of his ability. My lord, all it says, if I might say so, my lord, is that if I fail to pay, the property is with you, the title deeds are with you, you can sell it. Let's take it. Let's take it. This is what they are trying to argue. Millard had
then no. Then here is the main will automatically entitled to dispose of the project. What is the meaning of project?
automatically if you say if it's the project, it means Millard, as Mr. Mukherjee says, the project that is never in the development agreement. That is my share as well as his share.
Correct.
So if I am unable to pay off your dues, then you have a right to sell.
Correct.
Now, thereafter, if your lordship says, then it could have stopped over there, but it goes a little further. And thereafter it says that if I pay you 55 lakhs of rupees, you will return the title deeds to me. So, my lord, all this 10th May agreement envisages is that I acknowledge that there are dues to be paid to Merlin. I promise to pay him the dues. Failing which I say you can sell, but if I pay you any bit of money, then in that event you cannot sell the property under the mortgage right you have. Now, my lord, three objections I had to this. My first objection is that this piece of this agreement, if the parties had to, my lord, follow it up, my lord, then my learned friend need not have relied on the mortgage to sell his right. He could have simply said that, look, 10th of May is an agreement by virtue of which I have a right to exclusively sell the property. He didn't require the mortgage. Now, this right to sell the property either has to be in consonance with the development agreement for which it is required to be registered. And having said that, what was not drawn to your lordship's notice is, my lord, that the development expressly says that any modification has to be by way of register. 103. 103.
Clause 23.
Clause 23. I have shown this, Willard.
Yes.
No amendment or modification of this agreement or part thereof shall be valid and effective unless there is an instrument in writing executed all the parties expressly referring to the relevant provision of this agreement.
Shall be valid and effective unless it is an instrument in writing
By all the parties and expressly referring to the relevant provision of this agreement. So to say that this would have an effect on 10th of May 2024 minutes will alter the rights under the development agreement, this would have to say that in alteration or in violation or in change, or not violation, in modification of the development agreement and in particular clause thereof, the right which you had under the development agreement is hereby taken away. This 10th May doesn't say so because it was not intended. Coupled with the fact, my lord, my second argument
Yes. Yes. Next.
is that if this is a development agreement which is registered and if it is modified, if the rights are modified, it has to be by way of a registered agreement. Because the judgment which Mr. Mitra showed, my lord, that judgment says that an agreement for sale was entered into, which was supposed to be done within a particular time. Thereafter, the parties entered into an agreement which is unregistered, extending the time.
So as per your submission, what would be the effect of this 10th May 2020?
My lord, the 10th May 2024 agreement, my lord, it's not my submission, my lord. My lord, it shows thereafter that there has been a lease in favor of two other leases have taken place just after this. where the parties have acknowledged that the development agreement is subsisting. And not only that, my lord, my share has been recognized under that lease. So if 10th May is there, my lord, he need not have taken my signature for the purpose of executing that lease. He could have said, now, right with 10th May, I am the owner. So he also did not take 10th May to be a letter for the purpose of, my lord, giving him an exclusive right to sell.
Okay. Yes. Next.
Next. No, what the evidence and Millard, since my junior will say that you have not said so. In paragraph 29, Millard, I have given the exact dates as to how many meetings we have held thereafter after 10th May. And this issue was never brought up.
Paragraph 29.
29.
Thereafter.
Thereafter,
Thereafter the party.
yes.
Yeah. Then.
So, Millard, this issue was never, this 10th May, Millard. Now, Millard, how this 10th May letter has been utilized. That is, Millard, the thing, Millard, which I think, Millard, is the crux. Kindly take the conveyance.
Page.
Volume 3, page 310.
310. 310.
Yes, Millard, it starts.
That is the conveyance deed.
That's the conveyance.
Correct.
Millard, please put, Millard, in my respectful submission, Millard, put an end to this entire thing.
Which para you are referring to?
Millard, kindly come to the recitals, which starts at from 314.
E.
314.
Yes.
And paragraph G.
Yes.
The owner intends to retain built-up space measuring 1500 square meter more or less super built-up area on the third floor of the existing building for its office purpose herein, and after referred to as the owner's retained area. It is pertinent to note that the said premises has been mortgaged to the developer with a registered deed of mortgage dated 26th March 2019. So he need not have brought this mortgage issue over here. He could have easily said by 10th May, I am selling off my right. Because he knows that is not giving him the right to sell. So he brings in the mortgage right now. The said mortgage stands released.
Released. This present.
Kindly see.
Yes.
This said mortgage stands released by this present.
Correct.
And the developer shall adjust from the sale consideration amount mentioned herein all its receivables from the owner. Millard, if I may ask myself this question, if you had the right to sell under the 10th May, and if it was your understanding that 10th May read with the development agreement gave him the right, then he could have sold it on that, but he knew that the title was not coming. And that's
so you mean to say, if with this clause G read with the minutes of the meeting of 10/4, so you cannot say this is for the sale of the property in question.
Not at all.
Okay.
And Millard, thereafter H. The owner has taken various loans advances from the developer time to time, and further expenses were incurred by the developer on behalf of the owner relating to payment of corporation tax, office shifting space, CSC. To fix the modality of repayment of the said loan advances, mutually agreed of the aforesaid developer share, there was a meeting held on owner and the developer on 10th May at the office. In the said meeting, it was recorded owner will comply with the obligations and payment of the aforesaid amount of 15th May. So he also understands to be a meeting for repayment of dues. So as I said, Millard, on the very first day, he has taken three pieces from together, which is not permissible in law. To sell, he has to enforce the mortgage. So title is with him. B, he says that, look, to enforce that mortgage, I will have to show that the mortgagor is a defaulter. And for that default, 10th May and 10th May. So now he joins these two, which stands Millard at Millard 7 years apart. 19th, 2019 is the mortgage, and 2024 Millard 7 years apart, with no connection in between. And thereafter, Millard, he says, with this, I get a right to sell. Now, Millard, plain reading of the conveyance will show that he is exercising his right to sell under the mortgage deed. If it is, my lord, the mortgage deed which none of the parties have touched and which was the basis of my argument expressly says that if you want to enforce the mortgage, you will have to give him a notice in writing. That is there. So that's the reason, my lord. And even then, my lord, that notice would only apply if the mortgage deed itself provides for a right to sell without recourse to the owner. The mortgage deed here says just the opposite.
Okay.
Now, my lord, on a lot has been said, my lord, on conduct.
Conduct with regard to the interim order.
Yes, conduct has been.
Will not join them, you can't go on facts all over again. So I didn't want to interrupt. And only just one clarification on the question of mortgage.
No, he will give the reply to the conduct.
There's no affidavit.
So that has not come to the conduct. Let the conduct be explained.
But I don't think it's anyone's case, Mullah, that this right, Mullah, the sale was under the mortgage. I don't know why Mullah is
Conveyance says so.
Yes.
Conveyance doesn't, Mullah. I'm sorry, Mullah. Let me just let him, if he finishes.
That complete then.
Very well. I'll just take 1 minute.
I'll come back at 2 minutes for 10 minutes.
2 p.m. is the company matters.
Okay, Mullah.
How much time you will take?
5 minutes. Well, I know.
5 minutes.
5.
Complete.
Well, I'll complete it. Or Millard, if your lordship wants me to come back, but difficulty is Millard from tomorrow till I'm not there.
Yeah, completed. Now I have to dispose of this add-in time application.
Now, Millard, a lot has been said about Millard, my conduct on coming to court. Now, Millard, it will come back to your lordship, Millard, that on that day the matter was appearing in the list.
Correct.
And Millard, an adjournment was sought on the ground of either on them. They sought an adjournment. So, Millard, I was under an impression that since the matter was going on.
See, leave aside that. I am not on that. You mention and all these things.
But I mentioned upon notice.
No, that I am not taking on that.
Very well.
Only the question is that as per the agreement, you are in 3rd floor and 3,000 square feet of the property in question, and other has been handed over to the Marlin. Now
for development.
For development. Now you have cancelled the power of attorney and the development agreement subsequent to when you came to know about the agreements. But if you go by this power of attorney and the development agreement, so and the possession letter, so they are in possession of the property in question. So the question raised by Mr. Mukherjee is that if that's so why you have stated that the total property is in your possession?
It is even today, and I'm saying so even now, because of the reason, Millard, Mr. Mukherjee, to show his possession, is relying on the development agreement.
Development agreement plus possession.
Possession given under the development
Correct.
agreement. Kindly come to one clause in the development agreement, which clearly says. Millard, I had showed it on the very first day. Give me a moment, Millard. Page 75, page 6.5. So the possession of the developer for development was permissive, and he had a right to develop on that entire property. Now this the parties had contemplated. It is provided herein that if the situation arises anytime hereafter, parties may decide to demarcate the units areas in respect of their respective allocation on a rateable basis. In such event, the parties shall enter into a separate allocation agreement wherein the units areas and proportionate common areas appertained thereto with undivided impartible proportionate share in the premises shall be mutually allocated by and between the owner and the developer, and each party shall be entitled to sell or transfer its allocation separately in the event the owner shall forthwith refund. So, Millard, it is very clear that if Mr. Mukherjee is trying to come into possession through the developer's right, it's a joint right. No allocation agreement has yet been entered into.
Demarcation, yes.
So, therefore, Millard, it's an undivided property.
Okay.
I have come into allowed a promoter to make construction on my property.
Yes.
And Millard, that possession is only for the purpose of construction. Once it's developed, properties is sold. Here the agreement says otherwise. Now the situation has changed. Of course, Millard, Now, my lord, there are other things which I had to say about Mr. Mukherjee's client, but I think I'll put it on affidavit. All I wanted to just indicate, but I think Mr. Banerjee is here. Yes. My lord, I had shown to your lordship, my lord, please, because it's against his client. My lord, I have indicated on the very first day when I showed the conveyance that there were two attempts to sell the property. One was on 16th of March when the collector passed an order, and the other is on the ultimate day.
Correct.
Now, my lord, after moving this application, I had made an RTI. And under the RTI, I have come to know that it was the same person, Hatishala, who had that day presented the deed. So now the difficulty was, as on that date, when the deed was presented, Hatishala's
On March 2020.
on March 2020, I have got it from the 2025, Hatishala's authorized capital was only 1 lakh. And paid up was only 10,000 rupees. So these are all available on the website, Miller. So Miller, on that day when this attempt was made to purchase the property, this man was, all of a sudden in May 2025, funds started coming in galore from outside. Miller, I have stated very categorically that it's a transaction, not round trip, it's a transaction where money of defendant number 1 is being flowed, but those will be on affidavits if they disclose those documents.
Well, just one clarification. I don't think anyone's argued that it is pursuant to the mortgage realization.
Not mortgage. Mr. Banerjee, Mukherjee has argued with regard to the mortgage 13.1.
Correct.
Power of attorney and the minutes of the meeting.
Because the
is
sale
taken
is in the name of statesman. And kindly look at page 314, which my learned friend read out, paragraph G. I'm so sorry, just taking 1 minute. Paragraph G.
314.
Yes, my learned friend read G and said it is an exercise of right of mortgage.
Yes.
With great respect to I don't think he read the. It is pertinent in the middle. It is pertinent to note here that the said premises has been mortgaged to the developer. Vide registered deed of mortgage dated 26 March. The said mortgage stands released. It's the developer who's releasing the mortgage.
So otherwise, how will it sell?
But naturally, the encumbrance-free property is being given to me.
So therefore,
I can't give him 235 crores and the defendant number 1 will also retain the mortgage. Because the right is of the developer to have that mortgage. Quite naturally, he has to give it to me encumbrance-free. That's why he is releasing the mortgage. Said mortgage stand released by this present and the developer shall adjust over the sale consideration. Otherwise, it would have come encumbered with the mortgage of defendant number 1. Quite naturally, I wanted
so that's
encumbrance-free. And I have paid 235 crores. All this in argument, I have not heard.
Oh, yes. I need to deal with. My learned friend has paid 235 crores. 235 crores he's paid to whom? Merlin. Not a naya paisa has come to my coffers.
That you settled with Merlin.
Now,
that's exactly what we are on.
So
and just to finish.
At an ad interim stage, if my learned friend needs security, and if he is a bona fide purchaser for value, if he is bona fide Millard, then he will run after Merlin, his seller.
How much payment you have been received now?
Nothing.
And I don't. I'm told that's the submission I heard. If they were offered money, it's up to them. With Merlin. Merlin. Just one more thing.
That stamp duty is deducted from this. I shown that, Millard, that stamp duty is also deducted from mine.
So far as mortgage is concerned, Millard has noticed section 69(3). There also, Millard, it says if title has passed, if no notice is given, then you have a remedy against the person, Millard, who has sold it. That's 69(3). Millard, which is there.
My lord, we have shown, my lord, the amounts due from statesman to Merlin.
So,
my lord, we have shown, my lord.
My property goes.
Millard, I am not concerned with all that. If Millard, he has serious grievance against Merlin, Millard, let him go and do it.
I was surprised that Mr. Banerjee's client should have run after Merlin.
Why should I? I've got a property.
Mr. Banerjee is not concerned about the amount, concerned about the property.
Yes.
He has got that.
Yes, I've got the property and paid 235 crores for it.
He want to utilize that.
So
quite naturally, Millard.
He must get.
Millard, he is not saying that 235 crores are not being paid.
I have expressly stated that they are in a collusion with each other, and I can show it just because.
This is so wrong. One email, let me show you. One email.
It is enough to say that there are issues to be
What,
heard.
what?
One email, 7th of July.
For payment of amount?
Yes, we gave them the full accounts and said, you will ask, I'm going to transfer the money.
And there you adjust the stamp duty and
No, please let me. It's so dishonest. What is going on?
Property. Now I have adjusted everything.
Heavily
and this is
indebted property. Heavily mortgage property.
You take and go.
It annoy.
Statement.
Please come to page 308 of the petition once.
308?
I mean, dishonest. I have disclosed it. আমার application থেকে আমাকে suppression বলছিস? Well, it had shown this. Right? They have
Please
adjusted.
come. No, I'm going to show the next one.
Yes.
We are supposed to meet this is 7th July.
Correct.
We are supposed to meet in person to close pending issues, including accounts of sale proceeds pertaining to the property. However, we understand that the proposed meeting has been cancelled from your end. This is our email. As intimated by Mr. R.P. Gupta and yourself over phone yesterday, that is 6th of July. In the circumstances, we are attaching herewith scanned copy of sale deed, statement of account marked as Annexure 1 of the sale proceeds of your share, along with adjustment of amounts receivable by us on account of loans, advances, interest, and various payments made by us on your behalf from time to time on different heads. We further request you to let us know whether any further payment is required to be made on your behalf. Please share the details of your bank account so that we can make payment of your receivables by RTGS process. After all, statement as adjustment as per statement attached here too. Now, my lord, come to the next page. Total amount received from purchaser is 235 crores.
Yes.
Less.
Yes.
Stamp duty, my lord, vendors have to pay. Registration fee,
Stamp duty.
charge for legal advice.
Yes, on the 89.
Then, my lord, please, my lord, just read on. Then, my lord, extra work for anchor units. Then, less interest-free refundable deposit paid, interest-free advance, loan paid to owner and expenses on behalf of owner from time to time. Then, various payments made on behalf of owner on account of property tax, electricity consumption, shifting of owner's office, etc. Then owner's share is 52.75. Then balance share of revenue of owner, 32 crores. Now, my lord, I'll just show your lordship one document which is 10th of July. We write to them again, the 32 crores, give me bank account, I will pay you. 10th of July, we tell them, see, you've got the balance of sale proceeds, but what about, this is the letter. It's annexed to the section 9, served upon them. They are fully aware, I'll give another copy. Please refer, there are many emails leading up to this. Please refer to our communication by email dated 7th July. As per the statement submitted to you, sum of 32 crores is available as your revenue share. There are unpaid dues of 3 lenders, namely Bhattar, Zoom, and Innocent, who have given interest-bearing loans to you, having been introduced by us. Please note it is our responsibility to ensure that their loan together with agreed interest is paid back, and we are sure that you would agree. We are submitting a statement of amounts payable to these entities. That's not 7, 10, and 1.5. You are reminded that in the agreement dated 20th July 2019 between Statesman, Merlin, and Zoom, you had agreed that in the event of default being committed by the owner. So, my lord, may I just have 1 more minute?
Yes.
My lord, this Statesman starts the transaction with, my lord, the property mortgage to SBI. He takes 30 crores from me to free the property, and he mortgages the property with me. Then during the continuance of the transaction, I am to, my lord, develop the property. He doesn't have to spend 1 rupee. My lord, during the continuance, I put in over 200 crores, develop the property. But in the meantime, to protect the property so that, my lord, others don't come and create trouble,
I have to get him loans. 30 I give him myself, and 20 I give him myself, 30 I arrange for him. 50 crores I give him to pay off his creditors. That is also not enough. So I put in 200 crores. I put in 50 crores to protect the property, paying off his debt. Now, my lord, one more minute.
Okay.
1 minute. Just 1 minute.
So far as section
After that, when he says summary of the
You disclose all the things in the affidavit. Let me decide that.
Your lordship,
just one. No, just by the clock,
Yes, yes,
60 seconds.
can-
After that, he tells me that I'll buy it for 130 crore, 160 crores. Otherwise, you sell it and we'll pay off, etc. Then, my lord, we sell off as per his instructions. After we tell him these are the letters, and he waits. When people come, pounce. I am facing 40 legal proceedings today.
Okay.
Millard, only one thing.
And he has only
I need to understand that in the absence of any agreement to the contract,
mortgage section
the
69.
existence of providing
Section?
29, that we have to stamp back.
the providing proper stamp duty shall be borne in case of a schedule 1, which is conveyance by the person drawing or making or executing the instrument. Kindly see, in case of conveyance, including reconveyance and mortgage property by the grantee. Grantee is the purchaser, not the grantor, which is Merlin.
1500.
Okay. Hearing concluded. Fix for orders.
Great. Sorry, Malad.
And sorry for the 1
We are
minute.
all sorry, Millard.
I have a very faulty claim, my lord, against the official liquidator.
This CP has been transferred. So what order will be passed here without the file?
From what the department is saying, my lord, the file is still lying with the
Any order process is there?
transfer order.
So it has been transferred. It can't be done here. That's why I told you, let me.
Yeah, I was telling him only that.
Yes.
This Millard, my lord, recollect Millard, Mr. Bose has already Millard said that he is willing to not to.
Yes, no, only with
Now,
regard to
only
the
because of the interim order,
interim
Millard, what
order,
I
that's
say.
why I kept.
Yes, kindly text Millard volume 5, page 617.
Of the convenient compilation.
Yeah.
My lord, I am on my way, my lord. I will reach.
Yes, no problem.
Sure, sure.
Attendance.
Page
617.
Yes.
Kindly see Millard, the last paragraph lists this appeal for hearing on 25th April 2017. If the official liquidator proposes to disburse any further sum to Atanu Datto, the response number 2, he will give 72 hours notice. So this was the interim order first. Now, Millard, they had Millard kindly marks the Millard CA number at the top. This CA. Now, Millard, human error, Millard can take it. Millard,
what is CA number? 157.
157.
Yes.
Now, Millard, the OL forgot to give notice, disburse the money. Now, Millard kindly takes Millard volume 9 take to the volume 9, page 1217. Volume 9 লাগবে না 1217.
Yes.
Now, Millard kindly takes this was the allegation by them. Millard kindly see CA 157 at the top. Now, Millard kindly takes Millard first page last paragraph where Millard the last in italics Millard the 6th April order is Millard quoted. Then Mr. Atanu Datto is represented through advocate and was also present on the day on the order that such and such were passed. Admittedly, the order dated 6th April 2017 was not brought to the attention of this court either by Ms. Datto or Mrs. Demila, the learned counsel appearing. Prima facie, there has been gross fraud, suppression, which has been perpetrated in surreptitiously obtaining the orders. Accordingly, I direct that no further steps to be taken in terms of such and such order. The parties are directed to forthwith refund and repay. So, Millard, we have refunded the money which was disbursed.
Who has refunded?
My client, yes. Atanu. Atanu had refunded along with all the parties.
Correct.
Now, Millard, kindly see, Millard, thereafter, kindly takes 1224 of the same volume.
Yes.
Subsequent order. I had refunded, I have shown the letter to your lordship, Millard, on the next day only. Millard, immediately I have refunded. Millard, kindly takes 1225. It is submitted by OL that entirely the amount of rupees 4 crore, that is my joint account, Millard, joint amount, Millard, which has been disbursed pursuant to the order dated such and has been returned to the party, returned by the parties. By an order dated 16 February, this court had inter alia directed the OL to convene a meeting of all the parties present in the court to see whether the disputes could be resolved and the remaining property of the such and such, and not on that. Kindly takes me thereafter. This application has been filed by Arundhati Datto relying on an order of 6th April 2017, then Millard quoted. It is submitted by Mr. Atanu Datto that the order is 6th April was inadvertently and accidentally not brought to the attention of the court at the time of passing of the order of 16 February. Such and such, such and such. Advocate appearing on behalf of the Atanu Datto submitted this is a human error. On behalf of the liquidator, learned counsel had tendered her unqualified apology, has submitted that there has been a mistake on her part in not bringing the order dated 6th April to the attention of the court, even though she had represented. Both parties unequivocally submit that the order dated 6th April 20 ought to have been brought to the notice. In view of the unconditional apology, Millard, the court Millard had forgiven us. Now, Millard, in view of the subsequent fact that the monies have been returned to the OL and are lying with the official liquidator, and in view of the order dated 6th April directing that before any further amount be disbursed to Atanu Datta, appropriate notice of 72 hours be given to the applicant. OL is directed to forthwith make payment to the following parties. Now, kindly see, my name is not there. Insofar as 14B, Amritlal Bose Street, Kolkata is concerned, the parties are ad idem that for the benefit of all the parties, the property be sold without prejudice to the rights and contention of both Atanu as well as Arundhati. Now, Arundhati has stopped appearing before your lordship. Only Milad Atanu Milad.
Arundhati.
Arundhati,
Arundhati is only appearing.
Acha. The OL is directed to give full particulars of the such and such. Now, Milad, my amount has been withheld back. This has to return back to me. Proceeding is not dismissed. Section 144 of CPC. Institution. This CA has been dismissed now. Milad, this interim order of 6th April has to be vacated, number one. Now, Milad, the amount 1 crore 33 lakhs and odd, which I had refunded back.
Okay. Yes.
That has to be refunded back to me.
First and
But
foremost, my learned friend.
Milad, I have judgments and Milad 144.
Yes, but
my learned friend, I understand this order. My learned friend has also shown, but my lord would kindly take the last order that my learned friend has shown at page 1225. This order has been passed in CA number 25 of 2023. So unless and until my learned friend takes out a proper application seeking recall of this order.
No, I am not recalling any order. I am dismissing your application 157 with the observation interim order, if any pass in this application is
correct.
That's all. Nothing else.
Absolutely.
All this aspect.
My lord,
correct.
No.
And, my lord, may I just indicate one thing, my lord? That, my lord, that liberty, if your lordship recollects, my lord, I have sought for the liberty, my lord, to take out an appropriate application before the testamentary court seeking revocation of the grant. Because your lordship was of the view that the company court is not the appropriate court having jurisdiction.
I am of the view that, however, the dismissal of the present application will not prevent the applicants to take appropriate step before the
manner is provided.
Obliged.
I have given that.
Obliged.
With regard to this
My
portion,
lord,
I have kept it. So now I will pass that if though this application is dismissed, so interim order, if any, in connection with this application is hereby
Stands
Milad,
stands
one
vacated.
rider, subject
Stands
to correction, Milad. This order was passed on 6th April 2017.
Correct. That's
If 20, may I, kindly, Milad. If 2017 CA is not there, how can my money, may I put the question to myself? How can I be prejudiced and my money can be withheld by, under which proceeding they will withhold back?
You right to
No, because this was a commission of fraud.
My lord knows, my lord had been in this side of the part.
That's I'm telling. The court has passed an order. Court has passed an order to OL to release the amount on with the condition 72 hours notice. That's all. So if you give the notice to the OL, comply with the order, 72 hours notice will be given.
No, 72 hour notice goes.
No,
because that's 6th April order. Of course. Kindly see 617. That's passed in that proceeding where my lord had now dismissed it. So that order goes. Anyway.
So that's why I'm telling, if any order passed in this application is hereby stand vacated.
Right. Absolutely.
Correct.
No difficulty on that.
Then-
We are all at item.
then-
Now, this order of 1224 page is solely passed on that 6th April order. That it has not
Correct.
been for like a contempt.
Correct. 22 old CS 157.
Absolutely.
Correct.
Now, if that order is not, my lord, clarify to the extent, my lord, my money has to return back to me.
If the stay is vacated, you write to the liquidator, they will release that.
I
They will
hope
not
that they are,
release
they are hearing this.
Yes, my lord. I have
Yes.
no objection.
Very well. Very well. No difficulty.
My lord, kindly appreciate one thing, my lord. They accepted the order and refunded the money back.
Correct.
Now, my lord, the question is that there is no, where is the question of any interim order now? Now, technically, there is no interim order now. If
this court is
correct.
not mandatory directing the stay is vacated.
Absolutely. Basically, what my learned friend wants is that
This will
he wants
create
an order on my application.
But also, my lord knows how Millard OL office works. They will not, Millard, now Millard, they will.
No, we also know how it works.
Millard-
My lord knows, we know, we all know how it works.
1224 consists of several CAs.
Yes, but Millard, kindly see the quoted portion. Kindly see 1225 last paragraph.
Correct.
This is only solely 6th April. That's all. Nothing more. We forgot.
Both the parties unequally submitted the order dated 6th April out to have been
Yes.
brought to the notice of
It was
this
not
court.
brought like a punishment. It was imposed on us.
Correct.
Now 6th April goes. Now Millard, the money should come back to us. My lord, provide that. whatever relief he will take from the testamentary court.
ये ऑर्डर हो गया, इसके बाद यहाँ तक का ठीक है, ठीक है। इसी को फेयर कर दो। I have recorded that.
No, my lord,
यहाँ दो। I have recorded Learned Counsel for the Atanudatta draws the attention of this court to the order dated 24th April 2023, by which this court directed the parties to forthwith refund or repay the official liquidator any sum received pursuant to the order dated 15 March 2023.
Right.
In terms of the said order, parties have returned the amount. By a subsequent order, 3rd May 20, this court directed the official liquidator before any further amount is disbursed to Atanudatta, appropriate notice of 72 hours be issued to the applicant. Correct. It is submitted that the official liquidator has disbursed the amount to all the parties except the Atanudatta, and no notice of 72 hours is issued by the official liquidator.
Right.
As this court has dismissed the application filed by the applicant on the ground of jurisdiction, any order of injunction passed in the instant application is hereby vacated. I recorded that. Further, what can be done?
one line, Milad.
What?
Money has to refund back. If they're hearing this, I have no
Why?
difficulty.
Why?
I don't want to come back to your
Yes,
lordship time.
official liquidator.
কি বলছে শুনুন।
Why you are keeping silent all this thing, 2013, and you kept, why 72 hours notice has not been issued?
The notice has given by the respondent number 2, not by the OL, lordship.
OL has to issue. What is the order? 72 hours notice is to be issued by the OL. You have to disburse the notice. Yes, call the other man.
Milad, only one rider, Milad.
My lord has already
one
passed
rider.
a-
Yes, only one rider, Milad. If they are hearing, Milad, I have no difficulty. I'll write to them.
They are there. You write, otherwise
Very
the
well.
court is here.
Very
Yes.
I'm so grateful.
Call them.
Well, he is never so soft anywhere. Well,
Yes.
this matter, your lordship will recall, this was my application for offering the higher bid. The only thing was that the sale was not confirmed. At the stage of confirmation, I have come up before your lordship saying that I am paying an higher offer, my lord. And I had cited, my lord, 2 judgments, my lord, which clearly says that the highest bidder in an auction has no vested right.
Correct.
So
That's
that
why I
was-
given the chance to. I have
Yes.
considered the judgment.
I'm led by Mr. Munna. Yes, my lord.
Yes, Mr. Boss.
My lord, my lord, my learned friend had relied upon 2 judgments.
Correct.
One is Laika 1, one is Laika 2.
Correct.
My lord, kindly first take the judgment. My lord, which is 2000 volume 6 Supreme Court cases, page 79. My lord, effectively what my learned friend is saying is that my lord, kindly see the basic facts.
ये दूसरा
A-
और एक जजमेंट होगा ना?
But may I file the affidavit of service, but I have served the notice to the secured creditor.
Yes.
My lord, one is 2000 volume 6 page 79 and the other is 69. My lord, first take 79.
Yes.
My lord, before your lordship takes 79, certain basic fact. My lord, this is a company in liquidation. My lord, the assets of the company in liquidation is being sold. My lord, publication has been made by the official liquidator pursuant to orders of court. My lord, it is nobody's case, or at least not the case of the applicant, that there has not been adequate publication. So, my lord, the issue of inadequate publication is not a ground for, my lord, participation in the sale after the auction is over, number one. Number two, well, it is also not his case that the property is being sold at an undervalue, or that the sale value which has been offered by the bidder which has been considered to be the highest as of now, which is my client, it is an inadequate price. And this is not the market price. So none of these two grounds are available, which are grounds available in an auction proceeding for the purpose of interference with the auction proceeding to get a higher bid. Apropos this, kindly have a look at this judgment. This your lordship will find kindly take paragraph 2. This was the winding up proceeding of a company from India Electric Works Limited.
Yes.
Well, here your lordship will find there was a bid of 37 lakhs. And subsequently a higher offer came. Kindly take towards the bottom of the first page where the sentence starts with the division bench. By the impugned judgment dated 15th of September 1992, set aside the order of the company judge and directed to confirm the sale to Shantilal Malik at 37 lakh, as against which the present appeal has been filed. So, 37 lakh, there was a higher offer of 38, 37 was taken. Appeal court said that 37 should be the correct offer.
Yes.
When the appellant offered 45 lakh, this court directed the appellant to deposit the sum, taking into account. Then, my lord, kindly come to the next page, paragraph 3. Division bench set aside the order on the ground that after acceptance of the offer by the company judge, the sale should have been treated as closed, and it would not have been proper for the court to consider any other offer under subsequent date, even if such subsequent offer was higher. The earlier offer already accepted by the court would not be rejected upon some higher offer being made later. If this course is accepted, then there will be no finality in any matter, and in such event, every now and then the offer already accepted may be upset by being rejected in view of higher offer. Now, my lord, kindly see what the next paragraph. If an offer is accepted, then such offers cannot be later on rejected unless there is some strong grounds, namely that the price offer is inadequate or that some action of fraud is involved. In the present case before us, none of such elements were involved. Then, my lord, kindly make a note at paragraph 4, the judgment in Naulakha has been relied upon. My lord, Naulakha is the judgment of 1969, 3 SCC, page 537, which I shall be relying upon.
Yes.
My lord, coming back to this judgment, my lord, your lordship will find Naulakha has been quoted. My lord, kindly take the Naulakha part of the quoted portion of the part which has been referred in paragraph 4. It says in Naulakha, this court held that the court is the custodian of the interests of the company and its creditors, and the sanction of the court required by the Companies Act has to be exercised with judicial discretion, regard being had to the interest of the company and its creditor as well. Where the acceptance of the offer by the commissioner is subject to confirmation of the court, the offerer does not, by mere acceptance, get any vested right in the property so that he get automatic confirmation of the offer. The condition of confirmation by the court operates as a safeguard against the property. Then, in every case, it is the duty of the court to satisfy itself that having regard to the market value of the property, the price offered is reasonable. Unless the court is satisfied about the adequacy of the price, the act of confirmation of sale would not be proper exercise of judicial discretion. In that case, there are some more paragraphs of Naulakha which I wish to rely upon. But so far as this judgment that they have relied upon, now, my lord, kindly come to paragraph.
Yes, yes.
The purpose of an open auction is to get the most remunerative price. And it is the duty of the court to keep openness of the auction so that the intending bidders would be free to participate and offer higher value. If that path is cut down or closed, the possibility of fraud or to secure adequate price or underbidding would loom large. The court would therefore have to exercise its discretion wisely and with circumspection, and keeping in view the facts and circumstances of each case. My lord, pausing here for a moment, my lord. What is the case before your lordship? Somebody comes and says that I missed. This is that in substance, their case is that they were unable to participate because they missed the advertisement which was published. So today they come and say that, my lord, I am an offerer, I want to give a higher bid. They don't say that there is any irregularity in the auction process.
Yes.
The irregularity in valuation, irregularity in the inadequacy of price, nothing.
Yes.
Somebody just comes and says that I want to give a higher offer. Well, kindly consider a situation that today there is an offer, tomorrow there might be some other offer. So this situation will continue. So because somebody.
But Mr. Bose, come to the further paragraph. Therefore, mere acceptance of the offer of Mr. So does not constitute any finality of the auction. So what you are telling, if suppose today I accept Mr. Sen's client, that will be the finality. So after the finality, nobody can come. Here, whether it has been finalized or not. Mayor's acceptance and the official liquidator has submitted the report before this court as per the offer given by the tenderer for acceptance. It has not yet been accepted. In the meantime, the other party has come. So without acceptance, can it say that it has been confirmed?
So, well, the
connection is not good.
Mr. Bose, I think BSNL or MTNL, whatever it may be, not allowing you to say.
Because they don't want him to say something wrong. Providence.
Court can say that I do not, or I don't consider the same.
No, there is some disturbance. There is a disturbance. We cannot hear you.
I will prefer a short pass over. We'll reach within half an hour.
Then we have to come back at 4 o'clock if it permits. Otherwise, I was suggesting, but a short note we can give both of us.
No, you are already argued only. You give the short.
Well, I am just about 10 minutes away from the court. Well, can I get 10 minutes? Well,
okay, I am passing out to her if time permits.
I'll just be on.
Okay, I will see.
Your Honor.
Yeah.
4 p.m. if your lordship keeps on at both of
because 3 p.m. another matter is fixed. If it is concluded, then I will take. But let me see what would be the situation.
Lord, regarding this matter, I am the intervener. I am the valuer in this case. So I am not getting my fees right from the year to 2015. I am the faggot of my life. How will get it?
Yes, why you are not paid? Report then. Report the.
Company has no fund.
It's a report then. अरे लास्ट डेट में रिपोर्ट जमा किया था ना लास्ट से पहले 10 वाला.
I have got the report. I can get it.
Got the report.
Company has no funds.
Huh?
Company has no funds.
From establishment, they can get it.
Okay, you waited so many years. Please wait for some time.
I'm the faggot of life.
That's why now you have brought to the notice of this court. Let this matter be decided. Once it has been accepted, I will pass an order for release of the amount. That can assure. You have brought to the notice of this court. Let me see. First, the issue, because they are telling that the no amount. If this amount will come automatically, the amount will be there. Then I will pass a.
You try to understand. You just see from 2015 dragging it to 2025.
I will take note of it. I will take note of it, and I will pass up. देख लीजिए इनका क्या है.
Same. It will appear with minute 5.
Same. 7.
Number 7.
My lord, item 7, my lord, I received a call from Mr. Shomabho Ghosh in the morning. He was making submission that he will ask for adjournment.
Yes, Lordship. Mr. Shomabho Ghosh is appearing on behalf of Income Tax Department, Telangana, and he is.
Yes. Morning he has mentioned.
Yes, Lordship. Yes,
so
Lordship.
Not today.
If this matter can retain the same position.
Not today only. Not today.
Well, let this matter keep
Lordship,
its
one small
place in the list.
Yes, it will be released on next Wednesday.
Lordship, one small indulgence. If this can be fixed in the Wednesday week, not next week, Wednesday.
That will be a bit difficulty because we have a claim it's pending for quite some time, my lord.
Today we are on. Okay.
The liquidator has given a declaration that I will be entitled to preferential payment. Now, state tax officers come and they have claimed a preferential.
Claiming that, yes.
But that's the only limited scope, my lord, which is to be
Why? 11th, why?
Lordship, Mr. Ghosh will be out of station.
As per the prayer made by the council for the. You are appearing for whom? Commercial tax department.
For income tax department, Telangana.
Income tax commercial.
ठीक है Learned Counsel appearing on behalf of Mr. Shambhava Ghosh, Learned Counsel for the Commercial Tax Department, Telangana, prays for fixing the matter on 18th of September 17th of September 2025. Let the matter appear on 17th September under the same heading. 17th September. Yes, next. 8 also same.
Lordship, the same.
Same. 7, 8, same. 9.
Madam, my lord. Lordship, this is my application for dispersal of the sum, Lordship.
I am for the official liquidator.
Lordship,
Why? My lord, please to pass the order. Disbursement. My lord asks. By the number of the my lord FDS. Number of the FDS is required. Last question.
Number of
FDR, fixed deposit. My lord.
File
the fresh report. So prepare the fresh report for your lordship.
You are appearing for whom?
Official liquidator.
Lordship, directed to file them with the particulars of the fixed deposit, so that the amount can be.
This is up to date.
Yes, sir.
This is up to date.
Up to date.
SBI, Canara, PNB, all banks. PNB. 1 crore 68 lakh 35,700.
99 lakhs to
yes, sir.
Lordship, my claim is adjudicated, Lordship, 4 crores 25 lakhs. Lordship, my application page number 8, Lordship. Lordship, I'm praying for the dispersal of the amount.
Give the application.
Official liquidator have now in its coffer, Lordship.
Where is your adjudication?
Lordship, page 8 of my application. Letter dated 6th August 2019.
Inform the security. After scrutiny of the affidavit of proof, claim against the above company 4 crore 25 lakh 19,091. Why you are passing such? Why you are not giving the total details? Claim of 4 crore of 3 lines you adjudicated.
This is in respect of the goods sold and delivered, Lordship.
So you have to give the details.
That too.
Otherwise, you will be in trouble in future, sir. 4 crore 3 line is entitled for that. Where is
that amount has been admitted by us.
Admitted, but you have to give the total. This is the total. This was the claim, and
they came before the official liquidator office, and one document has been placed. In terms of the document, we admitted some and not admitted. Notice has been issued. If dissatisfied,
so you have to give the details. Where is the details?
Yes, I pass.
Only 4-line order you have passed, approved, admitted and allowed.
Lordship, our entire winding of application has been raised with all the invoices. They have considered it, and then this has been.
You do one thing. I file a supplementary report giving the total details of the admitted claim. What is the total claim? What is the admitted? What cannot be admitted? Give the total.
Admitted, I have given notice.
Lordship, this is all the admitted claim.
That's why, but there is no details.
21 days they have to file.
Tomorrow, further inquiry will be done. Who will be responsible for this?
Lordship, I pay some dispersal to be made, Lordship.
They have claim in dollar.
Correct. Whatever the dollar, but you have come to the conclusion 4 crore 25 is admitted. 4 crore 25, on what basis?
Also on the basis of the winding up.
And if the court is accepted this, tomorrow it will be finger upon the court. File a supplementary affidavit giving the total details how this amount is admitted. Then only I will pass a appropriate order.
This
report has been filed.
The applicant. You are the applicant.
Lordship, I'm replying.
The applicant has filed the present application
For disbursement.
for disbursement of the admitted claim of the applicant. The applicant has draw the attention of this court to the notice of admission of proof of debt issued by the Deputy Official Collector of this court dated 6th August 2019, wherein it is mentioned that, inward comma, you are hereby informed that after scrutiny of affidavit of proof of claim against the above named company, a sum of rupees 4,25,19,019 has been admitted / allowed as ordinary claim. Full stop. Now the official liquidator has submitted the report disclosing the details of the fixed deposits, total amounting to rupees
1,68,00,000,
1,68,35,700. The applicant prays for disbursement of the admitted claim in terms of the notice issued by the Deputy Official Liquidator dated 6th August 2019. So, this court failed to appreciate. This court found that though the Deputy Official Liquidator has admitted the claim of rupees 4,25,19,091, but he has not given the details how this claim is admitted. Accordingly, the official liquidator is directed to file a supplementary report disclosing the details of the admitted claim of the applicant within a period of 2 weeks. 2 weeks. Within a period of 2 weeks, let the matter appear on 17th September 2020.
One more indulgence.
24th September.
17th September.
Lordship, 17th.
17th September we will do.
Lord.
Yes.
17th September.
One more indulgence, my lord. My lord, direction was given to file an affidavit in respect of the affidavit filed by the bank. My lord, ready, but some error is here.
The counsel for the official liquidator prays for extension of time to file affidavit in respect of the
opposition affidavit filed by the bank. CA 26 of 2024 filed by the
prays for
bank.
extension of time to file affidavit in opposition in respect of the affidavit filed by the bank.
With me ready
Time to file the affidavit in opposition is extended for a further period of 1 week. 1 week.
Matter
Let the matter appear on 17th.
Lordship, I am also praying for 1 week time to file my opposition in their application.
1 week. Reply if any. Which? What?
In their application, Lordship, regarding the claim of 1 crore, Lordship.
The counsel for the applicant also prays for time to file affidavit in opposition to the affidavit filed by the bank. Let affidavit in opposition file within 1 week. Reply if any there to file 1 week thereafter. This is the matter on 17th.
Great.
Yes.
Item number 10 is our application. This is an application, Your Lordship. The official liquidator is seeking for disbursement of ex-gratia payment to the paid staffs as well as to the sweeper, Your Lordship. In the summons for direction, it has been stated. Similarly, Your Lordship, earlier also by dint of the direction of the Honorable Court, Your Lordship, the direction was passed and the amount was paid. So that is the reason, Your Lordship, this application has also been placed before Your Lordship, seeking for the payment of ex-gratia. 20,000, Your Lordship, for the paid staff and 19,000, Your Lordship, for the casual sweeper.
What is the how the ex-gratia you have calculated?
Lordship, this is Lordship, my instruction is on ad hoc basis. Because, Your Lordship, earlier also what we have done, we have relied upon some of the direction of the Honorable Court in our application, wherein my Lord has been pleased to direct to disburse the ex-gratia.
Should be a puja advance.
Lordship.
Ex-gratia, then it will be a legal
Lordship,
right.
I can understand, but it has been drafted.
Should be a For the festival advance, you can give it, but the ex gratia, then it will be create right. In
It's a
future, you will
bonus,
be in
it's like a
trouble.
bonus. Lordship, I
Festival advance
understand.
as a bonus.
I
for the-
understand, but it has
for
been
the
drafted in that manner. So, Your Lordship, earlier also it was drafted in that fashion only because the orders that has been annexed, there also the same word has been indicated. If my lord please to peruse page 30 of the application, similar observation passed on 12th September 2024. Since 1991, Your Lordship, this practice is being adopted.
$20,000 each.
20,000 each.
How many work how many regular paid company paid staff?
53.
So you are having the remuneration. You have the fund. How you manage for that fund? The official liquidator has filed. Who has filed this?
Lordship for the official liquidator. This application at the behest of the official liquidator.
The official liquidator has filed the present application, praying for a direction. Praying for a direction for direction to allow the official liquidator to pay ex gratia to the regular company paid staff who have completed a period of service not less than 1 year as on August 2025. August 2025. Full stop. It is fine from the record that on the earlier occasion also, the official liquidator has filed an application for payment of ex gratia amount to the company paid staffs, particularly on the festive occasions. Full stop. Taking into consideration of the upcoming Durga Puja festival, the official liquidator has filed the present application with the prayer to leave, with the prayer for a direction to allow the official liquidator to pay the ex gratia amount, consolidated ex gratia amount of rupees 20,000 each to the company paid staff. Considering the above, CA number
94
is allowed by giving liberty to the official liquidator to pay ex gratia to the regular company paid staffs of the company within bracket in liquidation who completed a period of service not less than 1 year as on August 2025, a consolidated sum of rupees 20,000 to each and proportionate amount there shall be paid to those who rendered service not less than 1 year on account of retirement or death, on occasion of Durga Puja Festival 2025 from the official liquidator's establishment charges account for the year 2025. The official liquidator shall also make ex gratia payment to the single casual sweeper. Still there. Single casual sweeper of the company in liquidation equivalent to 1 month's consolidated charges to the tune of rupees 20,000.
19,000.
Also from the official liquidator's establishment charges account, on account of the Durga Puja festival of 2025. CA numbers mentioned disposed of.
Much obliged.
Your Lordship, I am appearing for the applicant in item number 11. Your Lordship, by an order dated 30th of July 2025, Your Lordship had directed the respondent number 1, 3 and 4 to submit their affidavit in the course of the day, Your Lordship, affidavit in opposition. Your Lordship, they served the copy of the affidavit in opposition that day itself, Your Lordship, without any annexures. Thereafter, by several letter and emails, we have written to them to serve a copy of the annexures so that we can file our affidavit in reply, Your Lordship. There has been no reply, there has been no annexures, Your Lordship. They are trying to unnecessarily delay the proceedings.
Who is appearing? 1, 3, and 4.
Lordship, in this matter,
I am not rating that affidavit. I will dispose of. Yes, you are not giving the.
Lordship, I am for the.
I have submitted to this one. But since the client is a mobile base and they have no price for it. So the affidavit in opposition came to here. My lord, the annexure was not notarized. That's why for a court, the affidavit in opposition will serve in a course of the day. And as soon as the notarized copy will come to us, we will serve to them, my lord. The notarized copy have came to the late, my lord. That's why we are not able to serve the annexure. And most of the annexure are the part of the petition which they have filed, my lord.
Your Lordship, no such.
One or two new document, my lord. Otherwise, there is no new document on which I am relying. Most of the document are which they have already filed and which is the annex with the petition, my lord.
Your Lordship, he himself has submitted. There are 2 more documents.
We are filing, my lord, today affidavit in opposition. And my lord, sir, we are serving the whatever we have received, my lord, by today, I am giving to them.
Lordship, I am for the official liquidator. I am filing a report, Lordship.
Lordship, I appear on behalf of respondent number 2. By the last order, I was directed to file my opposition within a week. However, there was a slight delay. I have served the copy, Your Lordship. I may.
Your Lordship, we have received. In case Your Lordship allows their affidavit in opposition, we will file a reply to all of them within a week, Your Lordship.
No, I have reference number 5, my lord. I have already filed my affidavit.
Already filed.
Your Lord.
In the department. Counsel for the petitioner submit that though in terms of the order dated 30th July 2025, the respondents number 1, 3, and 4 have supplied the copy of the affidavit in opposition, but have not supplied the annexure thereto, in spite of the request made by the learned advocate on record of the applicant to the respondent number 1, 2, and 4, 1, 3, and 4. Counsel for the respondent number 1, 3, and 4 submit that the head office of the respondent number 1, 3, and 4 is at Bombay, and they were not having the annexes, notarized annexes, and as such, they were not able to furnish the annexes to the learned advocate for the applicant. He submits that his affidavit in opposition ready along with the annexes and is filed in the court today. Let the same be kept with the record. Full stop. The said affidavit along with the annexer served.
No, Your Lordship.
Served. Is also served to the learned counsel for the applicant. Full stop. Learned counsel for the respondent number 2 submit that she has also filed the affidavit in opposition after serving the copy to the learned counsel for the applicant.
All 3.
The counsel for the official liquidator has filed the report. Let the same be kept with the record. Counsel for the petitioner applicant wait for time to file affidavit in reply to the affidavit in opposition filed by the respondent number 1, 3, 4 as well as the respondent number 2. Let affidavit in reply be filed by
Lordship, by next week. Your Lordship may keep the matter in the next week. Your Lordship.
By 1 week. Let the matter appear on 17.
Lordship kindly fixes it next week.
Why?
10th, Your Lordship. Lordship, it's a very urgent matter. Your Lordship, one more request, Your Lordship. It be kept higher on the board, Your Lordship. Kindly, Your Lordship. Lordship, kindly. Your Lordship, this
counsel for the respondent number 3, 1, 3, and 4 is given liberty to file Vakalatnama by tomorrow in the department.
Your Lord,
Vakalatnama along with the competency, affidavit of competency in the department by tomorrow.
Your Lordship, this matter has been appearing.
It will remain in the list, man. No problem.
Grateful, Your Lordship.
Yes.
Your Lordship, in item number 12.
Yes.
Yes, Your Lordship, I'm in item number 12. I'm appearing for the ROC. Your Lordship, on the last occasion, I got to know the queries of Your Lordship. Lordship, I want to show my from my affidavit in opposition, page 37. That is the report of the inquiry officer, Your Lordship. Lordship, my instructions are that I cannot go beyond that, Your Lordship, the report which is given by the inquiry officer, and the same has been annexed to my affidavit in opposition, Your Lordship.
Page number?
Your Lordship, page number 37, Your Lordship. It starts from page 31 and the relevant page is from 37, Your Lordship.
Yes, my lord. In fact, I was also showing that chart. Very helpful.
No,
On that basis only, my lord, we should get
affidavit in opposition of whom?
Your Lordship, Shyam MCO of the ROC, Your Lordship. In the matter of Shyam MCO. First is Shyam MCO.
Affirmed by whom?
Yes, Your Lordship, the ROC, Your Lordship.
What is the
Aprojit Borua.
Aprojit Barua?
Yes, Your Lordship.
Page number 37.
Yes, Your Lordship. Page 37, Your Lordship. This is the report of the inquiry officer, Your Lordship. My instructions are that I cannot, Your Lordship, go beyond this, Your Lordship.
Well, that's good enough, my lord, to have me. My lord, kindly look at, my lord, what they complain of, and my lord, we have given the reply to that.
And Lordship, the conclusion of the inquiry officer is in the third. Yes, Your Lordship, that is also there. The inquiry officer's conclusion is there.
My lord, make a note, my lord, there are no shareholders, my lord, who have come and, my lord, complained with regard to, my lord, this.
On exam.
These kind of, my lord, they're far serious offenses, my lord, to pick up, and, my lord,
but also to transparent and provide additional disclosure to the users of it. Is
I've given the total figure. This I have not given the breakdown. Then, my lord, I've explained.
Your Lordship, by Learned Junior is also carrying the Schedule 3, Your Lordship. We can hand over the same also, Your Lordship. From there also I can show these queries, Your Lordship, which the inquiry officer has raised in the conclusion, Your Lordship.
Yes, you got the report.
Yes, my lord, it is no.
This report you got there?
Yes, page 37, my lord. It's
what is your contents?
Yes, my lord, kindly look at, my lord. My lord, first, my lord, kindly look at, my lord, the section itself, 463.
Yes.
My lord, kindly look at, my lord, 463 is power. Actually, company at 2030. This is good. If any proceedings for
yes,
negligence, default, breach of duty, misfeasance, breach of trust against an officer or company, it appears the court hearing case that he is may or be liable in respect of the negligence, default, breach of duty, misfeasance, or breach of trust, but that he has acted honestly and reasonably, and having regard to all the circumstances of the case, including those connected with his appointment, ought failure to be excused. The court may relieve him either wholly or in party from his liability, such terms as it may think fit. Then, my lord, kindly see 2, where any such officer is reason to apprehend that any proceeding will or might be brought against him in respect of any negligence, default, breach of duty, misfeasance, or breach of trust, he may apply to the High Court for relief. And the High Court on such application shall have the same powers to relieve him as it would have had it been a court before which a proceeding against that officer for negligence, default, breach of duty, misfeasance, or breach of trust had been brought under subsection 1. Then required the registration and such. Then, my lord, kindly look at. So this is, my lord, the section which, my lord, permits, and my lord, I'll show, my lord, some reported decisions, permits, my lord, from, my lord, the company and the directors to be relieved of any liability, my lord, if it is, my lord, found that he's acted reasonably and honestly. Now, my lord, the defects which, or my lord, the breaches which they complain of are, my lord, nothing, my lord, serious. They all, my lord, relating to, my lord, the accounts where, my lord, no shareholder, my lord, has complained. So 2 issues, my lord. First, my lord, this started, my lord, in 2021. And there is also question of limitation, which, my lord, some cases have also considered. The first one, my lord, relates to my lord balance sheet, my lord, will find or my lord 2019-2020. First notice, my lord, according to them, first my lord, notice came, my lord, in 2021. Then, my lord, the summons, my lord, was in 2023.
Where from here?
That, my lord, will find in the petition. Where are the judgments and where is Vishnu? Acha. Lord, kindly come to, my lord, the petition. First is, my lord, page 49. Asking, my lord, for all this information, which, my lord, be provided, my lord, in page 55.
49?
Yes, my lord, 49, my lord, of CP1. It should be, my lord,
48, then I think there is some pagination.
49, my lord, sorry, my lord, 49 not there.
49, 50 is missing here.
Missing?
Oh, just come later. First,
subsequently, my lord, given.
48, then 52, then 51, then 49. Okay, whatever it is.
So I'm so we'll not just have, my lord, a fresh copy, my lord. So 49, my lord, is where, my lord, they started, my lord, by calling for information.
Yes, calling for information.
Yes. And then, my lord, this is given, my lord, in 55.
Second is this is of March 21.
Yes.
Then
my lord,
given the reply.
Yes, my lord, reply, my lord, is there 16th August 2021. All information given to them.
March you received and you given them in August.
Yes.
Yeah.
And then, my lord, page 63.
Yes.
Is, my lord, the summons. This is, my lord, in 21st March 2023. So after 2021, nothing.
2 years slip. What is the punishment under this?
My lord, I have not checked that, my lord. I can, my lord.
Because if it is 2021, 2023, and that is 21.
Yes.
Is punishment the limitation?
Yes, limitation, my lord, will also come in. And, my lord, some of the cases have also considered limitation, and, my lord, said that in any event it is barred by limitation, therefore one has to be
the cognizance. That's why
I'm I will just check that.
Term of the punishment is to be seen.
Yes, my lord, there's imprisonment, not imprisonment, my lord, penalty and imprisonment depend on that, my lord. I'll just, my lord, check that, and, my lord, then, my lord, the next, I'm going to chart code, my lord, is 140. 3 is, my lord, my reply
of the summon
to, my lord, of the summons. My lord, that's at my lord, 139, my lord, is their order.
March.
And, my lord, this is what they complain of. This is, my lord, the main what we are concerned with. 139 at the bottom, my lord, will find contravention of section 129(1), read with schedule 3, division 2.
129.
139.
Yes.
Their complaint is long-term borrowings amounting to 11 crore 69 under the head non-current liability, but the company has neither classified surplus borrowing nor specified whether such borrowings have been guaranteed by the directors or others, the aggregate amount of such loans under each head, and the period and amount of default as on the balance sheet in repayment of borrowings, interest in respect of the accounts and such.
Yes.
Now, my lord, this reply, my lord, will find at, my lord, page 144. Is related to the balance sheet of 31st March 2020. Now, as far as the kindly similar 144. Now, as far as your contention regarding the disclosure required under Schedule 3, Division 2, concern following disclosure provided. Then, my lord, long-term borrowings, unsecured considered good, intercorp borrowing 11 crore. Further, it submitted no amount of the borrowing has been guaranteed by any of the directors or other persons. Sorry, my lord, 144.
Yes, yes.
Furthermore, the company has not made any default in the repayment of borrowings and interest payable thereon. Further, the company did not have any intent to hide anything or misrepresent the state of affairs against the public and stakeholder interest. This was only an inadvertent official part of the company's pure human error. Therefore, humbly submitted settlement will be viewed leniently and be dropped as as interest of no one will be prejudiced, including interest of public at large.
So this inquiry was held on
Mullah, this is
2023.
2020. It relates to Mullah 2021
2020, then the summon was 2023.
Yes, 2020.
And you have submitted the reply on the same June.
On 19 June.
19 June 2023. Then they have issued notice under section 206.
Yes.
And you have given the reply.
Yes.
Then what has happened?
And then, Mullah, 12, there are other, Mullah, I'll just come to that. Then from 148 is, Mullah, what we come up in challenge from. Same thing. Again, Mullah, they gave.
Made out an observation, conclusion after the considering report.
Again, Mullah, they say we have violated.
Yes, no reply with regard to the violation under the Provision of Companies Act, the inquiry report which have been reproduced here.
So without consideration of, Mullah, my reply.
Yes.
Because I have given a reply, Mullah, in 143. That has to be considered. Without that, Mullah, again, Mullah.
No, he has stated that. Kindly come to 148.
Yes, Mullah, 148.
148 is stated that paragraph, the inquiry office, paragraph 1, the inquiry of middle, the inquiry officer made out observation and conclusion after the considering reply, and no reply of the company with respect to the violation under the provisions of the Company Act in the inquiry report which has been reproduced. So you not give.
That is wrong. That is wrong on the face of it, because, Mullah, the answer, Mullah, in second is page 143.
Yes.
And it's the same, Mullah will find. It is observed from the financial statement as on 31st March 2020. Company has under long-term amounting to 11 crore 69. Same thing, Mullah, they have repeated again.
Yes. Unsecured considered. Yes.
Then, Mullah, that violation of 129(1). Then, Mullah, 150.
151.
150 and the same, Mullah, it's to directors now.
And this is for the company.
So balance sheet of 31st March 2020, 11 crore 69 shown as long-term borrowings, with saying it is considered good, no defaulter. And we have said that no director has anyway guaranteed it, therefore it is not shown there. So they come back with the same thing in again 2024 and Mullah pass the order. Now, in 139, Mullah, I've seen that first one I've shown, Mullah, A1. And then, Mullah, there is at 140, Mullah, we'll find B1.
(139), yes, A1.
It's all relating to, Mullah, that 31st March 2020 account, and also, Mullah, now page 140 is, Mullah, 31st March 2021.
140?
Page 140.
Yes.
Contravention of section 121(1) read with schedule 3.
Yes,
6. It is observed that from the financial statement of the company as of 31st March 2020, that the company has shown other payable amounting to rupees 1 crore 0169 under the head other current liabilities, but the company has failed to specify the nature of such payable in the notes to accounts as required by schedule 3, leading to violation of schedule 3 and such, which is punishment provision of section 129(7) of the Companies Act 2013. Then, Mullah, will find, Mullah, the reply given to this at page 140.
It will take time. Fixed matter hai kya?
Yes, Mullah, that backfall is there, Mullah.
क्या है? वही fixed matter है. वही तो पूछ रहा हूँ.
Mullah, that backfall is there, Mullah, that's true.
So it will take an exit.
Very good.
Counsel for the applicant has argued the matter at length, but due to paucity of time, hearing could not be concluded. Yes. On
There are 3 charges and nothing of any serious. So that
10.
Your Lordship, similar for item number 13.
yes, 12:30.
Yes,
Same,
12:30.
it's one for the company, one for the director.
Your Lordship, next date, Your Lordship.
10 next week.
Okay, I'm so grateful, Lordship.
Can it be the 17th?
Okay, 17. 17.
Okay.
17.
And only, I'm so sorry, just which was passed on this is till 10th September.
Interim order
Passed
is
in 2020.
interim order is extended till 17th September 2024 until further order, whichever is there. Yes.
17th. Grateful.
Two are the
Take steps. Item number? I don't think it will be taken today.
And connected matter to the Notoba Datta matter, another application of Ranjana Datta is also.
So may be taken up after completion. In the meantime, we'll take steps.
So let it be in record, then I will see. If it will, yes, call the matter.
Just one indulgence. Let's just one indulgence. In case that Avni matter, group of matters 14 to 49, the first matter is not taken up. The interim order was still today. That the interim order is extended.
Okay, if
and
it is not taken, I will.
Very well, someone will be there. They're grateful, so grateful.
Yes.
Oh, it's changed. Look, can I just change it?
This is best. Is changing it.
As for the
just for this matter.
Can do it.
Just for this matter.
And rightly so. I am
Suddenly, I found I'm on the
You're on the wrong side.
wrong side.
I
don't know if your lordship knows, my father, he would never address from that side.
Okay.
He would always be on this side.
Initially, when I started, I also picked that up. I used to go but no one is to give me importance. I used to push for the other side.
But in Andaman, that side is always for the government or the public prosecutor, whatever it is.
But I faced that once when I tried it. They said, why are you going that side? But I understand, Mr. Mukherjee won't finish today. So I'm just to have one matter. I'll just come back from that matter. If the next date, instead of 10th, if it could be the
17th.
Absolutely.
Fine. Let's check. One case I was to cite. Ma'am. I had on the last occasion concluded on the 1995 allotment.
Yes.
Now, I'm on the 2009 allotment of shares. Now, may I briefly indicate this is dealt with in paragraphs 9 and 10 of the impugned order. The allotment was made. This next allotment of 2009 reduced the shareholding of the petitioners. I'll just give a lordship seen the first allotment of 1995 takes it below 25% to 22. This allotment takes it below 10%. And there is a new majority created from 49%. the respondents become, my lord, 52% shareholders. So, my lord, now they have, my lord, a majority.
Correct.
My lord, rather, my lord, it's gone over 50, 72.79. So, my lord, it is
Majority has gone.
absolute, my lord, even special resolution, my lord, my lord, will not, my lord, deter, my lord, them from proceeding. So, my lord, if this is the position, my lord, this creation of a new majority and, my lord, my lord, reduction of shareholding, my lord, below, my lord, 10%, my lord, affects, my lord, a valuable right, my lord, of a shareholder. That is number one. Number two, my lord, our case was that, my lord, there was no need for this allotment. Why? My lord, because there was no need for funds. Second, my lord, case is this allotment has been made at a gross undervalue, my lord, because under the unlisted public company shares, my lord, a valuation has to be done. And, my lord, has to be supported by a certificate. The certificate which was produced shows, my lord, that though the meeting notice says valuation as on 31st March, my lord, 2008, my lord, the valuation is done, my lord, with a contingent liability taken into consideration of May 2010. My lord, it's gone, my lord, beyond. That's what I want to show your lordship.
I thought 90.
No, my lord, this is, my lord, some liability which came later. My lord, that has been, my lord, included for the purposes of valuation. Third, my lord, and this is, my lord, very important, my lord, there was, my lord, actually no notice received, my lord, by the petitioners, my lord, in respect of the extraordinary general meeting where this preferential allotment, my lord, was made. So there are two aspects here. One is, my lord, why, my lord, was there no rights issue that is offered to every shareholder? My lord, what was done was, because now, my lord, they could, my lord, go ahead and, my lord, have, my lord, a special resolution, my lord, passed. My lord, what they did was they had a preferential allotment, my lord, saying, my lord, that we will allot to whoever we want, rather than going through a rights issue. And to push that through, my lord, they did it, my lord, without notice to us.
Of his own.
Of, my lord, the extraordinary general meeting.
Okay.
So, my lord, we didn't know about it till we discovered it, my lord, in 2010. So, my lord, these were, my lord, the issues. Now, kindly have a look, my lord, at, my lord, the reasoning here. My lord, paragraph 9, my lord, page 21, my lord, of the impugned order, my lord. Kindly see. The petitioners have challenged the preferential allotment of what?
Yes.
What's wrong with you? Well, paragraph 9.
Yes.
The petitioners have challenged the preferential allotment of 4 lakh equity shares of rupees 10 each in consequence of an extraordinary general meeting dated 21st August 2009 for cash at a premium of rupees 5 per share. Petitioner number 3 was not a shareholder during that period, and therefore petitioner number 3 cannot complain of 2009 allotment. The aforesaid allotment was done in compliance with the provisions of section 81(1)(a) of the Companies Act 56. Keep the act out. The notice of EGM in relation to allotment of shares. Now kindly note this, my lord, this is very important, because to our case no notice has been given. My lord, this is, my lord, produced, they said it was under certificate of posting.
Okay.
The notice of EOGM in relation to the allotment of shares was stated to be sent to the petitioners under certificate of posting. The proof of dispatch of notice has been annexed at pages 103 and 104 of reply to CP. Now, my lord, a number of shareholders have confirmed receipt of such notices of EOGM dated 7th August 2009 as evident from pages 32 to 50 of reply to supplementary affidavit dated 8th November 2011. The petitioners have relied on the, that's my lord, us, have relied on the letter of the Postal Department dated 16 June 2011, wherein it has been intimated by Dharmatala Business Office of the Postal Department that no articles as per the enclosed chart were posted by the, kindly mark this, respondent company on 15 July 2009 under UCP. On the other hand, as per reply against information sought under RTI by respondent company, the Postal Department vide its letter dated 16 September 2011 has intimated that there is no record maintained in post offices in respect of under certificate of posting. Now, I'll show that to your lordship. My lord, this is a dispatch register, my lord, which they refer to. Not, my lord, the franking register which will show what has been received. Now, my lord, because of the reason, now this is, kindly have a look at this. Because of the reason that a number of shareholders confirmed the receipt of notices of EOGM dated 7th August 2009, and the postal authorities have indicated that no records are maintained in the post offices in respect of particulars regarding UCP, the presumption can be drawn that the notices in all probability have been received by the petitioners. Now, my lord, I pause here. My lord, there is no, my lord, statutory presumption, my lord, working here. My lord, because some say they have received. And who are they? They are their supporters who've come and said we've received. Now, my lord, kindly take the next sentence. The petitioners have contended that the allotment has been made in favor of the respondents in order to acquire control of the company against the interest of the petitioners, which action by itself is oppressive. Reliance has been placed on Lock and Blackwood and Ibrahimi Westbourne galleries. Now, Miller. On the other hand, respondents have contended that the allotments have been made following due process of law by holding extraordinary general meeting after giving notices to all shareholders through UCP, proof of which has already been placed in the documents. Even the consenting shareholders supporting the petitioners have not disputed on this aspect. With the evidence placed on record, it can be safely presumed that the notice was received by petitioner number 1, who chose not to attend, as has been his practice of not attending any general meeting since 1999. Now, I pause here. Now, my lord, if a business, my lord, in a meeting is directly going to affect me, there has to be an explanation, my lord, as to why, my lord, I did not attend. If in the past it's only approval of accounts.
No, even though notice, service of notice is required to be proof first.
Correct. And my lord, not just that, what is being held against me? In the past, you have not attended certain annual general meetings. Now, my lord, annual general meeting is, my lord, normal business. Now, my lord, here, the extraordinary general meeting is, instead of a rights issue, which I'm entitled to under the Act, my lord, it will be left to the board to decide who, my lord, they will bring in as shareholders. Now, my lord, kindly take now the next. Reliance has been placed by the respondents in the case of Konoklota Ghosh to submit that service deemed to have been effected as notice was shown to be properly addressed and posted. It has also been submitted that non-receipt of notice by any member in accordance with section 172(3) shall not invalidate the proceedings at the meeting. In this regard, Reliance has been placed in the case of Maharaja Exports and another so-and-so. On the other hand, my lord, kindly mark this. This is, my lord, the first case, my lord, which was decided under the 1956 Act by, my lord, our High Court, and it still holds the field. On the other hand, the petitioners have placed reliance on Ramashankar Prasad and other versus Sindri Iron Foundry to contend that UCP cannot be relied upon for the purpose of notice to attend general meeting. However, the case cited by the petitioners has been distinguished by submitting that the same pertains to a winding up scenario and it has dealt with family and partnership company, unlike the present case. I pause here. First, it's not a winding up. It is, my lord, a 397, 398. Second, it is not a family company case. It is, my lord, majority versus minority. Now, my lord, further in respect of Sindri Iron, the respondent sought to distinguish it by submitting that notices of 1995 allotment as also that of 2011 EOGM were issued through UCP and were duly received by petitioner number 1, and thus there is no plausible reason available to the petitioner to contend that notice was not received in. So if I've received it, my lord, in 1995, I must have received it in, my lord, 2009. Further emphasis has been placed by the respondents on the fact that majority of other shareholders have received such notices under UCP and had attended the meeting. Then, my lord, para 10. This is classic, my lord.
Just a minute.
I'm sorry.
Yes.
The aforesaid allotment of 2009 has also been impugned by the petitioners on the ground that allotment of shares to majority group themselves is oppressive by placing reliance on Shanti Prasad Jain. This judgment has sought to be distinguished by the respondents that in the said case, the petition was dismissed. My lord, greatest of respect, relief was granted. However, in the instant case, there is no lack of probity in allotting shares to the respondent group as the petitioners have not participated in the affairs of company and consolidation of shares by the majority will not be oppressive because it is to ensure that the company gets managed properly. So, my lord, I have a majority. So, I have a minority. So, today I say, minority, you are not attending general meetings, so I'll keep allotting shares to myself. My lord, this is unthinkable.
Not be oppressive because it is ensure the company.
And my lord, kindly see, my lord, what my lord, this jurisprudence is leading to. My lord, in a company, if somebody has a majority, he can disregard the minority.
Nothing
And say, you are not in management. I am doing good management. I am certifying myself. I am doing good management. I'll continue to increase my majority. Now, my lord, kindly look at it the other way. If somebody is in good management, my lord, and he offers, my lord, minority should also take advantage, buy more shares. My lord, because it's so good, he'll get dividends. Now, my lord, kindly have a look. Admittedly, the petitioner number 1 has not participated in meetings of the company since long, nor has he expressed any legitimate expectation in this regard. The respondents have placed on record the necessary documents to show as to how the allotment of shares was made in 2009 and the petitioners have not been able to dislodge the same. Under the circumstances, there is no merit in the submissions made by the petitioners and as a result, I am unable to interfere with the allotment in 2009. Now, my lord, 3 things your lordships would have noticed. My lord, we had raised the question of company was not in need of funds, not dealt with. Completely silent, and I'll show all that. Second, that it was at an undervalue. My lord, not dealt with. In fact, when I deal with, my lord, the 2011 allotment, your lordship will find that, my lord, figures I had mentioned regarding 2009 have been taken for 2011 to justify, my lord, 2011 allotment. They've completely ignored it for 2009. My lord, paragraph 14. Lordship makes a note. I'll come to that later.
Yes.
Now, my lord, kindly see first, my lord, the provisions of, my lord, of the Act. My lord, section 81. You have? My lord, this is the old Act. My lord, kindly have a look.
Yes.
Kalinga passage is marked. Have you marked the passage? Have you marked the passage? Yes. My lord, kindly see, my lord, where at any time after the expiry of 2 years, the formation of a company, or at any time after the expiry of 1 year from the allotment of shares in that company made for the first time after its formation, whichever is earlier, it is proposed to increase the subscribed capital of the company by allotment of further shares, then such further shares shall be offered to the persons who at the date of the offer are holders of the equity shares of the company in proportion as nearly as circumstances admit to the capital paid up on those shares at that date. So, my lord, 81(1), my lord, gives, my lord, a shareholder a right, my lord, to receive, my lord, offer in proportion to his shareholding. So, my lord, earlier I was 30%,
yes.
95. My lord, I received that offer. My lord, and I subscribed. And my lord, I was willing to subscribe even more. Kindly have a look, my lord. My lord, clause B, the offer aforesaid shall be made by notice specifying the number of shares offered and limiting a time not being less than 15 days from the date of offer within which the offer, if not accepted, will be deemed to have been declined. Unless the articles of the company otherwise provide, the offer aforesaid shall be deemed to include a right exercisable by the person concerned to renounce the shares offered to him or any of them in favor of any other person, and the notice referred to in clause B shall contain a statement of this right. So, my lord, I hold shares. My lord, I'll give your lordship an example. My lord, when my lord Indian Oil opened up, my lord, and my lord, they had their first issue. My lord, some shares were acquired by the public. Then, my lord, they had a rights issue. My lord, what they said was, this is what you are entitled to. You hold 3%. Our rights issue is 100%. So we are offering you 3% of, my lord, 100 shares. We are offering you 3 shares. And coupled with that, my lord, if you don't subscribe within 15, you can renounce.
Correct.
So, my lord, decided to renounce those 3 shares in favor of my child.
Correct.
That they also, my lord, get some shares now because of the renunciation. So this is what's provided. Then D, after the expiry of the time specified in the notice aforesaid, or on receipt of earlier intimation from the person to whom such notice is given, that he declines to accept the shares offered, the board of directors may dispose of them in such manner as they think most beneficial to the company. So, my lord, let us assume I didn't subscribe to those 3 shares. Indian Oil Board could then have said, I'm dealing with these shares by giving it to XYZ because it's beneficial to the company. I'll get more money.
Correct.
Now, my lord, 95 went by. This was not exercised, though I had, my lord, put in more money. Now, my lord, kindly have a look at 1A. If you do not want to, my lord, have a rights issue, what should you do? Notwithstanding anything contained in subsection 1, the further shares offered may be offered to any persons. Now, my lord, who are they? Whether or not those persons include the persons referred to in clause A of subsection 1 in any manner whatsoever. Kindly see A, if a special resolution to that effect is passed by the company in general meeting. My lord, I'm not concerned with B because B has not been, my lord, referred to here. Then, my lord, kindly come to, my lord, 3, etc., my lord, they don't, my lord, apply here. So what they did here in this particular case was to have an extraordinary general meeting.
Yes.
And, my lord, that extraordinary general meeting, my lord, was held, my lord, on, my lord, the shares allotment were in 21st August 2009. And, my lord, the extraordinary general meeting, my lord, was held on, my lord, 7th of August 2009. So, my lord, a special resolution is deemed to have been passed, my lord, on 7th of August 2009. Not deemed, my lord, said to have been passed on 7th August 2009. Now, my lord, our case is, we did not receive this notice, number 1. Number 2, my lord, that if we had received the notice, we would have attended and voted against.
Yes.
And, my lord, if I had voted against,
Then the majority.
it would not have been passed.
Correct.
Because those who voted in favor, my lord, were of such percentage that my 22% at the meeting would have exceeded 25%. My lord, yes, my lord, 56%, my lord.
Yes, 56%.
My lord, of shares voted at that meeting.
Correct.
If my lord, 22%, it would have blocked the special resolution. Now, my lord, this was our case. Now, kindly see. First is, I didn't get notice. First thing I want to show your lordship is, my lord, what did they show, my lord, to, my lord, content that notice has been served. My lord, kindly come to, my lord, volume 2, my lord, this is the reply affidavit, annexure R12 at page 364. Volume 2, page 364.
Yes.
Now, my lord, kindly note one thing. There is no stamp, my lord, on this document. First thing your lordship will find, my lord, there is no stamp. My lord, this is 364 and 365.
Yes.
Now, my lord, kindly come to 365 bottom. My lord, item 34.
Yes.
My lord, these are, my lord, shareholders, my lord, Rajiv Garg, who is petitioner number 1, Kusum Garg, petitioner 2, and Ritu Garg. Ritu Garg, my lord, is, my lord, the mother at that time.
Ritu is not before this.
No, my lord. And my lord, 33 also your lordship will find Rajiv and Ritu together.
Yes.
My lord, these were, and most important thing, kindly see the heading, dispatch of notice of EOGM to be held on 7th August. And there is a stamp, my lord, of the Dharmatala post office. Kindly have a look at that. My lord, the only stamp appearing there, Dharmatala business office. This is of the postal department. But there is no stamp, my lord, which has been put here. And the stamp date, kindly note, is 15 July 2009. Lordship has that, my lord?
Yes, yes, 15.
And now, my lord, kindly have a look at the notice. At page 360. My lord, I'm just showing your lordship what is important. My lord, registered and head office, 9 Knitter House. My lord, which is, my lord, the anglicized version of Mitro. My lord, 71 Ganesh Chandra Avenue.
Yeah, where from it?
My lord, 360.
Okay.
This is a notice which is supposed to.
Yes, yes.
Lordship
9.
has that.
Yes.
Dharmatala, some distance, my lord, from Ganesh Chandra Avenue. My lord, there are nearby post offices. But, my lord, kindly see, this is for a meeting of 7th August. The next 3 line notice,
Yes, 7th
on
line.
Friday, 7th August.
Yes.
Now, my lord, kindly see the date. My lord, left hand of page 361. My lord, Kolkata,
9th May.
26th May 2009. So, my lord, June went by. Middle of July, they decided to go and post it. Unbelievable. This is the date of the notice. It should have been issued.
Okay, May they have taken a decision for.
No. This is the notice date.
Acha, notice is okay.
Yes. This is the notice.
Okay, okay.
Notice itself is, my lord, 26 May.
Yes.
My lord, I'll come to the explanatory statement later. And, my lord, this notice is supposed to have been dispatched on, my lord, 15th of July.
Yes, as per this 15 July.
Yes, my lord. So, my lord, almost 2 months later, suddenly they say, now we need to dispatch it under certificate of posting. So, my lord, when they disclose this, my lord, my lord,
Yes.
made an inquiry with the postal authorities, and, my lord, we got, my lord, my lord, information. My lord, kindly first come to, my lord, page 565. My lord, which is volume 3. Volume 3, my lord, 565.
Yes.
This information came to us after filing of our rejoinder. So we obtained supplementary leave to file supplementary affidavit, and, my lord, produce this. I further say, pursuant to filing of the instant company petition, I, through my advocates, had caused inquiries to be made with the Superintendent of Post Offices, Central Kolkata Division, in respect of alleged dispatch notices relied on by respondent being annexure R12 to the reply. That's, my lord, that page 100 odd, my lord, which is referred to in para 9. In respect of the alleged dispatch notices, thereafter correspondence has been exchanged by and on behalf of the petitioner with relevant authorities. In this connection, copies of correspondence duly exchanged by and on behalf of the petitioners are annexed here to and marked. Now, my lord, kindly have a look at, my lord, the correspondence. My lord, it starts, my lord, at, my lord, my lord, 570. Kindly, my lord. This is, my lord, 12th of May, 2011.
Yes.
My lord, 570A, my lord, is more legible. Kindly come to 570A.
12th May 2000.
Yes. 12th May 2011.
Yes.
Dear sir, we are concerned for Mr. Rajiv Garg and others residing in so-and-so. Under instruction from our above named client, I request you to confirm whether a notice under certificate of posting addressed to the persons, including my clients as mentioned in the enclosed chart, has been dispatched from your office by Waxpole Industries on 15 July. If the same has not been dispatched, you are requested to issue a certificate to that effect and obliged. So we ask for dispatch. Now, my lord, we enclose that same document which I have shown your lordship. Now, kindly come to 573.
Yes.
My lord, this is 7th June 2011. My lord, legible copies at 573A.
Yes.
Madam, in acknowledging receipt of your letter, it is to intimate that case is under inquiry. Result will be communicated soon after completion of inquiry. Then, my lord, again, my lord, my lord, letter goes 15 June 2011. We had submitted a letter so-and-so. We have now been informed that they have sent you their reports dated June 6 and June 13. We have also received a letter from your office dated that case is under inquiry. A copy of your letter is enclosed. To expedite the matter as a. Then, my lord, kindly come to 575. And this is, my lord, very important. Subject. Kindly see the subject. Confirmation of posting of ordinary letters at Dharamtala Business Office. Madam, in response to your letter dated 12th May, it is to intimate that as per report of the Dharmatala Business Office, no such articles as mentioned in the enclosed chart of your above cited letter was posted by Waxpole on 15 July so-and-so under UCP.
Yes.
This is for your information as desired. So, my lord, they write back.
Yes.
Now, my lord, kindly have a look at, my lord, the document, my lord, which has been produced by them. My lord, this is, my lord, volume 3. Yes. Now, my lord, 607, my lord, is an application, my lord, which has been made. Kindly come to, my lord, 607A.
HRTA.
Yes. Subject application under, we request you to provide us the following information. Whether any register record are kept and are maintained or any other place there is, please mention if there's any relevant rule, law, etc. Now, my lord, kindly come to, my lord, page 604. My lord, this is their response. In acknowledging your RTI application, my lord, this is what they write. No register, record, document is or are kept maintained in the post offices in respect of letters dispatched under certificate of posting. No such copies exist regarding maintain of dispatch record of letters dispatched. And then, my lord, what is, my lord, the law? My lord, is mentioned here. Now, my lord, kindly, my lord, take 609 can. My lord, kindly come to, my lord, this is, my lord, very, very important, which has, my lord, been, my lord, missed out. No, I'm going to go to 27 July, 741. My lord, kindly take, my lord, 741. Lordship has that, my lord?
Yes.
Now kindly see. 27 July 2011. In response to your application dated 29 June, the required information as well as documents are supplied herewith. Item number 1, copies of entries made in the franking register of Dharmatala Business Office from 13 July to 16 July is enclosed. Item 2, copies of all documents pertaining to so-and-so are enclosed. If you are not satisfied, you may go on appeal. Now, my lord, what is, my lord, the document? Kindly have a look at page 742.
Yes.
My lord, copy of franking register. Kindly see the names of the entities. Wax Pole is missing. Adhunik is there. Greenply Industries is there. My lord, all these are there. So, my lord, it had clearly, my lord, not been produced. And my lord, the typed copies at 742A, my lord, 13th, 14th, 16th. 15th, my lord, is not even there.
Yes.
And they have got that, my lord, stamp on 15th. Now, my lord, with the greatest of respect, my lord, this shows, my lord, one is whether posted or not. So, my lord, nothing, my lord, in the register. But did it come for dispatch? They have a franking register.
So the finding is not correct.
Totally, my lord, it ignores this document.
Correct.
And says, my lord, the important thing is, my lord, UCP, my lord, there it has to be received, franked, and then, my lord, it is dispatched. Now, dispatch register is not there, but franking register is there. Now, franking register will show that on the 15th, nobody came.
Correct.
4 other companies are mentioned, but, my lord, this is, my lord, totally absent. Now, my lord, that being the case, the finding with the greatest of respect is perverse for 2 reasons. My lord, it does not, my lord, take into consideration material evidence, ignores it completely. And second, my lord, the evidence which it considers is of dispatch. But before dispatch, there has to be receipt. The receipt evidence is not considered at all. Now, my lord, UCPs, my lord, my lord, shareholder actions. Kindly see what our division bench has had to say. My lord, Sindri Iron, you please mark. My lord, this is All India Reporter, 1966, Calcutta, 512. Huh? Yeah. My lord, kindly take my lord, paragraph 49 and 50. Page 527 and 528. My lord, page number will probably not match, my lord. I'll give you a... My lord, page 25 of what I've handed up is para 49. Lordship has that, my lord? My lord, my original book, my lord, is in tatters. So, my lord, I got it, my lord.
Print.
Yes. Still more difficult it is to appreciate why the petitioner should fail to attend en bloc, both at the board meeting on January 22, 1963, March 4, 1963, and March 12, 1963, or the extraordinary general meeting on February 21, 1963. I find myself unable to believe that if notice of the board meeting on January so-and-so had been duly issued, they could have failed to reach all the petitioners in time, or that the latter, kindly mark this, would have all deliberately stayed away from the meeting. It is quite clear from the affidavits that towards the end of December 62, if not before, the parties had become openly hostile to each other, and it does not stand to reason that one group should absent itself en bloc from a board meeting so as to let the other carry the day as regards the affairs of the company. Now, my lord, I pause here. My lord, 1995, there's already been a skirmish. Settlement has not, my lord, worked out. My lord, petitioners group, my lord, is sidelined, my lord, in the management of the company. Now, my lord, when a further share allotment is happening, Forget, my lord, I'm not in the board now. When a further share allotment is happening, is it conceivable that I will stay away, my lord, from the extraordinary general meeting? My lord, now kindly read on, my lord. This was board and extraordinary general. More so, if there was any agenda for the meeting which is not disclosed, which would have shown what the respondents were after. The petitioners commanded a majority in the board and were not in a position to rout the respondents if any attempt was made to impair their supremacy. It is unimaginable that the petitioners would have allowed an extraordinary general meeting to be held in their absence when they, kindly note this, when the object of the meeting was to increase the number of directors from 5 to 7 and then, my lord, and to alter the Articles of Association so as to allow such increase to be effected. If notices of the extraordinary general meeting were suppressed, the resolution to increase authorized capital and to repay alleged loan of several creditors by issue of new shares in the company is, to say the least, a fraud of the worst character.
Yes.
The prior board meetings of the company do not show that any creditors were pressing for payment, or that there had been any discussion about payment of loans by the issue of shares, or that creditors had expressed their willingness to take such shares. No agenda of the extraordinary general meeting alleged to have been so and so has been disclosed, and I can see no reason why, if they had been served with notices of these meetings, the petitioners and their associates should again abstain from attending the same in a body. Kindly note this. Such conduct is tantamount to committing harakiri. It's inconceivable that, my lord, where, my lord, my rights issue is not happening, there's a preferential allotment which is left completely at the discretion of the board, that I will not attend, to protest, if not anything else. Then, my lord, kindly see, is it to be believed that the petitioners who held the majority, now in our case 22%, in a company would sit quietly and allow the respondents to effect alteration in the articles by increasing the number of directors, creation of new shares to suit their purpose so as to reduce the majority into a helpless minority, both on the board and at general meetings of the company? Now, my lord, here, below 10%, even worse. Because, my lord, if I don't have 10%, I can't file a 397. That's 399, my lord. The answer can only be in the negative. It was argued before us that the matter had not been thrashed out on evidence. No conclusion ought to be drawn as to whether petitioners had received notice of this extraordinary general meeting or not. It was further argued that as the Companies Act allows service of documents, kindly note this, by putting them in the post, production of certificate of posting was enough to prove service, and that the reason why a member or a group of members failed to attend the meeting was immaterial. If the matter was, now kindly see this, if the matter was tried on evidence other than affidavit evidence, no better result would have followed, for the petitioners would have deposed that they never received the notice, and the respondents would have averred that these have been put in the post, and the court would have to make up its mind as to whether petitioners had received notices but deliberately refrained from attending the meeting. In my opinion, such an argument is worthy of no consideration at all. Then, my lord, 50. If the case was such that it could be suggested that the petitioners, now kindly note this, because there is no motive being ascribed to the petitioners. If the case was such that it could be suggested that the petitioners had some motive in abstaining from attending the extraordinary general meeting, one might have hesitated to come to a definite conclusion that the petitioners had not been served with notice of the meeting. Now, my lord, a man may no doubt behave strangely on a particular occasion, but it is impossible to believe that a number of hard-boiled business people will keep themselves away from meetings where their doom may be effectually sealed in their absence and where they have only to attend and win their day by their superiority. I could have stopped, my lord, the resolution, because on that date, my lord, I had, my lord, 25% of those attending. The fact that no reference has been made in the petition either to the board meeting or extraordinary general meeting is only consistent with the conclusion that petitioners had no knowledge of them on March 14 when they moved. The happenings at the extraordinary general meeting could have been made capital of by the petitioners as regards their case of oppression. If it had been the case of a particular shareholder or director not receiving notice sent through post, one might possibly take the view that it had gone astray. But it is impossible to believe that all notices of board meetings, as also those of extraordinary general meeting, should have failed to reach all the addressees. Leaving aside the shares which were alleged to have been issued after the extraordinary general meeting, company had 16 shareholders, those in the respondents group being 4, while the number in petitioners group was 12. If any person in the petitioners camp had received the notice, he or she undoubtedly would have made it known to others. And although letters are known to lose their way in the post, I find myself unable to believe that the notices addressed to all these 12 persons in the had gone astray. In my opinion, the conclusion is irresistible that these notices had never been put in the post, although certificates of posting purport to have been obtained in respect thereof. Now kindly see the next. Judicial notice is being taken. It is only too well known that certificates of posting can be got hold of without actually putting letters in the post, and the respondents must have adopted that course as far as board meeting or the extraordinary. This is our division bench. My lord, now my lord, kindly note one thing. My lord, it was said, my lord, distinguished, saying that it's a winding up case. My lord, kindly have a look at para 1, my lord, of this judgment, my lord. My lord, page 514, my lord, of the report, but I don't know, my lord, paragraph 1.
Yes.
Page 4. This is an appeal from an order made by a learned judge of this court exercising jurisdiction under 397. As here. Wasn't winding up. Where did they dream of, my lord, winding up?
Oh, yes.
My lord, I'm just showing, my lord, the complete non-application of mine. In fact, my lord, if your lordships get the time, my lord, later, kindly have a look at the judgment of Justice Bijoy Mukherjee, my lord, which is the second judgment in this. My lord, I don't know which page that is. My lord, here it is in the report. It's 532. My lord. तो खोला ही नहीं पेज में.
Yes, 33.
33, my lord. Occasionally read the prints you are given also.
33. Page 33, paragraph 68.
Yes, my lord. Para 68.
I agree. Then appeal fails. Then
read it. My lord, this is one of the, my lord, finest, my lord,
judge.
My lord, judge and judgment, my lord. My lord, your lordship might know, my lord, Justice, my lord, G.K. Mitra, my lord, our Mr. Hirok Mitra's father, who ultimately went to the Supreme Court. My lord, Justice Bijoy Mukherjee, my lord, was somebody, my lord, who was most lucid. Now, my lord, which one? My lord, one document I had missed out. My lord, kindly have a look at, my lord, 747.
Why the appeal is not taken up so many years?
My lord, this is the problem, my lord. All 10F appeals. This is not the only one. There were 1 or 2 in between, my lord, which has. My lord, I am grateful, your lordships, here, my lord, that we are ultimately getting. My lord, it has happened like that. My lord, it's just tagged along with interlocutory proceedings in between, my lord. It takes, my lord, 397 earlier, my lord, when I joined the profession. My lord, company court, my lord, was the busiest court. My lord, it was best for juniors because there were small winding up petitions. My lord, scheme, my lord, first set of orders. And my lord, the heavy matters, these, my lord, 397s were taken up in the afternoons. The hearing matters. And they continue day to day. And in those days, in some 397, 398 matters, oral evidence was also taken on limited issues.
That's why, like this,
yes,
if required.
Yes.
And this all the evidence.
Yes, my lord. Not only that, there was, my lord, 155 rectification of register, where at times, my lord, trial on evidence was also held. My lord, it was My lord, kindly have a look, my lord, at page 747A, my lord, volume 3.
Yes.
And this is, my lord, very important. My lord, how the system works, my lord, of, my lord, under certificate of posting. Totally ignored. My lord, it's an annexure to the document I showed your lordship at page 741A. My lord, kindly see. With reference to your letter dated so-and-so, the undersigned is furnishing the following details about posting of ordinary letter. When a certificate comes to post ordinary letter with UCP, franking impression of postage as given on each article according to weight and class of article, and thereafter the same impression is also given on UCP list according to department at norms. The total number of articles of their postages and UCP charges are entered in the franking register. However, furnishing franking register of that proves reveals that no articles were forwarded on 15 and no postage is visible in the list. So no ordinary letters were received by this office from Waxpol on 15 July for posting. All this is ignored. My lord, apart from that, my lord, kindly see human conduct. My lord, how has, my lord, the entire law has been twisted. The persons who are benefiting and their friends come and say we have received. Therefore, petitioner must also have received. Now, my lord, there is no motive ascribed to the petitioner. None at all. Now, if that is the case, my lord, where there is going to be further dilution of shareholding, my lord, it's inconceivable that I'll be committing harakiri and not going. Now, my lord, it doesn't end there. Now, kindly see, my lord, out of the 18 shareholders of the company who had allegedly received notice of the extraordinary general meeting, 13 belong to the respondent group of their nominees. And my lord, out of the remaining 5 outside shareholders, no one attended the meeting. No one.
So how many persons have applied?
My lord, there were totally, my lord, 18 who said. Now, my lord, out of that, 13 belong to their group. My lord, the 5 who said they received didn't attend or attend by proxy. They didn't do either. It's unbelievable. And now, my lord, kindly see how they were manufacturing their own documents. My lord, kindly take page 611. Volume. My lord, volume 3, my lord.
Yes.
My lord, kindly see Waxpol's dark dispatch register.
Yes.
My lord, kindly see. My lord, there is a date of 15 July.
Yes.
Dispatch
Notice
of notice for extraordinary general meeting of members of the company
to be held on 7th August
to be held on 7th August
2009.
Yes.
Under
My
certificate
lord,
of
yes. Now, my lord, number of envelopes under certificate charges 36. And postal receipt documents are showing nothing has come. 36 rupees is all that it cost, my lord, to manufacture this fraud. I pay 36 rupees, shown payment of 36, and this is what happens. Now, my lord, I want to show why this was important.
Yes.
My lord, several companies, my lord, where there's public shareholding, as in this company, where, my lord, both groups just had together, my lord, both groups together, my lord, had, my lord, the majority, but not 100%, 32, 33, my lord, about 65 odd percent. The rest were public. Now, my lord, all members of the public do not, my lord, attend. Like, my lord, let us say an ITC or, my lord, Tata or Reliance, all don't attend. Now, my lord, those days there was no postal ballot either, no e-voting. So, my lord, physical presence had to be ensured. Now, it was difficult to force 100% shareholders to come. So, past conduct would have shown, my lord, roughly number of people who are attending. So, my lord, why was this step taken? To ensure, my lord, that we can never ever defeat, my lord, a special resolution. But at that meeting, they have disclosed the minutes, thankfully. My lord, page 366, volume 2. The number of shareholders. My lord, kindly see, my lord, who all attended. My lord, in person, your lordship has that. My lord, Praveer Garg, R.P. Gupta, A.P. Aaron, Suresh Bed, Shubhrangshu Ganguly, Gitika Garg, Shreya Garg. By proxy, Hem Garg, Rita Pasari. Through proxy holders, Akanksha and Shreya Garg. So, my lord, all the proxy holders are Gargs. My lord, and my lord, all those who are attending are either Garg or Bed or Gupta. Beds have been allotted shares. They are friends of my lord Garg. Outsiders have come into a family company. Now, my lord, proposed by Gupta, seconded by Aaron. Now, my lord, if these person shareholding, my lord, are taken into consideration, and this is not in dispute, only 56% of the total voting power, my lord, was present.
Yes.
My lord, of the company. So, my lord, we had 22% even after our dilution. Before that, we had over 30. If 22% had attended and had voted, my lord, the special resolution would be blocked.
Failed.
So, my lord, deliberate attempt, my lord, to keep us out. And, my lord, now, my lord, this is, my lord, an absolutely hopeless minority because of your lordship sees, my lord, the judgment, my lord, in, my lord, 1986, my lord, this is, my lord, Escorts, 1986, one Supreme Court cases, 264. हाँ ठीक है दिच्छे तो My lord, kindly take, just give copy to
Yes.
डांटना जोर जोर से अगर नहीं दिया. On an overall view of the several statutory provisions, my lord, 84, my lord, page 326.
Yes. Yes.
Lord, kindly see, my lord. The rights, my lord, about fourth line. Share is movable property. Your lordship has that.
Yes.
Share is movable property with all the attributes of such property. The rights of a shareholder are: one, to elect directors and thus to participate in the management through them, to vote on resolutions at meetings of the company, to enjoy the profits of the company in the shape of dividends. Now, kindly note 4. So, my lord, I have a right to vote.
Correct.
My lord, for that right to be exercised, I must at least have notice. My lord, here no notice. Now, my lord, kindly see 4. To apply to the court for relief in the case of oppression. To apply to the court for relief in the case of mismanagement. To apply to the court for winding up of the company. And to share in the surplus on winding up. So, my lord, if my shareholding is being diluted, my lord, 3 important things are happening. My lord, I lose my right to, my lord, complain of oppression. I lose my right to complain of mismanagement. I lose my right, it's diluted, to participate in the surplus. My lord, if a company goes into liquidation, its assets first have to be utilized to pay all creditors.
Yes.
My lord, the priority, my lord, is on the waterfall mechanism, secured creditor, workman, government dues, etc., then unsecured creditors. After that, whatever surplus, shareholders will take in proportion to their shareholding. So if I had 30%, my lord, I'd get more of that surplus. Then, my lord, I have less than 10%. Now, my lord, kindly see. Now, kindly have a look at, my lord, section 399. Why I say, my lord, this is important.
The old act or new act?
Old act, my lord, all old. Now it's 241, my lord. 399, 397 has gone from the statute book. Sadly. We've all been left without work, my lord. My lord, kindly see 399.
Yes.
This is the qualification. My lord, I have now been reduced to less than 10. Why? The following members of a company shall have the right to apply under section 397 or 398. My lord, A is applicable to us.
Yes.
In the case of a company having a share capital, not less than 100 members of the company, or not less than 1/10 of the total number of its members, whichever is less, or any member or members holding not less than 1/10 of the issued share capital of the company, provided that the applicant or applicants have paid all calls and other sums due. So, my lord, 10% shareholding, my lord, is required, or my lord, 1/10 of total number. So, to take away my qualification, my lord, to institute a proceedings which is a shareholder's right, 397 is oppression, 398 is mismanagement. Lordship will see that, my lord, in the marginal notes of the section 397.
Yes.
Application to court for relief in cases of oppression. Then, my lord, 398, application to court for relief in cases of mismanagement. Both are mentioned in para 84. This was an attempt, my lord, to do that.
Yes.
Now, my lord, given this is the position, now let us see, my lord, how, my lord, they have, my lord, allotted, my lord, to, my lord. Now, my lord, kindly take another decision. My lord, All India Reporter 65 Supreme Court 1535. My lord, this is, my lord, Kalinga decision. Huh? ना कौन पढ़ेगा?
Yes.
My lord, kindly, my lord, take. My lord, AIR 65 Supreme Court 1535. My lord, paragraph 19 onwards, my lord. No, I want to show that if you give to your own stooges and henchmen. My lord, kindly take. One. My lord, no. My lord, kindly take, my lord, paragraph 24, 25 and 26. It is, however, urged that the notice for the general meeting of so-and-so was not in accordance with section 173, and so the proceedings of the meeting must be held to be bad. This objection was, however, not taken in the petition, and we have therefore not permitted the appellant to raise it before us, as it is a mixed question of law and fact. We may add, though, the objection was not taken in the petition. It seems to have been urged before the appeal court. Justice Das has dealt with it, and we have agreed with him if we had permitted the question. The attack on validity must therefore fail. Then, my lord, kindly come to, my lord, paragraph 25, my lord, the sentence starting, my lord, after 10 or 15 lines, the matter would have been different.
Yes.
Matter would have been different if the 7 persons to whom shares were eventually allotted in July 58 were Benamdas or stooges of Patnaik or Loganathan group. For in that case, it may be said that these two groups forming the majority in the general meeting had acted fraudulently and unfairly by depriving the appellant of what he would have got under 81. My lord, I've shown your lordship, I would have got, my lord, proportional. Now, my lord, it is they, my lord, who, my lord, pass, my lord, this resolution. Now, my lord, kindly come to the next aspect of the matter, my lord. My lord, there are other cases on under certificate of posting. My lord, I'll give that in the note, my lord. It's for the same, my lord, proposition. Now, my lord, most important, kindly have a look at the notice, my lord, which was, my lord, issued. My lord, 362. My lord, these are special businesses. My lord, 360 it starts. My lord, volume, my lord, 2. 360, volume 2.
Yes.
My lord, kindly take my lord, 362. My lord, this is the explanatory statement. My lord, under section 173, my lord, if any special business is transacted, that is other than election, re-election of directors, appointment of auditors, and my lord, the accounts, if any other business, my lord, in law is special business, my lord, it's provided in the act. I'll come to that. Now, if it's a special business, my lord, there has to be an explanatory statement. Shareholders have a right to know why you are passing such a resolution. So, my lord, to justify, my lord, this, my lord, kindly come to item number 2.
Yes.
The company, in order to meet the fund requirement for its expansion and other working capital requirements, proposes to issue and allot. Kindly mark the next words. As and when necessary, equity shares on preferential basis to persons, body corporates, and other investors, whether they may be members of the company or not. Section 81 1A of Companies Act and the Unlisted Public Companies Preferential Allotment Rules so and so provide inter alia that further shares may be offered on preferential basis by an unlisted public company to any person in any manner if a special resolution to that effect is passed by the company in general. The particulars as required under the aforesaid rules as are under. Equity shares of rupees 10 each will be issued for cash at a premium of 5 rupees. Relevant date. Now, mark this, my lord, I'll come back to this. Relevant date taken for purpose of arriving at the price is the date of the last audited balance sheet of the company as at March 31, 2008. The object of issue of the shares, kindly note, is to meet the fund requirements for the expansion and other working capital. Now, my lord, kindly have a look at how the allotment is to be done. Allotment of shares is proposed to be made to promoters, directors, their relatives, corporate bodies under the control of promoters, directors on preferential basis. Details are as under. So it's all respondents and their friends. The names are given. Praveer Garg, Gitki Garg, Shrey Garg, Suresh Bed, Saroj Bed, PG Services. They are all relatives, corporate bodies under the control of promoters, directors on preferential basis. Admitted fact. I don't have to prove, my lord, that they are, my lord, friends or anything. Unlike in Kalinga, there was no evidence that the Patnaik and Loganathan groups, my lord, were, my lord, friends. So it wasn't, my lord, two, my lord, the same people.
Yes.
The promoters, directors intend to subscribe to the offer fully. Presently, 53.18% of the share capital is held by promoters, directors, relatives under their control. Their post-issue holding. So, my lord, I have been excluded from, my lord, promoters because it's only their shareholding which they mention.
Into consideration.
Yes. Their post-issue will be 79.61%. Accordingly, the shareholding of others before the offer is 46 and the same will be 20.31. So, my lord, even if, my lord, I tie up with all the public shareholders, I cannot defeat a special resolution. That was their intention. The proposed issue allotment of the shares will be completed within a period of 12 months No change in control is intended or expected to be. Special resolution is not to. Now, my lord, important. Said need for funds. Now, kindly make a note. Not one document from any bank or, my lord, any, my lord, find minutes to show, my lord, that fund requirement was there. Nothing. Number one.
Yes.
The records disclose, my lord, will show, my lord, that there was no fund requirement. My lord, just make the, my lord, just note this and I'll show the page numbers. My lord, for the financial year 2009-2010, my lord, the company had cash and bank balance of, my lord, 5 crores 23 lakhs 59,767. And, my lord, as on 31st March 2009, my lord, it had 3 crores 20 lakhs 52,152. So, my lord, this is, my lord, a cash bank balance which was available with the company. Then, my lord, apart from that, 2 crores, my lord, was in the current account of the company. And, my lord, most importantly, because it was in the current account, it was not even attracting interest.
Yes.
It had money to, park. 2 crores I park in a current account. I may have 3 crores, out of which 2 crores I park in a current account. And your lordship would be surprised to note how much was raised by this issue of shares. 60 lakhs. That was a need which is lying in the bank account.
Yes.
Then, my lord, kindly note another thing. My lord, after this issue and allotment, 21 lakhs 25,902 was paid out by way of dividend.
21 lakh?
25,902. My lord, was paid out by way of dividends. So, my lord, about 30% of the total funds brought in by the company went out. And the major beneficiary with about 80% shares after this allotment were the respondents. Dividend is paid to shareholders. They would have got 80% of this. Now, my lord, 50.8 lakhs was spent by the respondent in buying a BMW. It's important. 2 crores, my lord, lying in current account. What do? I had money to buy a BMW, so I routed through the company, saying it's required for its business. Now, my lord, in fact, my lord, the company has gained nothing out of this. My lord, only 17 lakhs, my lord, is, my lord, the addition to the gross block of plant and machinery. And that too, my lord, out of sums otherwise available. And, my lord, kindly note another thing. Balance sheet they have disclosed shows that, my lord, only 50% capacity utilization is happening to its plant. And they were going to expand. Unbelievable. The production capacity of the company, my lord, remains unutilized to the full. And they say we need funds.
Yes.
Now, my lord, this is, my lord, no need for funds. My lord, I can show the documents today, or I can cover another point and show documents, my lord, next time, whichever your lordship prefers. Because documents, my lord, will take longer. So I'll indicate, my lord, the other point. The other point, my lord, which has, so my lord, this aspect, kindly note, that company was not in need of funds, has not been discussed at all. I'll show it from the notes of submissions we filed. We'll show it from the arguments we advanced. It's recorded in the order, but in the findings, it's absent. Now, my lord, the next. Your lordship has seen the shares were of a face value of rupees 10. Premium was of rupees 5. So 15 rupees per share. Now, my lord, under the unlisted companies issue and allotment of share rules, there has to be, my lord, a valuation. Now, the valuation has to justify the price being charged. My lord, I will show to your lordship, my lord, number one, the valuation itself is wrong. My lord, why is it wrong? On the face of it. My lord, valuation is not an exact science. My lord, it's in the domain of experts. Courts have said, my lord, that it's possible for two valuers, my lord, to have totally different. But if the valuation report does not, my lord, is perverse, my lord, like, my lord, a valuation of 31st March 2008, my lord, valuation, let us say 5 crores. But what I do, I take a contingent liability of May 2010 to lower that value. That is perverse because valuation date is, as per the notice, 31st March 2008. That is absolutely perverse.
Yes.
Now, my lord, here, my lord, 31st March 2008, valuation taken, my lord, contingent liability as of 20th May 2009, my lord, has been, my lord, taken into consideration. Then, my lord, this contingent liability, your lordships will kindly note, my lord, was, my lord, 7.59 crores. 7.59 crores shown on 10th May 2009. My lord, this one document I must show your lordship because it's classic, my lord, as to what has happened. My lord, kindly see, my lord, page 371, my lord, volume, my lord, 2.
Yes.
This is what, my lord, Guho Roy and Associates, to whom it may concern. We have verified the, and my lord, this is the certificate which has to be given.
Yes.
Now, my lord, we have verified the books of account along with other relevant documents and records, so and so, for the year ended 31st March 2008. Based on the annual report and audited accounts for the said year. Now, kindly see, here there is something being added. And the information given to us relating to contingent liabilities of the company, kindly see the date, as on 20th May 2009, and other information as is true and correct to the best of our knowledge and belief. We certify that the intrinsic value of each equity share of HON'BLE is 5.46, detailed calculation. Now kindly have a look at the detailed calculation. My lord, page 372. Valuation of shares. Now, my lord, what is the method? Net asset value method based on audited accounts of so-and-so, 2007, 2008. Lordship recalls, my lord, the notice, 31st March 2008. Now, kindly come to contingent liabilities of 20th May 2009. Kindly see, my lord, last 4 lines, less contingent liabilities, 7 crores so-and-so. So, my lord, it comes to 1 crore 17 lakhs 67,823. Less capital reserve, funds belonging to equity, number of equity shares 5.46. So, my lord, according to them, it is below par. And we have done the company a favor by allotting it at 15. My lord, unthinkable.
Yes.
Now, my lord, kindly have a look. My lord, at page 794, volume 3. (793) and 794. What is this document? Is it disclosed by us or them? My lord, kindly take 793, my lord. Lordship sees, my lord, My lord, we prepared this chart to show, my lord, the peculiarity of the case. Lordship sees, my lord, 31st March 2002 to 31st March 2011.
Yes.
Because, my lord, the allotments that are challenged, my lord, are, my lord, of 2009, 2011. Now, my lord, the chart, my lord, it shows contingent liabilities. My lord, they are remaining constant, your lordships will find, from 2005. Now, my lord, suddenly, on 31st March 2009,
204.
yes, my lord, it goes up. Now, kindly have a look at the chart, my lord, how it happens. Next page, 3. And it's, my lord, the TARs, my lord, the, my lord, good overs. The good overs are, my lord, when they want to increase, my lord, their shareholding and keep us out.
It is a hit 6.
Yes, that's what I'm saying, my lord. Maybe 36 runs per over. My lord, that is, my lord, the, my lord, TARs. Now, my lord, kindly come to
Yes.
my lord, the next, my lord. Now, my lord, why do we have an objection to, my lord, 20th May 2009, my lord, being considered? First, the explanatory statement says that the valuation is to be done as on 31st March 2008. That's volume 2, page 362. Then, my lord, this contingent liability on that date, my lord, was not audited. Because, my lord, it's of May 2009. Allotment, my lord, is in, when was the meeting? My lord, 7th August 2009. My lord, audit would have happened after 31st March 2010. Because it's the financial year, 1st April 2009 to 31st March 2010.
Correct.
So it's an unaudited figure, which has, my lord, been accepted. Then, my lord,
yes,
in 2011, when, my lord, valuation as on 31st March 2000, I'll come to that, 31st March 2010 was to be the value for the allotment of 2011. My lord, there they did not say for a later period contingent liability. It was done for this meeting alone. Then, my lord, what is important, my lord, is, my lord, at page 372, and this is one, my lord, the last document I'll show your lordship today. My lord, the value of debtors, net of doubtful, my lord, is shown as 2 crores 88 lakhs 2,935. And, my lord, this is, my lord, the document at page 372, my lord, has to be compared with page 555. Kindly have a look, my lord. Page 555 shows, my lord,
yes,
my lord, the debtors value, my lord, kindly see. Sundry debtors, yes, my lord, is 3 crores.
58.
Yes, 3 crores, my lord, 58. Now, my lord, kindly have a look at, my lord, kindly have a look at, my lord. Now, 372.
288.
Yes, your lordship will see 288.
288.
They are ignoring the audited balance sheet as on 31st March 2008. Though, my lord, the heading says at 372 based on audited accounts of 2007, 2008. Clearly, my lord. Now, my lord, kindly have a look at, my lord, kindly have a look at investments at page 372. My lord, it is shown as 0.
Nil.
Now, my lord, kindly take 555. My lord, it's shown as, my lord, 25 lakhs.
25.
My lord, 1 minute. My lord, kindly see, my lord, just E, my lord, at, my lord, page 555
Yes.
against, my lord, the schedules your lordship will find.
Yes,
My lord,
25.
ABCD, E, it's 25 lakhs.
25 lakhs.
And my lord, one other thing. My lord, kindly have a look at loans and advances. My lord, is 372. It's 165.
1 crore.
And my lord, here, my lord, in the audited accounts, it's 166.
Yes, 166.
My lord, against, my lord, schedule, my lord, I, against schedule I.
Yes, 166.
So, my lord, no, stop here. And now, my lord, kindly have a look at term deposits with banks. My lord, kindly see non-trade investment term deposits with banks. It's an asset, but they've deducted it here as a liability, 372.
Yes.
Non-trade term deposits with banks. So what I have parked with banks as fixed deposit, my lord, is not my asset. They've deducted it, 372.
Yes, got it.
Treated it as a liability. My lord, I'm showing, my lord, on the face of it. My lord, first, though they say the valuation is on the basis of annual accounts, it's contrary to the annual audited accounts. Second, they take in figures which are not audited for the purposes of depressing the value. And, my lord, to further depress the value, assets, my lord, they deduct, my lord, from, my lord, yes. My lord, this is on the face of it. I'll cite, my lord, a case on valuation. My lord, may I stop here, my lord? I think past 4:30. My lord, some of us, I know your lord. My lord, I'll just change this around. My lord, I believe Mr. Banerjee wanted it on the 17th.
17, yes. 17 कोई fixed matter तो नहीं है ना? 17 कोई fixed नहीं रखा. Had the London Council for the appellant has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 17th September at 2 p.m.
17th at 2.
17th at 2.
My lord, may we permit to mention the Passover matter, which was lordship. My lord, if your lordship kindly fix any time, my lord. If your
But
lordship
he's here. My lord, whose connection went off. I've told him to stick to the High Court.
Item number 5.
Yes.
Your lordship kindly fix the time.
Which matter?
My lord, the Passover matter.
When I was addressing your lordship, my
Acha, that tender?
Yes.
That
tender, but not the tender, but that company sale auction.
company auction.
Yes. We can come back next Wednesday.
Your lordship kindly fix any time, my lord.
2 o'clock.
Yeah, काम करो.
Because your lordship takes company matters on Wednesdays from 2 o'clock.
No, those fix.
Item number 8.
5 and 6.
5 and 6. Learned counsel for the parties have argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 10 at 2 p.m.
Great.
Mention an application which has been filed for correction of the typographical errors which are cropped up in the judgment. The short application, the master summons will returnable today on any day convenient to my lord may be this.
To Wednesday को ना to be mentioned में रख दो नीचे लिख हाँ ये regular bench the company going on my regular bench staffs are not there tomorrow morning you mention I will see to that.
There are some hourly matters which are not appearing in the list.